last occasion to pay 2,40,000, the rest amount. I have taken instruction and he is ready, has already made a demand draft to that extent.
Fantastic.
The only thing is that Lordship will kindly see my CO application,
Yes.
page 19 and 91, where my lord, they have a mutual divorce. Page 19, they have agreed to withdraw all the criminal cases and the maintenance case. Paragraph 14, 15, and 16 of the mutual divorce application. Page 19 of the CO application. One nine.
The matter arises out of the dismissal of an application under Section 28 of the Special Marriage Act 1954, filed jointly by the parties for divorce by mutual consent. Which of next para? The complaint of the appellant husband was that revisionist petitioner stroke husband was that despite having taken the first installment of the amount of permanent alimony which was to be paid to the respondent wife in terms of the said application, the latter chose to abstain from the final hearing of the application for mutual divorce by mutual consent, leading to the dismissal of the same. Next para. The matter was heard on several occasions. Lastly, by the order dated July 15, 2026, we recorded that the respondent was agreeable to pursue the said application for divorce, subject to the appellant husband paying the entire balance amount of rupees 2,40,000, being the total balance of rupees 7,50,000 minus rupees 5,10,000, which has already been paid in the meantime pursuant to the order of this court. For next para, a dispute arose as to whether the appellant, whether the amounts paid by the appellant husband pursuant to the direction of the criminal code under section 125 of the Code of Criminal Procedure was to be adjusted from the balance, to which the respondent did not agree. Next para. Accordingly, we had granted time to the learned advocates for the appellant to take instructions in that regard. Next para. Today, at the time of call, the learned advocate appearing for the petitioner submits that his client is agreeable to pay the entire amount, remaining amount of rupees 2,40,000, and a bank draft has been prepared to that effect. Next para. In such view of the matter, there cannot be any further impediment to the application for divorce by mutual consent being proceeded with. Mr. Patra, you are there?
Yes, yes, Lordship.
We are directing the learned trial judge to take up that. We are setting aside the order, take up the application, and they'll put in the bank draft and on the date of the order, and that order will be passed.
Lordship.
Next para. In such view of the matter, in such view of the matter. Accordingly, CO 1434 of 2026 is disposed of by setting aside the impugned order dated February 25, 2025, passed by the learned district judge, Purulia, in matrimonial suit number 105 of 2024. The learned district judge shall now take up the application filed by the parties under section 28 of the Special Marriage Act and, subject to payment of the balance amount, payment of the bank draft of balance amount of rupees 2,40,000 by the appellant, by the revisionist petitioner stroke husband to the opposite party stroke wife, a decree of divorce by mutual consent shall be passed by the learned district judge. It is expected that such exercise shall be concluded within 1 month from the date of communication of this order to the learned district judge. Next para. For such purpose, the parties will be entitled to file a put-up petition bringing to the notice of the learned district judge the order of this court. Full stop. The learned district judge as well as the parties shall act on the server copy of this order without waiting for production of a certified copy for the purpose of compliance. Full stop. No orders to cause.
Lordship will kindly record that.
Lordship,
All the criminal cases that is in the
Lordship,
যেখানে বললাম যে directed to pass a divorce by mutual consent in terms of the clauses of the application under section 28 of the special marriage.
The other thing is, my lord, they have filed a suit for divorce.
If it's there in the clauses, every clause will be subject to
That
the
is they have filed after the decree, after the.
No, Mr. Pal, we have directed the divorce to be granted in terms of the clause of the section 20. If it's there, it's there. Yes, yes, Mr. Pal.
Lordship, I have a little submission. If your Lordship be able to allow this opposite party to insert the clause of return her stridhon.
No, Mr. Patro, but there is no difficulty in doing that later. But you have to first, a degree has to be granted, and these terms of this section 20 have to be completed. It's not there, it's not there.
Shall I hand over this bankrupt just here and there?
No, there. Subject to payment. We have directed that within a month to be decided after communication. You just give the server copy, and both of you file a put-up petition, or you file a put-up petition. Within 1 month, that will not lapse.
I'm grateful.
Thank you, Mr. Patro. Thank you for the cooperation also.
Lordship.
Good sense of counsel help the clients.
Lordship.
Thank you. Next.
Grateful to you.
Number 3.
Within time, Mr. Arifin?
My lord, affidavit service filed, my lord.
Within time?
No, my lord, there is a delay, my lord.
What is the delay?
There are, my lord, 3 applications, actually 4 applications, my lord. First is, my lord, for setting aside dismissal order, my lord, and there is a delay in asking for that one, so there is a section 5 application. Thereafter, my lord, there is another application, my lord, for substitution, setting aside appointment after condonation of delay. And thereafter, my lord, there is an application, my lord, for repair, my lord. What happened, my lord, if your lordship kindly first
Which is
check
which?
out,
Can
Can
4
fi-
is restoration?
can 5, my lord, can 6 is restoration, my lord.
No, can 4. You have written down wrongly.
Can
Your application
5
can...
is restoration. Can 5 is restoration.
No, can 4 is restoration, we can see from our copy. Can 6 is substitution. Which is the condonation for restoration?
Then my lord,
We don't find any application for condonation of the substitution.
Can-
There is only one condonation application.
but in substitution, my lord, itself, my lord, I paid for condonation, my lord.
Achha.
That's why, my lord. My lord, that would be one application only. My lord. That's why.
Substitution, what is the delay?
Substitution, my lord,
Affidavit of service you have filed?
every service are filed, my lord. Previously,
For the
they were
affidavit of
appearing,
service,
my lord.
আছে এখানে?
Previously, they were appearing, my lord. I tried to serve the advocate, my lord. They had not received. But they said that they have no.
No, the other side has been served
Staff,
directly.
my lord, and it has been refused, my lord. But if your lordship
Very
please, my lord, there is a specific amendment that refuse has been made, my lord. over there.
What has been?
But refused, my lord.
Refused, you have seen, yes. No, there is only how many?
My lord,
No, the other has been delivered.
One respondent, my lord, and others are pro forma, my lord. And if your lordship sees, my lord, the admission, my lord, order, my lord, it's saying, my lord, my application, my lord, for restoration, my lord. My lord, the initial order which was passed by the Honorable Justice Subramanian Mukherjee, my lord.
You have written here Shubhendu, Justice Shubhendu Samanto.
Hmm?
In your application, it's written Justice Shubhendu Samanto.
My lord, that initial application for but para 13, my lord, kindly see, my lord, in page 7, the application on 1 meter. It would be, my lord, on page para 6, my lord, the application stated that the
Which paragraph? You are saying 13(6).
no, sorry.
Which para should you look into?
But first, my lord, kindly see para 6, my lord, at page 5.
Yes.
But can see this applicant stated that the application was formally admitted by an order dated 28/1/2011, passed by His Lordship Honorable Justice Subramanian Mukherjee and Honorable Justice M.D. Abdul Ghani. Under order for
Yes, that we know, but why was it dismissed for default? You were
but
not there.
my lord, the next page, my lord, it was dismissed by your lordship, my lord. Kindly
Lozima for final orders, you did not
yes,
put in
my
the
lord,
requisite.
put the requisite, my lord, for service of appeal.
Yes, so you have to deposit the requisites then.
My lord, I shall, my lord, if your lordship extend that time, my lord, I shall do it, my lord.
What is the reason for the delay in preparing this?
But the younger son of the appellant, my lord, who used to look into this case, my lord, he fall very sick, my lord, and he ultimately, my lord,
On the affidavit of service, it transpires that despite due service, none appears for the for the principal respondent to contest the applications. Full stop. Accordingly, the applications are taken up for hearing ex parte. Full stop. Next para. From in the condonation application, it has been stated that the younger son of the appellant, defendant stroke appellant, who was looking after the matter, fell seriously ill, due to which the restoration application could not be filed in time. Full stop. Next para. From the averments in the application, we are satisfied that sufficient cause for the delay has been made out. Stop. Accordingly, Can 5 of 2025 is allowed, thereby condoning the delay in filing Can 4 of 2025. Full stop. Next para. In view of the reason for the absence of the appellant having sufficiently been explained, Can 4 of 2025 is allowed, thereby recalling the order dated January 8, 2025, passed in SA number 20 of 2011, thereby restoring the second appeal to its original file and number, subject, however, to the requisites for effecting service of notice of appeal on the respondent numbers 2 to 4 being deposited within a week from date. Full stop. In the event such deposit is not made by the appellant, this order shall stand automatically recalled, and the and Can 4 of 2025 shall stand dismissed without further reference to the court. Full stop. Next para. Can 6 of 2025 is an application for substitution of the heirs and legal representatives of the who has died?
My lord, main appellant has died, my lord. Thereafter, my lord, respondent number 2, 3, and 4, my lord. But when respondent is still alive.
So your reason for the delay is same.
But same.
Can 6 of 2025 is an application for substitution of the heirs and legal representatives of the appellant, of the sole appellant, and respondent numbers 3 and 4.
My lord, respondent number 2, 3, and 4. But that is pro forma respondent. They are pro forma respondent. Pro forma respondent 2.
All have died. 2, 3, and 4.
All.
And pro forma respondents 2, 3, and 4. Next para. Since the reason for the delay in preferring the application is the same as that for the delayed filing of the restoration application, which we have already condoned, we find sufficient merit in the application. Accordingly, Can 6 of 2025 is allowed, thereby directing substitution of the heirs and legal representatives of the petitioner, of the appellant, and the pro forma respondent numbers 2, 3, and 4, as mentioned in Can 6 of 2025, upon condonation, upon setting aside abatement on condonation of delay in filing the application. Full stop. Can 6 of 2025 allowed, bolam na? Full stop. There shall be no orders to costs. The office shall carry out the necessary rectification in the memorandum of appeal accordingly. Thank you. Next.
Last, my lord, applications for repair, my lord.
Repair file before the learned single judge. Go before the learned single judge. Once it's admitted, we are not in season. Because this was dismissed for default by division bench, that's why you. Yes. Next. What is the application for?
The application for restoration of an order dated 17th January 2020.
This is Can 1.
It is Can 2.
Can 2.
It has been passed by His Lordship Shambhuddha Chakraborty and Justice Hiranmay Bhattacharya. These are for dismiss for default for reasons
Yes.
that the advocate on record has not been able to turn up before the court because he is actually attending his father for his illness and treatment in the year.
This has been filed within time.
No, there is a delay of 970 days.
970 days.
Yes, because of the reason the order has been passed on 17th January 2020 with a limitation of 30 days. So it should have been filed in 15th March of 2020. But because of the outbreak of the COVID-19, there has been a delay, and the restoration has been filed on 20th February 2022.
Yes, the COVID delay applies.
My lord, kindly come to paragraph 3.
of can 3 or
of
which
section
one?
5 application
Yes,
as
section
well
5.
as the can
Very well. Can 3 of that?
section 5.
Yes. This was a 17.1.
That the advocate's on record father was ill. Now, my lord, kindly come to
That is
page.
not paragraph 3 of the condemnation application.
Due to his father's treatment, he was busy. Section 5, my lord.
Section 5, paragraph 3 is something else. The application was sorry, my fault. Yes.
My lord.
Yes, so what?
Now, my lord, kindly come to page 11, my lord.
Page 11.
The statement is quite contradictory, my lord.
Certified that certain such.
Aniruddha Singora is the advocate on record. Now, he was treated for gastroenteritis. Now, it is stated that his father was ill.
Yes. What about this? You are not Mr. Aniruddha Singora.
No, I'm not.
So the prescription says Aniruddha Singora, the advocate himself was ill. You have said father.
That too, my lord, for a few
That's
days.
so
My lord.
careless.
Then, my lord, in paragraph 7,
Yes.
they have stated that the limitation period start from 1st of March at page 7, my lord, first paragraph. But the order was passed on
Should start
16th of
from
January 2020.
16th of February itself.
16th of January. So it limitation
I
start from
supplemented affidavit, sir. There are two discrepancies pointed out by learned counsel for the respondents. For the first comma, in the condonation application comma, it has been stated that the matter could not be attended since the father of the learned advocate on record for the appellant was busy for the treatment of his father, comma, whereas the annexed medical document shows that the learned advocate himself and not his father was under medical treatment during the relevant period. Full stop. Also, comma, the limitation period for filing the restoration application has been treated to commence from March 1, 2020, whereas from the concerned date of dismissal of the appeal, comma, that is January 17, 2020, comma, it is evident that limitation for filing the restoration application expired on February 16, 2020. First of the explanation in the interregnum has not been furnished in the application. Full stop. Next para, on the prayer of learned counsel for the appellant, comma, leave is granted to the appellant to file a supplementary affidavit to can 3 of 2022 and, comma, if necessary, can 2 of 2022 within a week from date with an advance copy to the learned advocate.
one more, my lord, thing. My lord, paragraph 8. They have stated that for 2 months, they have stated that delay was due to pecuniary difficulties. Thereafter, there is no explanation.
We'll take that into consideration, the COVID period. For the respondent, full stop. Next para, the matter shall next be listed in the monthly list of August 2026.
May I use opposition?
What if? How do you
Mashallah.
have personal knowledge of his father's illness or his? It's entirely
Filing
different.
the affidavit service.
What is this? Service?
Affidavit.
Affidavit of service filed to be kept on. You yourself draft, be careful. Yes, next.
Mashallah. My lord, I pick to
Dipta Meghnath. Yes, what is this?
Can 4 is, my lord, restoration application, and in the restoration application there was some mistake, my lord, and
Restoration application after setting aside abatement.
yes, my lord. My lord,
Substitution, the main prayer you have not made.
my lord, substitution was made, my lord. My lord, only one thing, my lord. First of all, my lord, the supplementary affidavit, my lord, in the 13th paragraph, my lord.
Have you served copy of this?
Yes, my lord. Affidavit of service, I believe.
Yes, there is an affidavit, sir. They have received.
Received, my lord. I believe,
Delivered, yes.
my lord, in the paragraph number 13 of the restoration application, my lord, in place of second appeal, it has been mentioned wrongly as contempt application, my lord. That's why the submission.
So that's why. Well, that we understand, but
Yes, my lord.
why setting aside abatement without a prayer for substitution?
My lord, at first, my lord,
Now take the microphone closer to you. Yes.
right, order dated 12th of February 2020, my lord, it was dismissed for default, my lord.
Hmm.
After that, My lord, no indication was there in the official website, my lord, and it went out of notice of the advocate on record and his
Why
client.
are you not present on that date?
My lord, after that,
No, on that date, why were you not present? Because it was not on the, must have been in the list.
after that, my lord, in 2024, it suddenly appeared in the list, my lord, without filing of substitution application, my lord.
First, you have to explain why you were not present on the date when it was called on. Then, regarding the delay, you can say it was not in your notice. And
Yes, my lord.
so, on that date, it must have been on the website. What is the reason for that? Not present? What have you stated here?
On that day, my lord, I missed the list, my lord.
Let us see that.
My lord. My lord,
Miss the list. Yes,
if
very
the
well.
matter,
Very well. Fair enough.
my lord.
So, then when
No.
the matter came up in the what list?
Suddenly, before the Honorable Division Bench, presided by Honorable Justice Harish Tandon and Honorable Justice Madhuresh Prasad, my lord, on 9th of May 2024 as item number 66, my lord. Then, my lord, after taking instruction,
Even after dismissal, it wrongly appeared.
my lord, and no indication was there also in the website, so we were also ignorant of that, my lord, regarding the dismissal. My lord, as the sole appellant died, my lord, so one accommodation was
So,
paid for
substitution and section 5 was allowed.
Yes, my lord. Subsequently, that was allowed by order dated 23rd of February 2026, my lord. After that, my lord, when we tried the matter to enlist under the heading Order 41, my lord, then we came to know that the matter has been.
We can understand that, but why this substitution, setting aside abatement on condonation of delay for what? Restoration does not require a setting aside abatement or condonation of delay.
Wrongly drafted.
At that point of time, the substitution and section 5 were allowed.
Yes, my lord. That's a strange situation.
But then that order is also nullity.
Yes, my lord. Have to do everything again, my lord.
Where is Justice Tandon's order? You should have annexed here also.
Yes, my lord. That's my.
Where is that? It's in your pocket. What are you doing?
My lord, that's not annexed here, my lord.
So we have to look into that order. What is the date of that order?
Yes, my lord. That order dated 23rd of February 2026, my lord, where substitution along with section 5 was allowed.
Very well. Despite service, none appears for the respondents. Full of next para. The supplementary affidavit filed by the petitioner today be kept on record. Full of next para. From the amendments made in the application for restoration and from the submissions of learned counsel appearing for the appellants, we find that when the matter was listed on February 12, 2020, the same the learned advocate missed the matter in the list, due to which it remained unattended and was dismissed for default. Which of next para thereafter, although the appeal had already been dismissed for default previously, an application for substitution. The matter appeared on May 9, 2024 before a coordinate bench when the appellants, unknowingly, prayed for an accommodation to file a substitution application upon the death of the sole appellant. So next para, thereafter, the matter was taken up, the application for substitution as well as a connected condonation application were taken up by the said division bench, and on February 23, 2026, the substitution was allowed on condonation of the delay in filing the said application. Prior thereto, on December 11, 2025 and on February 9, 2026 also, the matter was taken up by the coordinate bench, but it escaped the notice of all that the appeal had already been dismissed for default previously. Thus, although erroneously the substitution application was allowed on condonation of delay, the appeal had already been dismissed for default, which was only detected by the learned advocate for the appellants subsequently when trying to enlist the appeal. Next para, from a perusal of the amendments made in the present application, we find sufficient cause for the delay in preferring the restoration application as well as the absence of the petitioner appellants on the relevant date. Next para, accordingly, Can 4 of 2026 is allowed, by reading by condoning the delay in filing the same and recalling the order dated February 12, 2020, passed in SAT 313 of 2018, which of the said appeal is hereby restored to its original filer number. Which of next para, since the order dated February 23, 2026 is rendered a nullity in view of the appeal having already been dismissed for default previously and not existing in the eye of law on the said date, comma, we recall the said order, full stop, however, comma, since the coordinate bench had, comma, upon full consideration of the averments in the applications, comma, was pleased to allow the applications for substitution and condonation of delay, comma, we hereby for the sake of judicial propriety, comma, we pass a similar order by adopting the content of the order dated February 23, 2026 and allow Can 2 of 2024 as well as Can 3 of 2025, comma, directing substitution of the heirs and legal representatives of the appellant as mentioned in paragraph number 2 of the said application bearing Can 2 of 2024 upon setting aside abatement on condonation of delay in filing the said application. No address to cost. Thank you. তাই করে দিলাম বুঝলে রেখে তো একটা জিনিস তো দিয়ে অ্যালাউ করে দিয়েছি নালিটি বলে জাস্ট ইয়েস নেক্সট এটা আগে ডিসমিস হয়ে গেছিল The appeal was dismissed for default by order dated January 4, 2024, and the present applications have been filed respectively for restoration of the appeal and for condonation of the delay in filing the restoration application. Full stop. However, comma, it appears that the appellant is not interested in pursuing the matter and is a habitual defaulter, comma, since even today none appears to move the applications. Full stop. However, comma, for the sake of the litigant, comma, the matter is adjourned as a last chance to the appellant to move the applications. Full stop. It is made clear that in the event the applications are not moved on the next occasion when they are called on for hearing, comma, appropriate orders may be passed ex parte. Let the matter be listed tomorrow under the same heading. Next.
Seven, my lord, Can 3, an application was filed seeking visitation of the minor child by the mother, my lord. During pendency of this application, my lord, the child has visited her mother, and presently it has.
You are the petitioner.
I am the applicant in Can 3.
My lord, appeal is mine, my lord. I filed the appeal and.
You have preferred against divorce decree or?
No, not divorce, custody. I prayed for, my lord. I filed the miss case for custody, my lord.
So this Can 3 was for appropriate order because you were allegedly not complying, but now you are complying.
No, my lord. Custody is with me by order of the
visitation. Compliance regarding visitation.
There is no in the order because stay of operation in the.
But now since you are visiting, giving the visitation.
Yes, my lord. That is, my lord. The child expressed his willingness vehemently, my lord, to visit the mother.
Very fair.
It did not stand in the way, my lord.
Extremely fair.
My lord, the application was filed before, but it could not reach, my lord. It did not reach.
No difficulty.
So, my lord, upon mutual agreement, my lord, I sent the son.
Thank
But,
you.
my lord, it would be, my lord, very beneficial for both of us, my lord, if there is a common order that in any vacation, if child expresses
Desires, then can.
then mother will go to, because I living in Guwahati. Mother will go.
Mother is willing to go.
This
go,
time one
Guwahati.
problem cropped up, my lord.
Yes.
The mother was to go to bring her child from Guwahati, but the father at that point of time did not want to give the visitation right for this interim order, my lord,
Yes,
which
my
is subsisting
But my
as to the custody of the child. My
I sent my child with my mother then in Kolkata because
after that, my lord, the child came to Kolkata and the mother
So, my lord, to avoid all these problems, my lord, let an
during
order
the
be
vacation,
placed.
my lord.
Yes.
Next is the puja vacation, my lord.
Yes, my lord. I do
During
not
the
want
puja
to stand in
vacation,
the way.
An extremely fair stand is taken by the appellant husband.
Yeah.
Full stop. Next para, the application bearing can 3 of 2026 has been filed at the behest of the respondent mother, alleging that the appellant father was not complying with an order of visitation passed by a coordinate bench on August 28, 2023. Full stop.
No visitation right was allowed, my lord, in the order. Order was, my lord, there are a very.
visitation was not been allowed by the
Yes, the honorable.
তাহলে allowing visitation না করে order dated না কি বললাম কোন সেন্টেন্সে by not honoring
Last orderটা
was not complying থেকে কেটে was not the থাক complying থেকে কেটে দিন, was not giving any visitation right of the child to
Yes.
the respondent mother. Full stop. Next para. However, comma, learned counsel for the respondent stroke petitioner stroke mother submits that despite there being no such specific direction, comma, the good sense has prevailed and the appellant father is granting such visitation to the mother. Full stop. Next para. Learned counsel for the appellant, comma, on instruction, comma, submits that in deference to the wishes of the minor child of the parties, comma, the appellant is even willing to permit the respondent mother to take the child from where he is residing at present with the appellant father, that is Guwahati,
Yes.
and bring him, child,
No, bring him and my lord return back because my lord minor.
return back, obviously, him or her, we are asking.
Him, minus.
Bring him, within bracket, the minor son, bracket closed, to Kolkata, comma, where the respondent resides
Yes.
during each vacation of the school of the child and immediately prior to the end of the vacation shall return the child to the appellant father. Full stop. Next para. In such view of the matter, comma, can 3 of 2026 is disposed of by granting permission to the respondent mother to visit the child at Guwahati at the residence of the appellant father upon prior intimation to the appellant. Full stop. Next para. Moreover, comma, during every school vacation of the child, comma, unless there is any other pressing business of the child which is unavoidable, comma, the respondent mother shall be entitled to bring the child to Kolkata during the tenure of such vacation and return the child to the appellant father before the end of the said vacation. Full stop. The appellant father, comma, needless to say, comma, shall comply with the cooperate in that regard. Full stop. No orders to costs.
My lord, I may be allowed, my lord, to contact my child, my lord, while he will be in because this vacation, my lord, I was not
Mother
allowed.
was allowed every
It is
time.
made clear.
It's 5 minutes.
Mother was allowed as per my instruction.
It
my
is
lord.
made clear that, but don't do it every 24 hours, 5 times you do it.
No, that should not be, my lord.
During the period when the child remains with the respondent mother in the vacations, comma, the appellant father will be entitled to contact the child, comma, either over the phone or by a video conference, comma, for at least for a period, up to a period of half an hour every day,
Yes.
if
My lord.
the appellant so desired.
My lord, one thing, my lord, because of this puja vacation, my lord, after 6 months, the CBSE examination will be of the child, my lord. He is passing Madhyamik. And for that reason, my lord, as per the routine of study of the child.
We have put that in, unless there is any pressing business of the child.
Yes.
We have put that in generally, because it may happen in other vacations
And my
also.
lord, during whole the vacation, as per order, my lord, there may be, my lord, it may be flexible, my lord. Because if 15 days or something, then, my lord, it will be a problem. No, desire of the
Desire of
child,
the child may be taken into
yes, my lord.
consideration, my lord,
Yes, my lord.
because
That is also-
During the vacation, কোথাও একটা
yes,
বলেছি।
it's for desire of the
During the school vacation of the child. আগে can 3 যেখানে dispose of বললাম বলুন।
end of the vacation কোথায় যাবে?
Return the child before the end of it.
End of the
তারপর return the পুরোটা পড়ার দরকার নেই, পরের সেন্টেন্স নেই, return No, no, return. And thereafter return the child. For the end of the vacation, comma, after the period of visitation, which is desired by the child.
Grateful, man.
Yes,
Before the vacation, you have already said.
After the vacation.
yes.
Grateful, man.
Thank
Affidavit of service may file there.
Affidavit of certified duty be kept on record after that. Thank. Next. Dakota. দাও ফাইলটা দাও ফাইল পরে ফাইলটা রেডি রাখো পরে ফাইলটা রেডি রাখো Yes, what is it?
The appeal has arisen against the grant of probate in favor of the respondents. I am the son, I am the appellant. Well, at the time the stay application was moved, and kindly see page 21.
Page 21 of Can 3. Which application? Can 3?
Can 3.
Page 21, yes.
And at page 22,
Yes.
kindly see that we therefore restrain the opposite party respondents and their men and agents and associates from transferring, alienating, or incorporating the suit property during the pendency of the present appeal. And in spite of that, at page 25, the respondents have instituted a civil suit, and kindly see the prayer. Now, the prayer is at page 28. Eviction of the defendant from the scheduled property, mean profit and all that. So that is in total violation, and what I am praying that let this suit be stayed. Or we have prayed before the trial court for stay of the suit, but trial court is not interested to stay it.
Yes, Mr. Halda, what do you say? This is in gross violation of this. Your filing of the suit itself is for, we'll discuss it. Let us see. Restraint from transferring, alienating, or encumbering the suit property. But
Yes,
there was
sir.
no injunction regarding possession.
Yes,
They cannot transfer, alienate, or encumber. They cannot transfer, alienate, or encumber. They have sought for eviction. There was no status quo regarding the property as a whole or
At page
regarding
20
possession.
page 28, the suit has been filed for eviction of the defendant from the suit property. If I am evicted, then nothing is there for the appeal.
Nothing is there for the appeal is not our consideration. Whatever we'll see, whatever order was passed.
Yes.
The order was from transferring, alienating, or encumbering the suit property. Your eviction does not mean encumbrance, nor is it alienating, nor is it transferring. Even if you are evicted, they still remain restrained from transferring, alienating, or encumbering the suit property. But eviction does not come within any of these. There was no injunction restraining them from disturbing your possession.
Well, in that case, I will be in difficulty if I have been evicted.
You will be in difficulty, obviously.
Protect me. If that be the case, kindly protect me. By
No, we cannot. This application is of a limited scope. You have asked for stay of that suit. But why should you? There is no injunction order passed by the probate court. Consciously, that was not granted to you by a coordinate bench. Why should you reopen that? Whatever happens in the eviction suit will be subject to the outcome of this probate. Suppose you are evicted,
Yes.
then the probate is negated. Then you can make necessary prayers. But this is not in violation of any injunction.
But encumbering, the word encumbering is there.
Eviction is removal of encumbrance, not encumbering.
Why
Eviction is not encumbering the property.
directly the encumbering means that I have been
We cannot construe an order indirectly. Whatever is directly there in the order, even for precedents, that is the law. You know better. For precedent also, you know better than us. You are sufficiently experienced because even precedents we cannot consider. In some derivative principle cannot be derived. Whatever is there in the order is there. No injunction from restraining your regarding your position. In the original injunction, there was a prayer for injunction. Let us see in the original application. We'll just check that. Can one must have been that application. Let us see.
But in the prayer that we have filed one application for stay of further proceeding of the.
Then there was. We cannot say that. We cannot say that.
Instead of granting that, this order has been met.
No, you can make necessary prayers there, but Mr. Haldar will say this, will reject this application because it does not, in our opinion, amount to violation of this order. But we'll give them liberty to pray for stay of the suit if they're otherwise entitled in accordance with law, and you will be entitled to oppose that.
They are for stay of operation of the judgment and
We are not granting from here.
dismissed, has been dismissed by the division bench earlier auction. Can you have a look at page 22?
22.
22, my lord.
We
It is in
have-
the middle portion, my lord.
We have prayed for
Paragraph number 8, my lord.
stay of further proceeding of
Can
the
one?
decree.
Can one is
Can one was stay of degree?
stay of operation of the judgment and decree.
Yes. They did not pray for protecting their position. Stay was dismissed. Stay was rightly dismissed. It's a judgment in name, Mr. Haldar. You know, we don't generally grant stay of probate. But injunction we grant. That injunction was obviously maybe due to inadvertence not granted, but not granted is not granted. But we'll do what we said. Can 3 of 2026 is an application alleging that, comma, in contravention of the order dated August 2, 2024, passed in connection with the appeal. Oh, no, can 2 was there. I'll just check.
Can
No, can 2 was discussed. Can 2 was for injunction.
Yes, sir.
You had made a prayer for disturbing the peaceful possession, but that was not granted. That's a deemed refusal.
I'm in predicament because of that.
You are in predicament, obviously. Now you have come here in predicament. But the difficulty is it was not granted, then we cannot also grant that prayer to put in that rider that you will be entitled. We cannot do that. I'm sorry. In contravention of যেখানে ছাড়লাম ওখান থেকে কমা দিয়ে the respondents have filed an eviction suit comma bearing title suit number 35 of 2024 in the court of the civil judge bracket junior division at Bidhannagar district North 24 Parganas in a bid to evict the appellant stroke petitioner from the subject property. For sub next para, learned counsel for the appellant submits that in the event that by filing the said eviction suit, comma, the respondent has categorically sought to disturb the possession of the appellant in respect of the subject property in the teeth of the order of injunction restraining the respondents and or their men and agents from transferring, alienating or encumbering the suit property during present pendency of the present appeal. So next para, learned counsel appearing for the respondent submits that an application bearing can 1 of 2023 had been not pressed by the appellant, comma, which was also recorded in the order dated August 2, 2024, full-stop. Moreover, comma, no injunction was passed restraining the respondents from disturbing the possession of the appellant at any point of time. For the next para, on a perusal of the order dated August 2, 2024, comma, we find that 2 applications were taken up for hearing and disposed of separately by the said order. Full stop. Can 1 of 2023 was an application for stay of the probate decree within bracket deemed bracket closed, which has been impugned in the appeal and was dismissed as not pressed. Full stop. However, comma, can 2 of 2024 was an application for injunction which was also disposed of by restraining the respondents and their men and agents and associates from transferring, comma, alienating or encumbering the suit property during the pendency of the present appeal. Full stop. Next para. However, comma, conspicuously, comma, although there was a specific prayer in can 2 of 2024 for restraining the respondents from disturbing the possession of the appellant in respect of the subject property of the will, comma, such prayer was not granted, which we treat to be a deemed refusal of such prayer. Full stop. The injunction granted was restricted to transfer, comma, alienation and encumbrance of the suit property, and the eviction suit subsequently filed by the respondents does not come within the purview of any of those. Full stop. Moreover, comma, in view of the deemed refusal of the injunction regarding possession of the appellant, comma, there is no fetter on the respondents to proceed with the eviction suit. Full stop. Next para. However, comma, we make it clear that we do not comment upon the merits of the said suit, and the same will be decided uh, uh, independently without being prejudiced without being influenced in any manner by any of the observations made herein. Full stop. In the light of the above, comma, can 3 of 2026 is dismissed without any orders to cost. Without any orders to cost. আচ্ছা, আরেকটা কথা, একটা তলে দিয়ে দাও। From the office report dated July 9, 2026, we find that along with the trial court records, comma, no exhibit list was sent. Full stop. Next para. The records, the trial, the concerned district judge, comma, Barashat, comma, North 24 Parganas shall ensure that a duly competent person is sent with the exhibit list, comma, if traced out in the trial in the concerned department of the trial court, comma, for such defect to be cured. For such, in the event the said exhibit list could not be traced out, comma, a report in that regard shall be submitted by the learned district judge with the learned registrar general of this court within 4 weeks from the date of communication of this order to the learned district judge. Full stop. This order be communicated immediately to the learned district judge at Barashat district, North 24 Parganas. Thank you. Next. আটটা হয়েছে, 80টা আছে, 10 গুণ দাও। Yes.
But here, my lord, I am appearing on behalf of the appellant, though, my lord. But my lord, there are certain things I must point out at the very threshold. My
Yeah.
lord, this entire thing, which has started with the filing of a suit for partition, is not maintainable. The reason-
Sandal, this is 1 lakh valuation.
My lord, furthermore, my lord, it's a legal aid matter. I understand, badly handled. but
Not
the
badly
thing
handled.
is, but
Different
the thing-
forum.
This district judge, it should have been. But my lord, the difficulty is, my lord, even the judge who had actually passed that order, denying entertaining of the partition, could not have, because this is a thika tenant matter. And my lord, that was not even mentioned, my lord, in the plain.
Ms. Sandal, even if you have to obtain a leave to take out an appropriate proceeding, you have to go before the jurisdictional court. We don't have determination to
Absolutely, my lord, even that court did not have. I just want to
that
show
point.
that.
You can take up what we indicate is, Ms. Sandal, in a competent appeal, you can move the appeal. While moving the application, you can ask for leave.
My lord, before your lordship gets into the document, my lord, that is the reason.
You
I
can ask for
pointed out.
leave before the competent.
First, my lord, the base court did not have the jurisdiction.
You can take that point before the
And
competent appellate
secondly,
court.
my lord, this court also does not, because it is a district judge who should have been.
That is what we are saying, that we just say that we don't have determination, we give you leave to prefer before the competent court. Before the competent court, we need not advise you, you know better.
My lord, my
You
lord.
can just go and say that we withdraw the entire thing lock, stock, barrel, or let the appeal be disposed of with liberty to you to approach the competent forum. No competent forum.
My
Take
lord,
up
my lord
property, there is
mentions
no.
that because this person appellant is a blind person, 100% blind. That's the reason why he had to
Take up
undergo
property, could you ask for partition?
My lord, that is also a issue.
Why should we handicap him twice? Let that be done by the jurisdictional
My
appeal.
lord,
If you don't prefer an appeal, advise him not to prefer an appeal then.
my lord,
It has been dismissed on the ground, decreed.
decreed. My
Or decreed. Then take that. That will be the first point in your appeal. Why should we
My lord,
say
that
anything
is
else?
the reason why I said. My lord,
What's
it
it?
was a one-pager decree. My lord, it is there with the memorandum.
Then your appeal should succeed at the drop of a hat. But we won't mention anything because we don't have determination to take up there.
True, my lord. That is why I
We'll record your submission on that.
Yes.
Learned counsel appearing for the appellant submits at the outset that this is a legal aid matter, and the appellant, comma, being financially indigent and otherwise challenged, comma, was apparently not properly advised. Full stop. The present appeal has been preferred against a. No, the suit was dismissed, not decreed.
Dismissed, my lord.
Suit was
Dismissed. It was a suit for partition.
We will not
and that was
say anything on that partition because the suit is not. Ask him not to prefer an appeal. The suit was dismissed ex parte. Full stop. Next para. However, at the outset, we find that the valuation of the suit was rupees 1 lakh, and as such, the concerned district court is the appropriate court having pecuniary jurisdiction to take up the appeal. Full stop. Hence, FAT 27 of 2024 is dismissed as not maintainable on the ground of pecuniary jurisdiction, with liberty to the appellant, if the appellant so chooses, to prefer an appeal before the competent court having pecuniary jurisdiction. Full stop. Can 1 and can 2 are disposed of as redundant in view of the above observations. Full stop. Next para. The appellant, the learned advocate in record for the appellant will be at liberty to take back the certified copy of the impugned judgment and decree upon furnishing photocopies thereof for the records.
My lord, only two things I was beseeching, my lord. One is, my lord, to file an appeal, my lord, if your lordship says that appropriate proceeding, I think that will be better for these people.
What is the appropriate proceeding? No proceeding.
And my lord, the other thing is, my lord, that I had in my submission that this is Thika property. My lord, if your
We
lordship.
won't say that that goes against your client. Why should you
My
mention? That's what we said. Let him not be handicapped twice, legally and physically.
Much obliged.
Let that be as it is. We just dismiss the appeal. If you don't prefer an appeal before any forum, then it goes. Your suit was not maintainable. There is no other provision in law which enables you to take out a partition suit.
Man, much obliged.
Yes, Mr. Shanal. What?
In this matter,
We are dealing with Shanals now.
this is not my application. This application has been filed by
The
the
side.
lordship respondent. And
Yes,
this
respondent. What is your
kindly comes to lordship. The paragraph number 7 is the
the
lordship.
prayer? Appropriate order. We hate appropriate order.
Allegation is lordship that we are not taking steps for lordship preparing the paperwork and
What is your
other.
answer?
We have lordship already after on 12th. We have lordship deposited the lordship special messenger on 13th.
No notice of appeal as yet.
Notice are prior to that. Prior to that, we have.
Has a notice of appeal been given to you? The records have come.
No. It has been sent down for correction. Lojima court, they did not appear. None of the parties were appeared lordship. That's why it's been sent down. It was came from the lordship learned trial court. Thereafter lordship from some correction lordship. The learned register has sent down the record before the learned trial court. On
We'll permit you to move the registered logima.
On 13 July
Registered-
2026.
Registered logima regarding the sending back of the records to this court. But we cannot allow this application because they are not at fault.
On 13 July lordship that
Can 4 of 2026 has been filed by the respondent numbers 1 and 2, by the respondent number 1 in the appeal, alleging that the appellants have deliberately delayed the preparation of the appeal for final hearing. Full stop. Next para. It is pointed out, we are putting words in your mouth, sir. We are putting words in your mouth in support of It is pointed out by the applicant that in defiance of the order dated December 12, 2024, no paper books have yet been prepared. Full stop. Next para. Learned counsel for the appellants submits that in compliance of the said order, special messenger costs were deposited and the trial court records had been brought before this court. Full stop. However, subsequently, due to some defects in the records, those were sent back to the trial court for effecting necessary rectifications. Full stop. Thereafter, it is submitted, no notice of arrival of the trial court records has been served on the appellants. As full stop. As such, no paper books could be prepared as yet. Full stop. Next para. In view of the above, can 4 of 2026 is disposed of by directing the office to serve a fresh notice of arrival of the trial court records after rectification as and when the same arrive on the learned advocates for the parties. Full stop. The appellants shall, within the time stipulated previously, therefore, take appropriate steps for preparation of paper books. Full stop. Next para. Liberty is granted to the parties to move the learned registrar within bracket lozima in respect of the early arrival of the trial court records after rectification. No rest of cost. You can move the register lozima, seek appropriate orders or report from the district court. Register lozima will do that so that to ensure that it arrives quickly. When it arrives, notice will be given. Their paper books. Thank you. Next. Give your names.
11th, my lord, I applied for the petition.
Yes.
This is my affidavit of service.
Good service affected, Mizra?
Yes.
Yes. What is the matter?
This is an application under Order 41, Rule 27 for reducing additional.
Will direct pass the usual order to be heard along with the appeal. You serve copy?
Yes, copy served.
Oh, achha.
Yes, copy served.
Was there a direction of court or of your own you have served?
No, I have of my own. I have.
No, that is not a valid service because our directions substitute rules.
Right.
The rules, you know, your father knows at least.
I don't know.
You ask your father why it should.
The paper books were all.
Very well. No difficulty. Can 2 of 2026 is an application for production of additional evidence under Order 41 Rule 27 of the Code of Civil Procedure. Full stop. Next para. Although an affidavit of service is filed today, comma, since there was no previous direction of the court, comma, we direct the appellant to, since there was no direction of the court to so serve and none appears for the respondent at the time of call, comma, the appellant is directed to serve a copy of Can 2 of 2026 afresh on the respondent and file an affidavit of service to that effect at the time of hearing of the appeal. Full stop. Affidavits in opposition, comma, if affidavit in opposition, comma, and affidavit in reply thereto shall be filed by the parties before the hearing of the appeal. Full stop. Next para. The application, comma, due to its nature, comma, shall be listed for hearing along with the appeal. Full stop. Can 2 of 2026 is disposed of accordingly. Heard along with the appeal, serve copy immediately so that they can file their opposition and you can file it.
But when it will appear, my lord?
It will appear along with the appeal whenever the appeal is ready.
Appeal is the LCR is there, my lord.
Whenever the appeal appears before some court, the application will appear along with that. The department will keep it along with the appeal. Thank you. Next. 12. Yes.
12 petition for restoration.
Within time or beyond time?
The time is, I have filed
Section 5 is also there. What is the delay?
delay 231.
231.
232.
Have you served copy on other side?
Yes, my lord.
Was there a direction for service?
Yes, lordship.
What is the envelope? What is the endorsement? Feruddin, প্রশ্ন করছি হাতে ধরে দিচ্ছে. What is the endorsement there? What is the endorsement in the envelope?
Reports, my lord. Report.
Check up, please. Refused.
Refused.
Hand over. Hand over both. The affidavit of service also. What is the delay? You said 232. What is the reason for the delay?
Delays.
Reason for your absence and reason for the delay?
Delay, my lord. The learned advocate did not appear before the before their lordship, the Honorable Justice Horistander.
That is not an excuse. Why did not he? Why didn't he appear?
Delay, my lord. On that time, petitioner was on duty, my lord, as a soldier during the period of operation of Sindhu. My lord.
No, petitioner we can understand. Why was the advocate not present? You have to give some reason for that.
My lord, I have served already. My lord, did not.
Why was the advocate not present?
Advocate not present. Ex-learned advocate not.
You have cast aspersions on the advocate, then you have to serve the previous advocate and come back. Serve the previous advocate. The affidavit of service and the envelope sent to the respondent, comma, indicating service of the application on the respondent, comma, is filed in court today and kept on record. First, from the endorsement in the envelope, comma, it appears that service was refused, comma, which tantamounts to good service. First of next para, however, comma, we find in paragraph number 5 of the application for restoration that allegations have been made against the erstwhile learned advocate for the appellant. First of next para, accordingly, a copy of the application of Can 1 of 2025 as well as Can 2 of 2025, copies shall be served on the erstwhile learned advocate for the appellant, and an affidavit of service shall be filed to that effect on the returnable date. Full stop. Next para. Along with such copies, comma, a server copy of this order shall also be served on the said erstwhile learned advocate. Full stop. Next para. The application shall next be listed in on August 17, 2026. Serve copies of these applications and a server copy of this order on the erstwhile advocate, and pray that it does not appear on the next day. Yes.
For the appellant.
Give your name. Give your name, please. Your name?
My name is Suresh Malik.
Write on a piece of paper for the records. Yes.
My lord, for the respondent.
My lord, this is the affidavit of
Prediction,
assets.
my lord, not today, my lord.
No, refused. What is the application for?
Application for my lord, maintenance pendulite, my lord. Your lordship directed both the parties file the affidavit of my lord assets. I
You are
filed.
filing your assets.
Yes, yes.
Then
I served the copies thereof.
why
On
haven't you filed your opposition?
21st May, I have served.
My lord, I'll be candid, my lord. We don't have the brief, my lord, today. I mean, kindly, my lord, not today, my lord. Only.
No one will impose cost on you. Sorry. When was it directed to? When were you directed to be? Was there a direction on you to file this?
Yes, yes.
When? Date of the order.
Date of the order.
Affidavits were directed here.
Yes, yes, my lord.
What is the order date?
They received the affidavit of my
No, there was no direction for affidavit. Sorry.
Yes, my lord.
When? There is no direction. Give us the date of the order. There is no direction for affidavits. Only a direction to serve.
No, my lord.
Sorry, you are
My
stating incorrect statements.
my-
এটা দাও তো। তুমি একটু alert থাকো কোর্টে কি বলছি। Show us the order where affidavits are directed. Where are you making incorrect statements, Mr. Da? Can 1 was disposed of by the previous order, then you were directed to serve a copy of this. No direction of affidavit was ever given. Last order is on the top. You ask your son to check up. You check up. Please give him the order sheet. The last order is at the top. You please see by the previous order, can 1 was disposed of, thereafter direction to serve this copy.
No, my lord. Perhaps there is a direction. The matter.
Show us.
My lord, matter went to the my lord mediation by my lordship's order.
Show us the direction for affidavit. Yes, hand it over.
Okay.
Then an adjournment is sought on behalf of the respondent husband. Full stop. Next para. In any event, comma. Since affidavit of assets and liabilities are filed by the appellant stroke petitioner today, comma, have you given copy of this affidavit of asset also?
21st May,
comma, the respondent is directed to file affidavit, composite affidavit in opposition to the alimony application and the affidavit of assets of the appellant wife within 3 weeks from date. Full stop. A composite reply thereto, comma, if any, shall be filed within a week thereafter. The application shall next be listed in the monthly list of September 2026. Affidavit of service you have filed today.
My lord.
Affidavit of service you are filing today.
Yes, my lord.
Affidavit of service filed today be kept on record. Next. You please take down, tell your senior that what you have directed. See, within 3 weeks, composite affidavits to this. Oh, sorry, arekta line add kore. Affidavit of composite affidavit of affidavit in opposition along with the affidavit of assets of the respondent husband shall be filed within 3 weeks. Give your names. Give your name. Your name only. Who is not appearing? Why are you giving him his name? You are asking for adjournment on his time and you are giving his name. Who taught you this?
Lord,
Give your name only. You are asking for adjournment on the ground of a person and you are putting his name. Unheard of. Only your name, please step aside. Call on the next matter. Yes, Mr. Bose.
And for the decree holder respondent.
Respondent. Not interested in respondents. Please for the appellant.
The state. This is an application, my lord, for withdrawal of 50% of the decretal sum which has been deposited in court.
It's your application.
My application. This is a land acquisition case. Now, on the last occasion, your lord.
Suppose in some cases court grant, some cases court don't. What will be the security you will put in some?
I'll tell your lordship this. The entire appeal does not have any merit anymore because this is a large chunk of land requisitioned under the 1948 Act, which then lapsed. Then there were acquisition proceedings. One of the references made out of that LA case, final judgment has been passed by the by this honorable court, upholding the judgment of the court below. So there are multiple petitioners in the same acquisition process.
So the appeal, nothing survives in the appeal.
Nothing really survives. I'll show your lordship.
So
this.
challenge by one of the other land losers have been decided.
One of the other land losers filed a reference under section 18, obtained a decree. State preferred an appeal. Appeal of the state has been dismissed.
So that reference stands.
Yes, so this is the judgment.
Mr. Bose, keep it with you. Just we'll direct you to serve a copy on the GP office, and we'll take
We
it
have
up.
done that. Affidavit of service filed on the last occasion.
Oh, then they hand it over. Yes.
Supplementary affidavit কোথায়? Supplementary টা? না, কোর্টের কপিটা কোথায়?
Mr. Bose will record your submission. We'll keep this on record, and we'll say that the appeal and the application will be taken up together on the papers available. We'll fix a date for that. Give another notice because we'll take
because
it.
the old gentleman money.
Definitely, you understand. Learned counsel for the respondent stroke petitioner submits that although the present application is for withdrawal of 50% of the deposit made in connection with the appeal by the state, in the meantime, a reference under section 18 of the Land Acquisition Act 1894 made by another land loser in respect of the same cluster of lands as the present matter was disposed of, against which an appeal was preferred by the state, which has since been dismissed, thereby affirming the order passed under reference. For the next para, learned counsel for the respondent stroke petitioner submits that the present appeal ought to be governed by the said verdict, the said decision. For the next para, in view of the short ambit of the appeal, we are of the opinion that the appeal and the application can be disposed of together on the papers already on record by dispensing with formalities regarding paper books. However, since none appears today to on behalf of the state stroke appellant, as a last chance to the state to appear and put forth their version before the court, the learned advocate on record for the respondent stroke petitioner shall serve a notice, along with a server copy of this order on the office of the learned government pleader, indicating that the application shall be taken up for hearing on August 10, 2026, when a receipt in that regard, receipt stroke affidavit of service in that regard shall be filed by the respondent stroke petitioner. It is made clear that the understanding will be that the appeal and the application will be taken up for hearing together on the returnable date. In the event the state chooses to abstain from the said hearing, the appeal may be disposed of along with the application expert.
Obliged.
That's why we have put in several things.
Yes,
so
yes.
give a server copy of this order along with it.
Yes, ma'am.
Next. Yes.
I am for the appellant.
Yes.
On the last occasion, it was submitted before your lordships that
Please take the microphone, Mr. Last occasion submitted that
there is suppression of material facts before your lordships while moving the application for stay. What is that suppression? That in the earlier suit we have lost. So it is res judicata.
Order 9 Rule 9.
Yes, but the fact remains that the present suit, the cause of action of the
two suits. One was decided on merits, another dismissed for default. So order 9 Rule 9 as well as
yes. The question was whether I have prayed for declaration of my tenancy and I have lost. If that be so, I am submitting before your lordship that this may be a case of res judicata.
What was the previous suit?
Previous suit for declaration that I am a tenant in respect of 2 rooms along with 100 square feet open space, and the landlady was trying to encroach my 100 square feet open space. Today, I have.
You said that 100 square feet was a part of your tenancy.
Yes.
2 rooms plus that.
Yes, and the learned trial court held that no, in that suit, that tenancy in respect of 2 rooms is admitted. Lordship, kindly come to my reply.
Complete, then we'll come to. Yes.
The tenancy, so far the tenancy in respect of 2 rooms.
Admitted 100 square feet, not.
Yes. Let me accept that.
So what was the decree then?
The suit was dismissed as a whole, but the judgment says that it is well admitted that I am a tenant in
So what is the present suit for?
present suit for declaration that subsequently declaration and recovery of possession that subsequently have been dispossessed. So till date, from the side of the landlady, there is no suit for eviction. They have to file. This is my
So your suit, present suit, is for declaration of your tenancy rights.
as 2 rooms and for recovery of
Two
possession.
rooms declaration of tenancy rights, if it was held by the learned trial judge on the previous occasion, then also it's barred by res judicata. It has been held in your favor.
In my favor. So at best, I can safely say that I am a tenant in respect.
So even if your declaratory relief is barred by res judicata being held in your favor,
yes,
still your suit remains for recovery of possession.
Yes.
Acha. What was the order 9 rule 9? Dismiss for default suit?
No.
What
Order
was
9
that
rule
suit?
9. I have not filed any order 9 rule 9.
What was the second suit for?
Second suit for same that they were again trying to disturb my possession by making unauthorized construction. That was dismissed for default.
So then order 9 rule 9 hits you.
But at the same time, so far the declaration I have sought for in the suit. Lordship, now kindly come to my reply at page 14. The earlier suit. Well, this is the reply.
ওই পেজটা অরিজিনালি নেই, এখানে সার্টিফাইড কপি অরিজিনালি এতে করে দেবে।
So there is no dispute. And in that suit, my lord, I have not prayed for recovery of possession.
Page 14 is the first suit decision.
Yes. Moreover, kindly come to the first line. Moreover, the plaintiffs have prayed for declaration that the plaintiffs are the tenants in respect of 2 rooms, including 100 feet wide area up to the room, but that is not the part of the tenanted portion of the plaintiff. So no declaration can be granted because the plaintiff's tenancy in respect of 2 is well admitted.
Even previous page.
Yes.
Page 13.
My lord,
before the issues,
it is the case of the plaintiff.
On the other hand, the defendant by filing a written statement that continues.
They created on the basis of an agreement made in.
And fact remains that the plaintiff is a tenant in respect of the 2 rooms on the ground floor, and except this, there is no other room immediately above the issues.
Yes.
So that was decided in your favor.
Yes.
Acha, very well. Let us see the dismissal for default of the second suit. You must have annexed that also.
My lord, dismissal for default, that is not available to me.
Not available. Must be available to them then.
Yes.
So let us see from their opposition.
Page 44 of the opposition.
Up to this, my lord, may I submit one thing? Up to this, my tenant.
Up to this, we understand you, sir. Yes. Let us see 44. Because now the other part remains 44. Please fix for hearing. Acha, where is the plaintiff of that suit? Have you annexed the plaintiff of second suit?
Second 20. No, that was not annexed, but I am handing it over.
It's their suit, so they should have a copy. Particularly after the allegation.
Too short.
Where is the present plaintiff prayer?
Lordship, kindly come to the degree.
Page 18 of
Page
the
12 of the
page 18 is the prayer.
Page running page 69, my lord, of the stay application, the prayer of the present plaintiff. A declaration that the plaintiffs, being the tenants in respect of the scheduled property, have every right to enter into the scheduled sub-room without any disturbance and interference by the defendant. Permanent injunction, then mandatory injunction. And the lordship kindly see at page 70 the schedule. All that 2 rooms, 1 big room and 1 small room. But I submit before your lordship that so far the tenancy of 2 rooms, that is not disputed. If that be so, they cannot show any papers that I am suffering any degree for eviction. If that be so, then my lord, my suit is very much maintainable. And
your suit is not barred on merits. We are not saying that. They are also not saying that.
Yes.
Satisfy us, Mr. Rai, whether your this suit is not barred by Order 9 Rule 9 because of the dismissal for default of
That is one thing, my lord. On the last occasion,
forget the last occasion. Just satisfy us with the plain side before us.
I'm just trying to cut short the matter, my lord.
We have cut it short. Nothing remains. You just answer this question. It will be over.
Hear out the appeal. Hear out the appeal.
We will dismiss the appeal right now.
My lord, so far the point raised by your lordship my
You have not
respectful-
raised anything. It's before us the two plaints. You satisfy us, Mr. Rai. It's
That's-
already raised.
my tenancy in respect of 2 rooms is undisputed till date. And they said that I am suffering a degree that my suit is dismissed.
No.
But those degrees, there is no single degree of eviction against me. Once a tenant, always a tenant. They have to satisfy your lordship that I have raised this point after disposition that I am suffering a degree for eviction. Had it been a case that I am suffering a degree for declaration, my third suit is not maintainable. I am submitting before your
Well,
lordship.
we'll ask them a question. One question to you. Everything in your favor. Mandatory injunction is a new cause of action. Continuing cause of action. Even if it is barred on the earlier reliefs, the tenancy of it was recorded in the first suit that you have admitted in your written statement. Tenancy declaration becomes redundant. Permanent injunction they asked for in the last suit, Order 9 Rule 9 suit. We are now speaking of the Order 9 Rule 9 suit. Tenancy declaration, Order 9 Rule 9 bar is there. Order 9 Rule 9 and res judicata operate in somewhat different fields. Res judicata, the same subject matter you cannot re-argue, constructive or res judicata. But Order 9 Rule 9 is the bar in a suit on the self-same cause of action. So there's a subtle distinction. Once more you nod your head, we'll dismiss you.
Lordship, I have to say.
Yes. So Order 9 Rule 9 is on cause of action. Cause of action is somewhat different from subject matter. Mandatory injunction is maintainable. That's not a material suppression.
My lord, first of all, this is not a suit under section 6 of the specific.
No, it's not. It's 5.
It's a 5.
5.
5.
No,
There is a misconception. See, even if I file a suit only for possession, on the basis of title, I can file it. That will be under section 5. All the suits only for recovery of possession are not under section 6. This is a section 5 suit, no difficulty. Even if the declaration pair is not there, section 5 of specific real fact is the language is on the basis of title. Basically, on the basis of entitlement or something like that. It boils down to that. We are paraphrasing. So, entitlement. Therefore, if I am entitled, even without seeking a declaration, I can ask for mandatory injunction for recovery of my possession under section 5 also. Therefore, mandatory injunction is maintainable. That suit has been dismissed, that you have challenged here. And what is this CAN 1 for?
CAN 1 for stay application.
That is the injunction application.
Injunction application.
Not creating any third party interest, nature, character. You are granting that. Suit has been dismissed. Why? On the ground of?
Res judicata.
Only on the ground of res judicata. If you agree, we can dispose of the appeal itself.
Yes.
It will save you time. Otherwise, we'll grant injunction.
No.
It's not a threat. I mean, we'll do that. What we actually will do that, we say. It's an offer, rather, to cut short the matter.
First of all, no.
First, second, third, come to the last.
Lordship, kindly come to the.
This is only on the we have seen.
Yes.
But where res judicata?
Only res judicata. He has not entered into the merit of the matter.
Let us dispose of the appeal. We'll say whatever you said just now, and we'll dispose of the appeal application, and we'll direct the court to hear out on merits, and within, say, 6 months, it will be decided. Not 6, 8 months.
The thing is that.
What is the thing?
What they are saying that it is in favor of the admission of the 2 rooms in the earlier suit. That is an issue that has been, according to them, that has been decided in their favor. But the suit in which the declaration is sought for tenancy in respect of the 2 room along with 10 feet passage had been dismissed.
The present suit?
No, earlier suit.
The Order 9 Rule 9 suit?
No.
Previous one, yes.
Yes.
So there, that 100 square feet is not, it has been held against them.
And now in this suit, they
also included that. That is what
they also kindly come.
Let us see this schedule.
Kindly come
to the
come to
degree.
no, kindly come to page
You have
18.
finished your submissions. Now we'll come back to you if necessary. Come to the schedule. Yes.
No. Kindly come to page 18.
Come to the schedule at page 19. What are you saying?
It is there.
See?
It is our opposition.
Oh, come to their plaint. Internal page.
It is their plaint. My lord, kindly come to the plaint at page 18 of their opposition. And
come to the schedule of their plaint. Please come to the schedule of the plan.
I know the schedule is
The relief shot is in respect of the schedule.
in respect of the two rooms.
No, the schedule shop room.
In respect of the schedule shop
And
room.
the schedule also is two shop rooms.
But in the body of the plaint, they claim
suits
that
are not
10 feet-
decided on bodies, only on the reliefs and the
So,
schedule.
no. And another thing is that if the suit has been dismissed and one issue had been gone in their favor, that has not the binding effect on us. I have a judgment. Yes. Any judgment?
Because you cannot prefer an appeal against the finding.
Yes. Kindly. বলছি this is page 35 and paragraph number 46. Last but not the least reason hold.
Paragraph number, sorry,
46.
Page
35. Last but not the least reason to hold that the finding in the that suit recorded by the High Court in its original judgment on canon, etc., could not operate as res judicata is where a decree is one of dismissal in favor of the defendants, but there is an adverse finding against him. A plea of res judicata cannot be founded upon that decision because the defendant, having succeeded in the other plea, had no occasion to go further in appeal against the adverse finding recorded against him.
Then that issue is not res judicata.
That point is not res judicata.
But trial court has held it is barred by res judicata, not or
No, the entire suit has gone. The two rooms along with this 100 feet passage had been declared dismissed.
That was on the basis of your admission. So you are barred by issue estoppel then from raising that point. You are not barred by res judicata, you are barred by issue estoppel because we agree what you are saying. Suppose it was a finding of the court that I find that no, this issue should go in their favor. Only one issue, but should dismissed. Then this judgment would be applicable. But it's recorded in that judgment that in your written statement, it was a quotation of your written statement. From a written statement, it appears that those two rooms, they are tenants. That was a narration of your written statement. So you are then barred by issue estoppel from raising this issue. Yes, we are deciding it. The appeal and the application are taken up for hearing.
Thing I want to the CPC today.
What is there in the CPC that we need to be apprised of?
My lord, kindly
Tell us.
section 11, explanation 5. Any matter which might and ought to have been made.
That is 5.
Sorry.
That has become 5 now.
No. Any relief claimed in the plaint which is not expressly granted by the decree shall, for the purpose of this section, be deemed to have been refused. Now the main prayer.
What has not been asked for by them?
They had asked for declaration
regarding the entire thing.
Entire thing that has been refused.
We'll deal with that. We are dealing with that. The appeal and the application are taken up for hearing together due to the short ambit of the same. For sub next para, the appeal arises out of the dismissal of the plaintiff/appellant suit for declaration of their tenancy right in respect of two shop rooms, comma, for permanent injunction and for mandatory injunction, comma, on the allegation that the appellants have been subsequently dispossessed from the suit property. For sub next para, learned counsel for the appellant argues that although a previous suit had been dismissed, comma, where apart from the two shop rooms, comma, tenancy was claimed by the appellants in respect of 100 square feet space as well, comma, the learned trial judge had come to the finding that insofar as the two shop rooms are concerned, comma, it was the admitted position from the written statement of the defendants stroke respondents that the appellants are tenants in respect of the same. For sub next para, thus, comma, even thus, comma, the said issue was settled Full stop, next para. Moreover, comma, the subsequent bracketed second suit, which was filed for similar relief of declaration regarding the two shop rooms as well as permanent injunction, was dismissed for default, but the same cannot operate as a bar under Order 9, Rule 9 of the Code of Civil Procedure, comma, since in the present suit, comma, the additional relief of mandatory injunction has been sought. For the next para, learned counsel for the appellant places reliance on such as such reported at AIR 1995 SC 2001 for the proposition that even if a finding was rendered against the successful party in a suit, comma, the said party shall not be barred by res judicata due to such finding, comma, simply because the said party, having succeeded in the suit on the other plea, comma, did not have an opportunity to prefer an appeal merely against the adverse finding. Full stop, next para. Moreover, comma, it is argued that in the previous suit, comma, the relief of declaration of tenancy, previous suits, comma, the relief of declaration of tenancy right in respect of the two shop rooms was sought but not specifically granted. Full stop, next para. In such view of the matter, comma, going by explanation 5 to section 11 of the Code of Civil Procedure, comma, it should be deemed that the said issue was decided against the plaintiff's stroke present appellants. Full stop, going by such principle, comma, learned counsel for the respondents argues that the self-same relief, comma, having been turned down previously, comma, cannot be re-agitated at the present stage. Full stop, next para. Insofar as the first question is concerned, comma, we find that the first suit between the parties was dismissed insofar as the claim of tenancy rights of the appellants with regard to the 100 square feet adjoining plot was concerned. Full stop. Although the issue of declaration of tenancy rights of the appellants regarding the two shop rooms was not specifically decided in the said suit, comma, the learned trial judge, comma, on the said occasion, comma, clearly narrated the pleadings in the written statement made by the respondents to the effect that the tenancy of the appellants regarding the two shop rooms was an admitted position, and went on to observe that the further extension of tenancy regarding the 100 square feet plot could not be granted. Full stop, next para. Thus, comma, although the principle of res judicata might not operate squarely, comma, the issue having not been decided, comma, in view of the categorical stand taken by the respondents in the written statement in the first suit, comma, which was recognized by the trial court on the said occasion, comma, the respondents are, comma, nonetheless, comma, barred by the principle of issue estoppel insofar as the tenancy of the appellants regarding the two shop rooms is concerned. Full stop, next para. Insofar as the issue of tenancy rights regarding the said shop rooms is concerned, comma, thus, comma, although does not come within the purview of section 11 or its explanations of the Code of Civil Procedure, comma, by application of the doctrine of issue estoppel, comma, the said issue cannot be said to be res integra inter se the parties. Full stop, next para. Coming to the next question, comma, the second suit of the plaintiffs on similar cause of action was dismissed, comma, thereby apparently attracting the bar under Order 9, Rule 9 of the Code of Civil Procedure. For some next para, however, comma, the conspicuous difference between the two is that in the second suit, comma, declaration of tenancy right regarding the two shop rooms as well as merely permanent injunction protecting the possession of the appellants was sought, whereas in the current suit, comma, it was further alleged that subsequently the appellants had been dispossessed from the suit premises and a relief of mandatory injunction, comma, which is in the nature of a continuing cause of action, comma, was also sought. Full stop, next para. The cardinal difference between res judicata and a bar under Order 9 Rule 9 is that whereas the former pertains to decision adjudication on the subject matter of the dispute, and also covers the reliefs sought in the suit, the latter pertains strictly to the bar of filing a fresh suit on the self-same italic say cause of action. Full stop. Next para. Hence, for the purpose of the bar under Order 9 Rule 9 in the present case, this court is to look only at the cause of action pleaded in the current suit, full stop. Since the cause of action for mandated injunction is a subsequent cause of action and also is a continuing one, it cannot be said that the current suit is on the self-same cause of action as the second suit, thus precluding the operation of the bar under Order 9 Rule 9 of the Code of Civil Procedure, at least insofar as the mandated injunction relief is concerned. Full stop. Next para. As held above, since the issue of declaration of tenancy rights of the appellants with regard to the two shop rooms is no longer res integra, the said issue is rather a non-issue stroke a redundant issue, and the current suit shall be heard primarily on the issue of mandatory injunction. Full stop. Next para. Thus, neither the current suit is neither barred by res judicata nor under Order 9 Rule 9 of the Code of Civil Procedure insofar as the claim of mandatory injunction is concerned. Full stop. Next para. The learned trial judge, by the impugned judgment and degree, erroneously dismissed the suit only on the ground of res judicata, which according to us is contrary to law. Full stop. Next para. Hence, FA 236 of 2024 is allowed on contest, thereby setting aside the impugned judgment and decree dated September 27 or 22. What is the date?
24. 24.
12th of July 2024.
Oh, 12 July.
12th of July.
July 12, 2024. These were the third bench.
Yes, sir.
11th bench.
Were tried by the third bench.
July jeta bollam, passed by the learned judge, third bench, city civil court.
11th bench. 11th bench. 11th bench.
Passed by the learned judge, 11th bench of the city civil court at 11th bench of the city civil court.
Yes.
11th bench of the city civil court at Calcutta in title suit number 674.
No, 156 of 22.
Third bench. Third bench.
But final judgment is by 11th bench.
It was found for the third bench.
Acha, in title suit number 156 of 2022. Full stop. The suit is now remanded to the learned trial judge for an adjudication on the merits in the light of the above observations by giving adequate opportunity to both parties to lead evidence. Full stop. It is expected that in view of the long pendency of the matter, the learned trial judge shall make all endeavor to dispose of the suit as expeditiously as possible, preferably within 8 months from the date of communication of this judgment to the trial court. Full stop. Can 1 of 2026 stands disposed of accordingly? No order as to cost. Interim order, if any, stands vacated. This much. Formal decree hobe na, remand korbo.
Two things I want to bring to your lordship notice. I have made out a case that they have surrendered their tenancy. That has not been decided by the trial court. Now, another thing is that after the suit was dismissed, the shop room had already been
needless to say, all questions are being are kept open for being argued by the parties on their own merits, and if so raised, the learned trial judge shall decide those independently in accordance with law without being influenced unnecessarily in any manner by any of the observations made above.
Landlord's application for deposit of occupation charges.
Occupation charges?
Yes. In the appeal filed by the landlord against
under what provision can we do that? Order 41 Rule 5, you know the answer was. Order 41 Rule 5, we can do that as a condition.
Recently, your lordship is aware a judgment has been passed by the Honorable Supreme Court.
Cited.
This is reported in 2024 8 SCC 668, my lord.
Can you come to the relevant paragraph, sir?
Yes. My lord, in paragraph 2, your lordships will find that during pendency of these leave petitions, interlocutory applications have been filed before the Supreme Court. But same set of facts, but the application was filed before the Supreme Court for deposit of occupational charges.
In this case, present case, your suit has been dismissed.
Dismissed. And here also the suit was dismissed. It was carried before the Supreme Court. Lord, in paragraph 13, it is recorded that the applicant petitioner is SLP seeks direction for payment of monthly occupational charges. Paragraph 14, my lord, the area is Dalhousie area. Here it is near Chandni Chowk. But in paragraph 16 and 17, the respective charts are set out where the tenant and the landlord have given their estimates.
Yes.
The landlord's calculation is based on a report by a valuer. Then, my lord, paragraph 28 onwards, the Honorable Supreme Court discusses the issue, my lord, relying on various previous judgments. If your lordship kindly comes at paragraph 31, having considered the submissions made across the bar, we note that the disputed nature of the lease deed, in other words, its continuation or forfeiture on account of non-payment, is heavily contested, and stemming therefrom, so is the nature of payment to be made. We also note that the location of demised premises is in the heart of Kolkata, and if the submissions of the petitioner are to be believed, they have been deprived of rent for a considerable period of time. Taking lock, stock and barrel view of the present dispute, the averments and the documents placed before us, we may record a prima facie view that the respondent tenant has, for the reasons yet to be undemonstrated, been delaying the payment of rent and other dues payable to the petitioner, applicant, landlord. Denial of monetary benefits accruing from the property when viewed in terms of the unchallenged market report forming part of the record is undoubtedly substantial, and as such, subject to just exceptions, we pass this order for deposit of the amount, which was, my lord, later on directed by the Honorable Court.
Mr. Shen, you notice the last phrase of para 31.
31.
To ensure complete justice interest the parties. So that's squarely under 142.
But I knew it was coming from your lordship, but nonetheless, my lord, this principle has been laid down, and considering the report of the valuer, this direction was passed.
Your suit was filed on what ground?
Default and reasonable requirement.
Default ground will still be available to you in the appeal if you succeed. So if they don't pay, they're at their own risk. We'll say that if they don't pay at their own risk. But we cannot invoke this judgment to, because no issue was laid down here. The court considers in paragraph 28 that yes, that argument was made, but not decided. If it was decided, turned down, that argument was specifically made here. You are right that an argument has been made that it can be granted only. Para 28 squarely records that as observed above, the respondent contends that since in the present case no decree of eviction is passed and there is no stay awarded, the question of such payment does not arise. This question was taken note of, but not decided. Ultimately, what the Honorable Supreme Court does is, yes, this denial of monetary benefit, such as to ensure complete justice, it has been directed. 142 applies. I can't say this is maintainable, but we'll say that they subject themselves to the risk of default in the event the appeal succeeds.
But in my application, there are other scope also, my lord. The first direction is this regarding the occupation charges with regard to, my lord, the present market rate.
The interpretation on that, yes.
Apart from that, my lord, if your lordship kindly takes up paragraph 9 of my application, my lord, I have also sought for a direction to make further payment of the amount of the last paid rent, less the amount, if any, deposited in the trial court. That I am entitled
That
to.
is consequential to the first.
But that was
If a parent
142.
relief is not granted, then same. They are subjecting themselves to default ground. What else can we say?
Second default.
So happy about it.
Happy about it. You should be
You
happy.
also happy about it.
Yes, my
In
lord.
the world. Just wait till the appeal is allowed. Then see what happens to your client. You are taking a risk.
Well, in paragraph 10, I have also sought for a direction to continue. That is, of course, my lord, covered.
Sir, can you look into the paragraphs? It is premised on that main
Yes,
prayer.
yes, I understand, my lord.
Sorry, Mr. Chairman. Paper books and all directions are given otherwise.
Yes.
If the records have come.
But that I have to ascertain.
The present application
Record
is,
has come. I am told record has.
so then whenever the notice is served, you prepare the paper books and
Very good.
before the next unfortunate bench which takes up first appeals you mentioned for inclusion in the list of the hearing. The present application has been filed by the landlord in an appeal preferred against the dismissal of the appellant stroke landlord's eviction suit. Full up, the prayer of the appellants is that during pendency of the appeal, the respondent tenant be directed to put in occupation charges at the current market rate. Full sub next para, learned counsel for the appellants cites such and such reported at 2024-8 SCC 668 for the proposition that even if the appeal is against the dismissal of an eviction suit and the prayer made for occupation charges is not in connection with a stay awarded in that respect, the court is competent to direct the tenant to pay occupation charges at the present market rate. Full stop. Next para. Learned counsel for the respondent opposes such prayer. Full stop. Next para. Upon a perusal of the judgment rendered in Vijay Kumar Manish Kumar Supra, we find that the Honorable Supreme Court, in paragraph number 28 of the judgment, took specific note of the question raised by the respondent therein, that since no eviction decree was passed and no stay was awarded, the question of payment of occupation charges does not arise. Full stop. However, while directing payments to be made at the current market rates, the Honorable Supreme Court, in paragraph number 31 of the report, ends with the phrase to ensure complete justice inter se the parties, close, thereby clearly indicating that the directions in the said judgment were passed within the contemplation of Article 142 of the Constitution of India, to do complete justice between the parties. Full stop. Next para. The issue raised in the said case was not conclusively decided throughout the judgment. Full stop. Next para. Thus, it cannot be said that the said judgment is a binding precedent under Article 141 of the Constitution of India for the proposition that even in a suit filed by the landlord against the dismissal of its eviction suit, the court, as a general norm, can direct occupation charges to be paid at the current rate. Full stop. Next para. Occupation, there are a plethora of judgments directing occupation charges to be paid, but as a condition for stay within the contemplation of Order 41, Rule 5 of the Code of Civil Procedure, in a case where the appellant tenant suffers from an eviction decree and seeks a stay of the same. Full stop. Next para. Since such paradigm is not applicable in the present context, and we do not find any conclusive proposition of law in that regard having been laid down in Vijay Kumar Manish Kumar Supra, we are unable to accede to the contention of the appellants stroke landlords in that regard. Full stop. In our opinion, in our humble opinion, there is no scope, in a suit, in an appeal of the present nature, to direct the respondents to pay occupation charges, since such a direction would not be covered by any principle or provision of law. Full stop. Is in any event, comma, in any event, comma, in the event the appeal succeeds, comma, the respondent tenant shall expose itself to the risk of being a defaulter in payment of rent, even for the period of pendency of this appeal. Full stop. Be that as it may, comma, in view of the above observations, comma, can 3 of 2026 is dismissed without any orders to costs. Full stop. This much, because those directions are already there. Next.
But the appeal is otherwise ready for hearing.
We are not touching that issue. That is one issue we don't want to decide.
Lordship, one indulgence, Lordship. In item number 14, Mr. Nilanjan Bhattacharya is engaged in this matter, Lordship.
No, he was not there. We won't put his name.
Lordship, kindly restore the matter.
No. Next matter.
And
Yes.
for the appellant, can 2 Millard is application under section 5 Millard. First time, let me serve and come.
The appellant shall serve copies of Can 2 of 2020.
Can 2 of 2025.
2025 on the respondents, indicating that the application shall be listed in the monthly list of August 2026 when an affidavit of service to that effect shall be filed by the applicant.
Millard, here, Millard, I appear for the respondent. I have filed an application. Can 1 Can 2 Millard of 2026. Millard, this is Millard for vacating the interim order.
Why 2 appeals?
Millard, one from Millard counterclaim and another from dismissal of the suit.
Your suit for eviction?
Yeah, my suit for eviction decreed, and their suit, Millard, for declaration of their counterclaim for declaration of tenancy right dismissed.
So what order was passed?
Millard, kindly
stay order without any occupation charge?
No. Stay order, occupation charge, they are complying. If your lordship would kind enough to, Millard, kindly see the order dated, Millard, 4th March 2025. Kindly see, Millard, page 5 of the order.
Page 5 of the order, yes.
Kindly see, Millard, paragraph 16. In view of the appearance of the respondents through their learned advocate, service of notice of appeal of the respondents is dispensed with. The trial court record shall be brought for by way of special messenger at the cost of the appellant to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records or on the learned advocate for the appellant. Now, Millard, lordship would kind enough to come to, Millard, the order dated 3rd November 2025 passed by the Register Administration.
Yes.
Now, Millard, kindly see the first, Millard, paragraph. Learned advocate Pradeep Kumar Boshak appears for the appellant. Superintendent FA section has submitted a report, and in the said report it is mentioned that on examination of the TCR of title suit number 856 of 2001 received from the Assistant Registrar City Civil Court Calcutta, it was found that the TCR has the following defects. Then, Millard, kindly see the 3 defects are mentioned, 1, 2 and 3. Then, Millard, kindly see the next paragraph. Considering the nature of the defect, there is no alternative but to send the TCR to the title suit number of 856 of 20 to the learned trial court for necessary rectification. Department is directed to do the needful in this regard, and the trial court is requested to retransmit the TCR for after removing the defects within 2 weeks from the date of receipt. Well, we have taken specific, Millard, information from the department. This has also arrived, Millard, in, Millard, February 2026. Millard, still date they have not, Millard, prepared paper book. But although, Millard,
you also did not file Vakalatnama administrative notice had to be issued.
That is done, Millard.
You are also at fault.
I am also at fault.
No, but we don't know whether notice has been served by the office after arrival.
Millard,
to direct the office to serve immediately, we are disposing of this application. No vacating. Direct the office to immediately serve notice if the records have arrived, and them to comply with the previous direction of preparation of paperwork. In default, you will be at liberty to mention the matter.
Or in default, it will be put up in Logima, Millard.
Very well, we'll do that. Yes, we'll do that. By an order dated, have you served a copy of this vacating? We are not allowing this so. By an order dated March 4, 2025, comma, an order of stay of the impugned eviction decree and the connected execution case, comma, if any, was granted till disposal of the appeal, comma, subject to the appellant stroke judgment debtor depositing occupation charges as directed in the said order. Full sub next para. The respondent stroke present applicants submit that subsequent to the said order, comma, the trial court records were sent down to effect necessary rectification of defects as pointed out in the order of the registrar administration within bracket L and OM bracket closed dated November 3, 2025. Full stop. Learned counsel for the respondent submits that even after such defects being cured and the records having since returned to this court, comma, no paper books have been prepared by the appellant, comma, thereby rendering the appellant a defaulter in terms of the order dated March 4, 2025. Full stop. However, comma, we do not find anything on record to indicate that after the records were retransmitted from the trial court to this court, post rectification of defects, comma, any further notice was given in that regard to the learned advocate for the appellant. Full stop. Next para. Hence, comma, there is no scope of vacating the order on such ground, comma, since it is fairly submitted by the respondents that the occupation charges are otherwise being paid by the appellant. Full stop. Next para. Accordingly, can 2 of 2026 is disposed of with a direction on the concerned department of this court to immediately send a notice of arrival of the trial court records after rectification, comma, if the trial court records have actually arrived, comma, full stop. Upon such notice being served, comma, the appellants shall, comma, within 8 weeks thereafter, comma, prepare the paper books in terms of the order dated March 4, 2025. Full stop. In default, comma, the matter be placed in the list under the heading Lozima for final orders. No other order is to costs.
Okay. Oh, yeah.
Number 20, and I appear for the respondent.
All the affidavit reply in connection with by the way, signature of forging the signature of the
opposition and reply.
Yes. Forging the signature of the appellant number one, my lord, the judgment and decree was expert. My lord, the was obtained expertise. And my lord, the on 19/11/2020.
So you say you are never aware of the judgment and decree. No. What is the nature of the decree?
Eviction. The eviction. Eviction of trespasser and possession.
So what is the delay?
Delay, my lord, the was 30 days, but the practically there is no delay. But we came to know the opposite fact on, my lord, the on 19th.
Their opposition, what is their stand?
They only stated that we have not sufficiently displayed disclosed the. But the facts remains, my lord, the paragraph 12 and 13 specifically till 19/11, my lord, we came to know. 20th, my lord, we went to the police station about the fraud, my lord, we are in totally dark. We went to the police station to move before the honorable court.
According to you, how did you first come to know of this?
On, my lord, the 19/11, my lord, we came to know.
How?
My lord, the over phone, some persons assembled in front of my tenanted room. Then, my lord, that time the appellant number one was in phone number, he came returned. He went to the police station. And my lord, he was on 20th morning, he was mercilessly beat up, he was admitted.
Signature of appellant number 1 was forged.
1 was forged.
What about 2 and 3?
2 and 3, my lord, the no summons were issued, their name was changed, my lord, the name was mentioned in the.
Let us see the decree once, whether it was passed expert against them. No, expert against all the defendants. Regarding them, your submission is that no summons were served.
No. The name was different.
Name was different. Raghunath Chaudhary, Polu Chaudhary, Monu and Tablu. So, Bablu was mentioned at Tablu, but Monu Chaudhary's name is correct. And what about Polu Chaudhary? He is not even a party here. Polu Chaudhary. Not implemented him. This appeal is bad for non-joiner.
Appeal, my lord, the
Polu Chaudhary is not a party here. He was a
in
party
the
in the
appeal, my lord, he was added as a party. Pro forma.
Acha. But in this application, he is not there. So that we can grant you leave to carry out, add his name in the cause title. In the memorandum, he is a party.
No, is a party.
Let us see.
Memorandum is a party.
Oh, it was added subsequently. All right. But Monu Chaudhary's name was correct. Summons was not served. There must have been a finding in the trial court that summons was served.
In the judgment, I have gone through, my lord, the learned judge was told that the summons was served, but practically no summons was served.
Yes, Mr. Bhattacharya, what do you say?
Milord, regarding name, Milord, kindly see, Milord, my learned friend had, Milord, filed an application under Order 21, Rule 99, 100, 101 in connection with the execution case. Milord, I do not, Milord, find any change of name, Milord, what they say. If your lordship would once.
Order 20 Rule 97 to 101, how they were judgment debtors.
Milord, this is
That's
the
wrong. There is a.
This is
So that was.
They hurriedly they have filed. They
So
don't
that
have-
was also dismissed.
pending.
So that is pending. Lord.
Milord, kindly see, Milord, this is the. Milord, I could not find any name change of name.
Yes, they're the same names are there as applicants. In your Order 20 Rule 97 to 101, your names feature as Bablu Chaudhary and Bablu is W. Yes, Monu Chaudhary is same.
Monu Chaudhary is same.
No, but Mr. Bhattacharya, but then there, your learned friend's case is that as far as Monu is concerned, no summons was served.
Kindly,
The Bablu W confusion.
kindly appreciate. Milord, if this is the confusion, this cannot be subject to correction by lordship, decided in appeal. My learned friend should have, Milord, filed an application under Order 9, Rule 13 because this evidence is required. Milord, one. Number two, I don't say, Milord, appeal is not maintainable, but here in this, the facts of this case, Milord, Order 9, Rule 13 was was the appropriate remedy because evidence is required. One. Number two, if your lordship would kind enough to see, Milord, paragraph, page 5, para 9 of the application, Milord, how do, Milord, they come to know, Milord, there is no such statement. And paragraph, kindly see paragraph 9 and 10.
No, para 6. Someone informed them over mobile phone on such and such dates. People have assembled in front of the tenancy room, colorable persons, etc. Break open the padlock and all.
There was someone, Milord, that is also, Milord, and Milord, kindly see, Milord, page 6, Milord, para 10. They say the petitioner state the appellants do not know where the city civil court is situated and the appellants never approached any advocate on the two defendants have said, but they are filing, Milord, application under Order 21, Rule 99, 100, 101 before the city civil court.
Subsequent to the degree.
After that, they
after that they filed they appeal as well as the auditor. That is not a good ground which you are taking now. It only happened post facto as per them.
They came to know, Milord, the city civil court after the decree.
No, they then not. Why appellant number 1? Appellant number 1 is illiterate. There is no proper explanation of the other appellants.
The other appellants, no summons was served.
Monu Chaudhary, we don't find any explanation. He remains Monu Chaudhary.
And Milord, regarding appellant number 2 and 3, my learned friends, the contention is non-service of summons. Milord, that is also has to be looked into in evidence.
It's not true, you are right, but
we are at section 5 stage.
Section 5, we cannot decide that conclusively either way. We can allow the section 5, keeping this question open in the appeal. You will record your submissions.
Milord, also, Milord, they have filed Milord, police in action, writ petition, Milord. This is what the statement they don't know. City civil court, Milord, they are taking advantage, Milord, everywhere they are going and taking.
They may be from this side of the border. So
only this side.
If they were from the other side, then they wouldn't have been. It wouldn't have been required to identify High Court to them.
And
so they are in totally dark.
How the Bengal is saying we lend credence to that.
Milord, if your lordship would kind enough to see, Milord, page.
But this is not High Court. This is City Civil.
This is City Civil Court.
Proverb is High Court.
But there is, Milord, one, Milord.
No, the proverb relates to High Court, not City Civil.
Milord, kindly see, Milord, page 12. My lord, there is also an observation of the Honorable Single Judge. If your Lordship would kind enough to come to, my lord, the second page of the order, page 3, my lord, this paragraph starts with "be that as it may."
Yes.
Since the case has already been registered, grievance of the petitioner so far as issues relating forgery of summons and the manipulation of the be brought to the notice of the
Yes, yes, no doubt that will be
investigating officer. Then, my lord,
criminal trial will proceed separately. Not only that, you are right. Even if the criminal trial succeeds, they have to independently prove it in the this appeal. Your learned friend should know what he has to do, what application he has to file.
kindly appreciate.
They have not asked for any local inspection here. Sorry, any expert or anything.
Yes, yes, that order was passed by the Honorable Court.
In this court?
One of the Reach Court.
No, in connection with the appeal also independently you have to prove that your signature was forged. So neither you preferred any application before the trial court, there was no scope.
Yeah.
Here you should have taken out an application and order for 27 seeking for that expert. We have advised you sufficiently, please do that.
I will take out the application, but with this.
And Mr. Bhattacharya will help you draft it. Affidavits in opposition and reply filed today be kept on record. Push up. The delay in preferring the appeal has been sought to be explained by the appellant by relying on the alleged forgery committed in the trial court to the extent that the appellants, being unaware of even the situation of the city civil court, where the impugned judgment and degree were passed, and having no knowledge about the subsistence of the suit, did not appear in the same at any point of time. Push-up learned counsel for the appellant submits that the signature of the appellants were forged in the trial court. Push-up. It is also pointed out that a criminal complaint was lodged in that regard, which is undergoing investigation.
Investigation?
Charge sheet, no. Charge sheet file?
No.
Undergoing investigation. Push-up.
Order to the seizure of signatures is also passed. Reply.
Next para.
In reply, my lord, at page 9, I have disclosed it.
Upon subsequently coming to know that certain people had assembled before the suit premises, the appellants took information and learnt about the expert degree being passed, upon which the present appeal has been preferred. Next para, learned counsel for the respondents opposes the prayer for condonation of delay and hands over a copy. You have to hand over a copy.
Immediately make a photocopy.
And hands over a copy of an application under Order 21 Rules 97 to 101 of the Code of Civil Procedure filed by the self-same appellants, where the names of the appellants have been mentioned identical to that in the present appeal. So it is pointed out that insofar as appellant number 3 Manu Chaudhary is concerned, the argument of the appellants that the names of the appellants were incorrectly mentioned in the plaint and summons were not served on them accordingly, cannot hold true, since the name of the appellant number 3 appears as Manu Chaudhary in the present appeal, in the application under Order 21 Rules 97 to 101, as well as the trial court's decree. Next para. Furthermore, learned counsel argues that the appropriate remedy of the appellants might have been to take out an application under Order 9 Rule 13 of the Code in order to lead evidence on the allegation of forgery, which would give an opportunity to the respondents to meet the same. However, the appeal is not the appropriate remedy in that regard, particularly since no such relief has been sought in the appeal. Next para. However, from a perusal of the materials before us, we find that one of the grounds in the appeal is the alleged forgery committed insofar as the erroneous, insofar as the signatures of the appellants in the Wakalatnamas in the trial court having been allegedly forged, and the names of some of the appellants having been incorrectly mentioned in the plaint, which purportedly led to summons being sent at the wrong address. Next para. Learned counsel for the respondents is justified in arguing that unless an appropriate application seeking expert is made by the appellants in the appeal, this issue cannot be conclusively decided. Full stop. However, comma, at the stage of deciding the condonation application, comma, there is no scope for the court to enter into the details and decide such issue of forgery and erroneous mention of names conclusively. Full stop. The same will be decided in the appeal and are being accordingly kept open for being so decided, comma, subject of course to the appellants making appropriate applications seeking to prove the allegation of forgery. Full stop. Next para. However, comma, insofar as the application under Section 5 is concerned, Section 5 of the Limitation Act is concerned, comma, a sufficiently strong prima facie case has been made out in order to condone the delay in preferring the appeal. Full stop. Accordingly, can 1 of 2025 is allowed on contest, thereby condoning the delay in preferring FAT 01 of 2025. Full stop. The said appeal stands hereby registered and admitted. Full stop. There will be no orders to cost. Full stop. We, however, reiterate that the question of alleged forgery and erroneous names of the appellants being mentioned in the trial court is kept open for being decided in the appeal, comma, subject to appropriate steps being taken by the appellants therein. You hand over a copy of this. As an appeal, you are appealing for all the respondents.
All the respondents.
In view of the appearance of the respondents through their learned advocate, comma, service of notice of the appeal on the respondents is dispensed with and the appeal be treated to be ready as regards service. The trial court record shall be brought by special messenger at the cost of the appellants, comma, to be deposited within a week from date. First of the appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records at the time of final hearing. Trial court records. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Yes.
21, Your Lordship, for the appellant.
Yes, for this
Lordship,
application.
Against the, my lord, money.
Let them move the application. Yes.
Your Lordship, I have received the exhibits of the plaintiff on the last week on
Stay of execution of money decree.
Yes.
Execution case.
Your Lordship, I need 1 week time to prepare the paper book. Your Lordship, I have received the exhibits.
No,
on
you are
the
not
last-
pressing this application.
No, I'm pressing this application.
Then you put in the deposit. The decretal amount you have to put in.
Your Lordship, kindly take it up in the next week.
No, no adjournment.
Your Lordship,
Will grant stay Mr. Poddar for a limited period, subject to their putting in the decretal amount. If they don't put in, default clause will be there. It will stand with it.
My lord, my lord.
Usual, Lord.
Yes, yes. My lord, see, my lord, since my lord last day and today, there are 1 month, my lord, elapsed. My lord, no development taken place. At the insistence of the learned advocate for the, my lord, appellant, Mr. Mahato, who, my lord, insisted to prepare paper book and sought a hearing, full-fledged hearing. My lord, though he, my lord, prepared paper book, but which is bereft of written statement, which was his document, to challenge my limitation. My lord, though, my lord, in my claim, the and cause of action, my lord, there was no challenge. Contrary, in written statement, they admitted not only the claim.
No, that we understand. But if they have not put in the
Yes.
written statement, then why didn't you put in the written statement?
Your Lordship, it was fixed for hearing. That's why Your Lordship, Your Lordship, the
The statement
exhibits.
is not required to be put in the informal paper books.
No, Your Lordship, but
No, either you press this application or you put it out of the list.
We served copy of the written statement to them since 1 month back. We don't require a written statement because it is with us.
Your Lordship, the exhibits of the plaintiff was required.
No, we have recorded that neither the written statement nor all the evidence are part of the paper.
Yes.
The exhibits were required, Your Lordship, but it was handed over by them on last week on
Oh,
June
we had
15th.
directed those omitted documents to be handed over.
Yes. We, my lord, hand it up, my lord.
So move the appeal then.
Appeal, Your Lordship, the paper book is not ready, Your Lordship. That is why.
Paper book was prepared only. No,
The
what are you saying?
exhibits only.
Yes, paper book is there.
No, what are you saying? On the last occasion, our order says
We
learned
prepared-
counsel for the appellant submits that the paper books have been prepared with relevant documents.
written statement.
However, we find that written statement or evidence, not all the evidence was part of the paper book.
Yes, Your Lordship.
We requested the respondent to furnish copies of those omitted documents to you.
We have done.
We have, they
Which has
have
been
done
done.
it.
So we were ready to hear the appeal on those documents.
Yes, Your Lordship, but it was handed over on last week on Wednesday. So I
The
could not
last week
prepare.
Wednesday is 1 week back. I mean, several days back.
Your
If you're
lordship,
not prepared, then you're not prepared.
your lordship, we could not prepare the paper book in the just 1
Then
week
it
time.
goes
your
out of the
lordship.
list. No. No further paper book is required to be prepared. You had already prepared.
Yes, your lordship, but we have to annex it together.
No, we did not direct you. We directed only copies to be exchanged and we'll hear on that.
My lord.
An adjournment is sought by the appellant on the specious plea that paper books have not yet been prepared by the appellant. However, learned counsel for the respondent rightly points out that on the request of the appellant for the appeal itself to be heard out, vide order dated June 23, 2026, we had recorded that paper books had already been prepared but was bereft of the copies of the written statement and all the evidence, due to which we requested the learned advocate for the respondent to furnish copies of those omitted documents to the learned advocate for the appellant, which, we are informed, has already been done. Full stop. Hence, there cannot be any impediment in hearing out the appeal along with the application. Full stop. Next para. It may be noted here that the present appeal has been preferred against a money decree, and it appears that the appellant is delaying the matter indefinitely. Full stop. Next para. Since the appellant is not interested to argue the appeal, let the application go out of the list for the present. Full stop. We make it clear that no interim orders have been passed in respect of the connected execution case. Next. Yes, Mr. Banerjee, you are for the appellant.
The respondent.
Oh, it was recorded in the reverse order, the last order.
In this application, I'm for the respondent.
No.
My appeal is conditional stay upon payment of money. They've taken out an application because we've not paid that money. Now they're not here. It'd be prudent on my part to not do anything. Then
they're not enjoying any stay.
I am enjoying a stay. Decree against me.
We put it out of the list. None appears to move. Can 3?
And 3, 4. 4.
4 is appearing in the list today. None appears to move can 4 of 2026, which is an application by the respondent in the appeal. Respondents in the appeal. Although the appellant is represented through counsel. Full stop. Accordingly, let the matter go out of the list.
May I please, Your Lordship? This is first appeal, but there is a section 5 application. There is some delay.
Sorry, this is against an appeal, against a decree.
And decree, my lord, dismissing the suit.
Your suit for?
Suit for, my lord, recovery of possession.
On the ground that they are trespassers?
Because there was a lease.
What is the delay?
30 days delay, my lord.
30 days. You have served. Did you direct for the first time?
First time.
The appellant shall serve copies of Can 1 of 2025 on the respondents, indicating that the application shall be listed in the monthly list of August 2026 when an affidavit of service shall be filed by the appellant to that effect.
I'm grateful.
Sir. At the time of hearing this, we will pass the other directions regarding the appeal. Next.
Number 24. I appear for the appellant.
Yes.
Lord, this is my suit, my lord, has been dismissed on a preliminary.
One defect was the classification of the appeal. Have you corrected? Let's check up.
Original decree.
My lord,
yes, removed.
Yes.
Original order. This is from original order.
Yes, on a point of maintainability, my lord, formal decree was never drawn up.
No, but then it should be decree. Decree drawn up, not drawn up does not.
I have classified this memorandum for appeal from original decree. Right. This is my application.
What is the decree? I mean, your suit.
My suit. What? Milord, for a declaration that I am the 16 owner, permanent injunction. Milord, mandatory. Yes, Milord. Two things, Milord. If your lordship have annexed, Milord, the bunch of certified copies. If your lordship would kind enough to first see the Milord 13th June 2022 order, from the memorandum of appeal.
What is your point? Just tell us.
Milord, court, Milord, picks the point of maintainability. Next order says, Milord, no, this cannot be decided. It will be after full-fledged trial. Then, Milord, then the point of maintainability was decided in this order. Then again, Milord, suo motu taken up the point of maintainability and decided against me.
Not decided by this order. The direct to be decided at the trial.
Full-fledged trial. Then again, point
Again, before the trial, it was decided without evidence. Anyway, we are allowing can 1. It's for expeditious hearing.
Expeditious hearing, Milord, not required. Milord, paper books, Milord, I'm serving and coming back, Milord. Plain written statement, all are here.
But the notice of the appeal has to be served.
Or if they appear, Milord.
This application was directed to be served.
First time.
Will directed to serve. We want that.
Let them come and, Milord.
Then counsel for the appellant submits that although the present application is for expeditious hearing, comma, if a copy of the same be directed to be served on the respondents and the respondents appear in connection with the application, comma, service on the respondents may be dispensed with and the appeal may be expedited. Full sub next para accordingly on the prayer of the appellants, comma, we direct copies of can 1 of 25 to be served on the respondents, indicating that the application shall be listed for hearing in the monthly list of August 2026, when an affidavit of service to that effect shall be filed by them.
Along with the memorandum of appeal.
Achha. Serve a copy of can such and such along with a copy of the memorandum of appeal.
Great.
Next.
I'm appearing on behalf of the appellant, my lord. This is the copy of the rejoined, my lord.
Last
In
officer, my lord,
respect of-
was pleased to direct me to file, my lord, supplementary affidavit stating that the area of the flat, my lord, along with other things.
Eviction degree.
Eviction degree.
Yes, my lord.
Eviction of tenant.
License. My lord.
So you have filed your opposition?
Yes, yes.
What opposition?
Item number 25, my lord, eviction of a licensee and
why supplemented affidavit by that?
My lord, supplementary affidavit, my lord.
You had already filed an opposition?
Yes.
Yes, yes.
Previously you had filed an opposition?
My lord, I filed opposition, my lord, for the occupational charge. My lord asked me to what is the area of the my lord, occupied area. My lord,
And you have filed a rejoinder to that also.
my lord, page 4, my lord, of my supplementary.
But this is the price of the property for sale.
Yes.
This is not for occupation charge. This is the
No, my lord,
valuation for the purpose of sale.
My lord, page
We wanted you to put something to show other rent receipts or something. Market rent is not equivalent to market price. So this is not a good indicator. Where is the area? Where is the location?
Location, my lord.
Batra police station, my lord. Batra Kodamtala, Howrah.
Lord, prime location, my lord.
Still, we don't have anything. You have not annexed anything.
Page 6, my lord. I stated.
That is 2 BHK category consisting 2 bedrooms. Which floor?
That's first floor, my lord.
35.
Area? What is the area?
Area, my lord, I have stated, my lord, the area is, my lord, 543 square feet.
Where have you stated?
My lord, page 4.
Yes. 543, what is stated? Where is that?
Similar in my.
Yes, thank you. What was the last licensee? Licensee without license fee?
Yes, my lord. My case is that, my lord, initially the appellant was a tenant under the predecessor of the present opposite parties, my lord. My lord, subsequently, they became the tenant under the present.
They produced rent receipts before the trial court?
Yes, my lord. The last rent was, my lord.
Did you produce rent receipts before the trial court?
Yes, my lord, I have produced. My lord,
you have produced, then why was the suit decreed?
My lord, my second case is, my lord, the appellant also filed a suit for specific performance of contract.
That does not give you a present right to stay in the property. That's an actionable claim. So you did not produce any rent receipt?
Rent receipt? Yes, my lord.
Yes, my lord. Let us see from the impugned judgment. If you find that you did not produce, we'll dismiss the appeal right now. If you produce rent receipts, then how could you be held to be a licensee? It's a registered agreement.
Yes, my lord, registered agreement.
Registered agreement for sale.
Agreement for sale.
So your defense was under 53A of the Transport Property Act.
Yes.
According to you, Mr. Sheth, what should be the occupation charge? You have given anything in your rejoinder?
My lord, according to me, my lord, occupational charge to 2,500 to 3,000.
You have given anything in your rejoinder? You have produced any material in support of? Have you stated that in your rejoinder? Or you are submitting from the bar?
Building is, my lord, 35.
No, but we cannot rely on this, Mr. Das. We cannot rely on your market value to arrive at the occupation charge.
My lord, I have stated the where the property is situated, when the prime location, my lord.
What landmark is there nearby?
In my opposition, my lord, I have stated paragraph 9.
In your opposition?
Yes, my lord.
Or your supplementary opposition?
Opposition, my lord.
Paragraph 9.
Paragraph 9, my lord, I state that the suit property is situated in a prime locality of Howrah city, the Berelias Road, which is famous for its engineering jobs.
No, para 9 of the opposition.
Yes, my lord. In my opposition, my lord.
Yes, opposition. Para 9 is something else.
FA 211.
Why 2 appeals?
2 appeals, my lord. There are 2 suits, my lord. One suit filed by my client for suit for eviction, 2006. And after 2 years, they filed a suit for specific performance. But my suit digged it, their suit dismissed, challenging that the both are 2 appeals preferred. In FA number 211 of 2025, paragraph 9. My opposition.
oppositionটা কোথায়? সব একসঙ্গে করে ফেলেছে। সব একসঙ্গে হয়ে গেছে। এখানে সাপ্লিমেন্টারি এখানে আছে নাকি? এই অপোজিশনটা বলছি। সব জুড়ে দিয়েছে, এটা মুশকিল হয়ে গেছে না? এর সঙ্গে জোড়া রয়েছে তো। আচ্ছা না, এটা আলাদা। 11 para 9.
Paragraph 9. But I state that the property.
Yes, famous for its engineering job.
Engineering job area is distance about 350 meters.
Railway station এর কাছে বলছি।
Soilen Manna Soroni East West bypass distance about 300 meter. Tikapara railway station distance about 500 meter. Howrah Moidan Metro Railway Station, Howrah Court, Howrah Hospital, Howrah GPO.
500 meter within those?
Yes, my lord. It is to ward number 22 of the Howrah Municipal Corporation.
No, you have stated Tikapara Railway about 500 meter.
Yes.
Howrah Moidan Metro Railway, those are 2.5 kilometer.
Yes.
2.5 kilometer is quite some distance.
It's
2.5 kilometer is quite some distance. To travel 2.5 kilometer in Howrah, it takes some time.
Within 1 kilometer walking.
You'll cover half of Howrah to reach that place. The Howrah, the proper Howrah, the town.
10 minutes to its take by bus.
First floor, 543 square feet. কত হওয়া উচিত আপনি ঠিক করুন।
35 years old building.
Leave the premises. Leave the premises. The test is how much they can fetch, how much that property can fetch now if they sell, rent it out to someone else.
For purchase the said property already, I have paid the amount, my lord.
Did you file a suit for specific performance of contract?
Yes, that should be.
That is the other suit.
Other suit.
That was dismissed. Why dismissed?
This means, my lord,
He has
according
not
to
complied
the
our agreement. He has not.
How has he not complied?
It is stated in this order, my lord.
You have not read the order. We'll read it for you. Let us do it. Same judgment, common judgment.
common judgment. Page number 10 of the judgment, my lord. Sorry.
Readiness, willingness, or why was it dismissed?
Page number 13, paragraph number 8. On perusal of the exhibit number 1, got it, my lord?
Got it.
Paragraph number 8. On perusal of the exhibit number 1, the agreement
No evidence of complete payment within stipulated time. Time was extended, you did not pay. What is the balance amount to be paid? What is the total consideration?
Total consideration, my lord, 3,30,000.
3,50,000. Page 14, second line.
My lord, thereafter the plaintiff enhanced the rate and already plaintiff paid 4,77,000.
What was the rent? Enhanced rent? Page 14, you have stated that plaintiff alleged that he had made further payment of rupees such and such, that is rupees 35,000 for rent consideration. 35,000 for 1 month.
No, my lord.
He is residing there since 2005, paying nothing.
2 BHK,
This was
5
released
square
by-
feet.
Plaintiff paid total 4,77,000.
Reasonable. You are making 12,000 per month.
Fine. Consider, my lord.
The present appeals arise respectively
yes.
out of a decree of eviction of licensee granted against the appellant and the dismissal of the appellant's suit for specific performance of a registered agreement for sale of the self-same property. Full stop. The specific performance suit was dismissed primarily on the ground that the balance consideration was not paid by the appellant within time. Full stop. Since the premise of the defense in the eviction suit was section 53 capital A of the Transfer Property Act, and in view of the specific performance suit having been dismissed, the eviction suit was also decreed. Full stop. Next para, by the present application, stay of the impugned eviction decree has been sought. Full stop. Next para, learned counsel for the supplementary affidavit and rejoinder filed by the respondent and the appellant respectively are kept on record. Full stop. The respondent, in the supplementary affidavit, has annexed documents to show the market price of the property, which is entirely different from the market rent. Full stop. Next para, be that as it may, we take into consideration the location of the suit premises, as evident from the affidavit in opposition filed by the respondent in Can 1 of 2025 in connection with FA number 211 of 2025, from which it transpires that the suit property is situated in a prime locality of Howrah, is about 350 meters from Belilius Road, about 300 meters from Shoilen Manna Sorani stroke east-west bypass, and about 500 meters from the Tikiapara railway station. Full stop. It is also about 2.5 kilometers away from important landmarks of Howrah, such as the Howrah Moidan, Metro Railway Station, Howrah Court, Howrah Hospital, GPO, Howrah GPO, Collectorate Building, etc. Full stop. Next para. The suit premises is of about 543 square feet, situated on the first floor of a building comprised of a 2 BHK flat. Full stop. Learned counsel for the appellant argues that the building is about 35 years old. Full stop. Taking into consideration all such ingredients, comma, we come to the ballpark figure of rupees 12,000, which according to us would be an appropriate monthly occupation charge for the said premises. Full stop. Accordingly, comma, can 1 of 2025 in FA 211 of 2025 is disposed of by granting stay of operation of the impugned decree of eviction and or any execution case if levied in respect thereof till disposal of the appeal, subject to the appellant going on depositing occupation charges to the respondent at the rate of rupees 12,000 per month. Full stop. The first of such current installments shall begin from the month of August 2026, comma, to be paid by the end of the said month and thereafter by the end of each successive month for every current month. Full stop. Next para, the arrears of occupation charges for the period between passing of the impugned decree and July 2026 shall be paid in 4 equal monthly installments, comma, payable by the last day, the first of which shall be payable by the last day of August 2026 and thereafter the rest of the installments by the end of each succeeding month. Full stop. Next para, subject to the first such payments being made within August 31, 2026, comma, the stay order shall continue till disposal of the appeal. Full stop. In default of payment of any of these aforesaid amounts, comma, however, comma, the stay order shall stand automatically vacated without further reference to the court. Full stop. Next para, in view of the appearance of the respondent or for all the respondents of the respondents to their learned advocate, comma, service of notice of the appeals is dispensed with and the appeals be treated to be ready as regards service. Full stop. Composite paper books in respect of both the appeals shall be prepared by the appellants within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant.
Order was there.
Already.
Yes.
Oh, achha, these orders were there previously.
Yes, my lord. Already I have deposited the special messenger.
Paperbook direction was also there.
Yes.
The appellant shall prepare paperwork. The appellant shall adhere to the timelines earlier fixed for preparation of paperbooks.
My lord, may I submit one thing, my lord? My lord, if your lordship kindly direct the appellant, my lord, to deposit the occupational charge before the learned register, my lord, because of that, my lord, specific performance.
No, directly to him. Occupation charges in any event till the specific performance suit is, you have not asked for, your suit has been dismissed. You have got any bank account which fund is that? একটা লাইন অ্যাড করে দিও তো ওই সবকিছু শেষে cost no order as to cost আগে. The aforesaid payment shall be made to the bank account of the designated bank account of the respondents, comma, the particulars of which the particulars of which shall be communicated in writing within a week from date by the learned advocate on record for the respondents to his counterpart appearing for the appellant. Full stop.
My lord, may I be excuse me for mentioning the order.
But that order we have already passed.
No, my lord, the order was passed earlier.
We are not reopening that.
My lord, earlier order
Item number 27, Mr. Rajiv Bhattacharya is one of the appellant, Lordship. He is in hospitalized, Lordship, due to his abdominal pain in Peerless Hospital. I'm paying for only not this week, Lordship.
The application is for only for substitution.
Oh, you can move the application.
But, Lordship, I'm not in brief.
On the prayer of the appellants, the matter is adjourned till July 27, 2026. Give your appearances. Your own appearance, obvious. Yes.
I appear for the appellant, my lord. Chatterjee is leading me, my lord.
I have instructions to appear on behalf of the respondents.
Then, my lord, I will serve all the applications to my learned senior friend. And
Oh, so not yet served.
first time.
Very good. So your costs are saved.
Yes.
His costs are saved.
The delay of more than 4,854 days.
Only 4,000.
No, we will explain that.
It's a checkered
Checkered history, my lord, several.
No, only we said sarcastically.
Yes, well, order 9, rule 13, along with section 5. Section 5 dismissed, automatically order 9, rule 13 goes. Now, my lord, prefer an appeal, first instance appeal before this honorable court. Your lordships, my lord, dismiss the appeal. Then SLP preferred. SLP dismissed. Then review preferred. Review dismissed. Then, my lord, against the final order of ex parte degree, an appeal has been now preferred with the delay of 4,854.
So you lodge a caveat before you pass our order. Before they have.
Mr.
Anyway.
Chatterjee is perhaps there in the virtual mode.
Huh?
Mr. Chatterjee is leading me, my lord.
Mr. Chatterjee, which Mr. Anindya Chatterjee?
Nee.
So very well, yes. Since Mr. Debashish Roy, senior advocate, submits that he has instruction to appear through his learned advocate on record on behalf of the respondents, the appellant shall serve copies of Can 1 of 2025 and Can 2 of 2025.
No, 1 to 5.
Can 1 to 5?
Can
all of 25. So সব কটা আলাদা Can 1 of 2025, Can 2 1 থেকে 5 পর্যন্ত of 2025. On the learned advocate on record appearing with Mr. Roy during the course of the day, the matter shall be listed on July 27, 2026 for hearing of the applications.
By tomorrow, can it be by service by tomorrow?
By during the course of the day, na kore by tomorrow.
27.
So great.
This is coming for the first time, my lord.
And may I file an affidavit in opposition against the...
You've got a copy?
Yes, my lord. The copy has been served.
But erroneously, my advocate on record has served.
See, your purpose is served also. This is an application for stay.
Yes, my lord, permanent.
This is, my lord, nature of the suit is, my lord, suit for dissolution of marriage, my lord. We have partially aggrieved by the order of the permanent alimony.
You are the husband.
The suit was filed by the wife.
So divorce decree granted, you have no qualms with that?
No. With the
you want to challenge the permanent alimony?
Yes, the permanent alimony portion, my lord.
So you want to file an opposition to
yes,
this?
My lord, I have to file because it has a checkered history, my lord. Earlier, my lord, contempt.
If you want to file, how soon can?
My lord, within 2 weeks.
They have also preferred, my lord, execution.
Yes, execution, my lord. Next date is fixed on August 28, 2026. My lord, I am just seeking 2 weeks' time, my lord, to file affidavit in opposition.
The respondent seeks to use an affidavit in opposition to Can 1 of 2025. Although learned counsel for the appellant expresses apprehension, since an execution case in respect of the portion of the impugned decree whereby permanent alimony has been granted is pending, learned counsel for the respondent submits that the said execution case is fixed next on August 28, 2026. Hence, on the prayer of the respondent, the respondent is directed to file her affidavit in opposition within 2 weeks from date. Affidavit in reply thereto, if any, shall be filed within a week thereafter. The application shall be listed next on August 17, 2026. If by any chance we cannot reach by, say, about the end of that week, 17th week, then you make your prayer for. Right.
But this is an application for a suit for partition
Yes.
among the parties. Now, my lord, partition suit was dismissed, therefore we came up before this appeal. Now, my lord, in appeal, your lordship was pleased to grant an injunction, restraining them not to change the nature and character of the property, and also status quo to be maintained.
Mr. Banerjee, on the last occasion when you appeared, you had submitted that all the respondents could not be served.
Yes, yes, because, my lord, here also in this application, my lord, for mandatory injunction, only respondent number 1 and 5.
1 and 5?
1 and 5, my lord,
Were served.
allegation is against, no,
Oh.
allegation is against, my lord, the violation of the order of this court and raise construction, that is against 1 and 5, not other respondents. Therefore, they are bound to demolish it.
No, the
Therefore, we
application
have
is
to serve the
which
court.
application are you pressing now?
Lord, I am placing application CAN 4 of 2026. Now, Lord, I shall serve copy because in none of the times, Lord,
1 and 5 have been served.
1 and 5, Lord, have not been served. That is why we are to serve.
So, but
Because
you did not
unless
take
you-
any step in the meantime.
Because, my Lord, on the earlier occasion, interim order application was filed. After service, they didn't appear. Your Lordship passed an
Till
order.
now, they have not been.
Till now, they did not. Therefore, my Lord, this application is to be served on the respondent number 1 and 5.
Since the grievance of the appellant in CAN 4 of 2026 is against respondent numbers 1 and 5, comma, who have not yet been served, comma, on the prayer of learned senior counsel appearing for the appellant, comma, we direct the appellant to serve copies of CAN 4 of 2026 on the said respondents and file an affidavit of service to that effect on the returnable date, full stop. The application shall next be listed in the monthly list of August 2026.
Lordship.
Yes.
31. Two application, one
Section 5 is-
5,
yes.
along with my lord. Earlier I have sent it, but it was returned with insufficient attendance. Thereafter I have sent it, all of them.
Receive.
Yes.
Yes. So file both.
Two mal affidavit of service. Delay probably 16 days delay.
16 days. What is the reason?
Delay mal I have stated in paragraph 5, 6 and 7 I have stated. Actually, my lord, we made a application. Judgment was delivered on 4th April 2025.
Mistake in the judgment for correction.
Yes, I made an application for correction.
Affidavits of service filed today be kept on record. Full stop. It transpires therefrom that although initially the service could not be effected on the respondents, comma, subsequently it has been properly effected. Full stop. Next para. Accordingly, the application is taken up for hearing expertise since none appears for the respondents despite service. Full stop. CAN 1 of 2026 is an application for condonation of the delay of about 16 days in preparing the appeal. Full stop. It has been averred in the said application that initially correction of the impugned judgment was sought, which took some time. Full stop. Next para. Next para. Time, comma, leading to the delay primarily. Full stop. Next para. Upon a perusal of the averments, comma, we are satisfied that sufficient explanation for the delay has been made out. Accordingly, CAN 1 of 2026 is allowed, thereby condoning the delay in preferring FAT 472 of 2025. Full stop. The said appeal be deemed to stand registered and admitted. What is the other appeal application?
Application for my lord, the injunction. My lord, this is in respect of letter of administration. My lord, judgment has been delivered in OA number 9.
So your probate application, a letter of administration has been dismissed.
Of the citizen.
So it has been dismissed. So you want injunction now?
Yes, I have filed an application for injunction. So you are certainly pass usual order.
The present appeal arises out of the dismissal of the appellant's application for letters of administration in respect of the last will and testament of the appellant's father.
No, I am the first son, my lord. It was on 24th.
On the death of his father, you have stated in the cause title. In the cause title, you have stated on the death of his father, Mukul Raha, the sole executor. Acha. Oh, executor. Acha.
Father was the
Will was
executor.
Acha.
And the will was executed by one, my lord.
Probate of the will executed by one Nirmala Devi within bracket Chatterjee. Which of next para, since questions of both fact and law are involved, comma, we are of the opinion that a prima facie case for hearing the appeal on merits have been made out. Which of accordingly the respondents and or their main agents shall remain restrained by an order of injunction. Possession, we are not sure at this stage.
No, I am still in possession.
So, but how can you know that?
Because, my lord, after, my lord, the execution of the will, I am residing there.
But where do we get it? Is it recorded anywhere in the trial court? Or did you enjoy an injunction in the trial court? In the testamentary court? Have you annexed that?
No, that is not there, but straight away, my lord. Earlier, my
And you have not paid for any injunction regarding the subject property?
Yes, yes, I have paid for injunction. Here I have paid for injunction.
No, you have asked for only disturb the peaceful possession. Nothing else in your application. Prayer portion is only that. Page 8 of your application.
Yes.
Your advocate on record is there. Mr. Shah, your advocate on record is present.
Today, no.
Today? Then you cannot also direct you to amend the prayer portion.
Do one thing.
Accordingly, the response shall remain restrained. Accordingly, the parties shall maintain status quo with regard to the
advocate on the court.
Here,
Yes.
before us. We direct the parties to maintain status quo with regard to nature, character, possession, and transfer of interest to third parties insofar as the subject property is concerned till disposal of the application. Which of the appellant shall... You have served copy of this also?
Yes, yes, I have served all. I have served all.
Till disposal of the appeal. For sub next para, leave on the prayer of the appellant, comma, leave is granted to the learned advocate on record for the appellant to carry out the necessary rectification in the prayer portion of the application by incorporating prayers for injunction in respect of nature and character and transfer in favor of third parties in the prayer portion of the application. During the course of the day, Mr. Shahu.
Yes, yes.
Who's up next para? The trial court record shall be brought by special messenger at the cost of the appellant, comma, to be deposited within a fortnight from date. The appellant shall put in postal costs and requisites for service of notice of the appeal on the respondents also within a fortnight. Which of the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, which of liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. The subject will shall be preserved duly by the department under the aegis of the learned registrar general of this court during pendency of the appeal, subject to orders being passed for production of the same at the hearing of the appeal. Thanks. No rest to cost.
But affidavit of service we kept on that.
Yes, that was the first.
I'm developed. এখন করে দেবো
But I am for the appellant. I feel that my notes have not come. But can it be possible for Lord to take it tomorrow?
When?
Tomorrow only. Only not today.
What has not come?
My notes will not because of rain. I will take it up tomorrow. I'll do it.
On the prayer of the appellant, let the matter stand adjourned.
Not like to take time.
No, you don't. You don't. That's why we are granting you time. On the prayer of the appellant, the matter is adjourned for the day.
May I file my reply or shall I file it tomorrow?
Tomorrow.
I'll take to them.
I've served my application.
Proper service has been effected? Yes. What is the delay?
230 days.
What is your explanation?
Explanation I have stated in para 5, 6, and 7.
ভালো করে সব টেস্টিং করে নিলে কি করবো তো সার্ভিস করেছে কেউ অ্যাপ্লাই করছে না। বিলকে দোষ দিয়েছে ঠিকই, সিরিয়াস না। There is nothing to show that you had contacted your advocate. It's not your advocate's duty to contact you. And where is the statement that you had been diligent and had been contacting the advocate?
Paragraph 7, my lord, the month of September 20, when the
Before September 2025,
middle of the month of September.
Judgment was passed in April 2025.
You are delivered, but
What were you doing in the meantime? From April to September, you did not contact your advocate. Are the advocates supposed to inform their clients every time? You should at least state that you had contacted your anyway. Despite service, none appears for the respondents at the time of call. Full-stop, the affidavit of service is kept on record. Full-stop, from the averments in the application, we find that sufficient explanation for the delay has been made out. Accordingly, can 1 of 2025 is allowed, thereby condoning the delay in preparing FAT 517 of 2025. Full-stop, the appeal be deemed to stand registered and admitted. This is against what? Appeal?
Against declaration and recovery position.
Your suit was dismissed. The appellant shall put in postal costs and requisites for service of notice of the appeal on the respondents within a week from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. The appellant shall prepare and file the requisite number of paperbooks within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Next. Dismiss expert. Confirm. Third.
Yes, sir.
Section 5.
Section 5, my lord, there are two appeals, my lord. One, my lord, my client being the husband filed a suit for dissolution of marriage by a decree of divorce. The wife filed, my lord, another suit, my lord, for also praying for dissolution of marriage.
Hers was decreed, yours was dismissed.
Dismissed, both by a common judgment, my lord. First one, my lord, is a 17 days delay, and my lord, second one is 34 days delay. On my advice, it was not advised to prefer the second appeal from the other suit, my lord. I advised, then certified copy was obtained, and 34. That's why.
No. Why the delay in the other appeal then?
On my advice, my lord, it was not advised to the client, my lord, that two appeals have to be preferred.
So one appeal should have been preferred in time.
Yes, my lord.
Why
that
both were
explanation is
delayed?
there. Yes. My lord, the advocate, my lord, had expired, my lord. Then a fresh, my lord, it came to a fresh set of.
Delay in one is 17, the other is
34 days.
Good service, you said.
Yes, I've checked up.
Despite service, none appears for the respondents at the time of respondent in each of the appeals at the time of call. Full stop. The two appeals arise respectively out of the dismissal of the appellant husband's suit for divorce and a decree and a divorce decree passed in the respondent wife's suit for divorce. Full stop. Next para. The ground made out in the applications are primarily that advocate's illness, you said?
No, my lord, Mr. Devashish De, my lord, he had expired, my lord.
Is that the advocate initially engaged to prefer the appeal had expired in the meantime, and subsequently, the appellant was not properly advised to file a first appeal from the decree passed in the suit for divorce filed by the respondent.
Analogous hard common decree.
Decree cannot be common. Decree cannot be common. So next para. From the averments made in the applications, we find sufficient explanation for the minuscule delay of about 34 and 17 days respectively in preferring the appeals. So accordingly, can 1 of 2026 in FAT 524 of 2025 and can 2 of 2026 in FAT 522 of 2025 are allowed, thereby condoning the delay occasioned respectively in preferring FAT 524 of 2025 and 522 of 2025, which of the said appeals be deemed to stand registered and admitted. Which of yes, anything else?
It's not 34, 35.
34 to 35 hoga.
And my lord, another application, my lord, can one in connection with FAT 522, my lord, I have prayed for analogous hearing of both the appeals.
Since the appeals arise from a common judgment but separate decrees,
This was not served. Only section 5.
need not. Since the appeal arises out of a common judgment but separate decrees, comma, the appellant has filed Can 1 of 2025 in FAT 522 of 2025 for analogous hearing of the two appeals, full stop, in view of the innocuous nature of the prayer, comma, prior service of copy of the said application is not being directed, full stop, Can 1 of 2025 is accordingly allowed, thereby directing FAT 522 of 2025 and FAT 524 of 2025 to be heard analogously. Full stop, the appellant shall put in postal costs and requisites for service of notice of both the appeals on the respondent within a fortnight from date. Full stop, the trial court record shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a fortnight. Full stop, the appellant shall prepare and file the requisite number of composite paper books for both the appeals within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellant, which of liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Obviously, have not asked for stay, or you want also divorce.
Yes,
You want her to marry in the event.
My lord, the allegations, my lord, have to be.
No, the appeal will be persisted, but the remarriage you are not.
My LCR, my lord, has direct LCR, my lord.
What were you thinking when you
My lord, I was, my lord.
gossiping with him? Yes.
Your Lordship, I am appearing on behalf of the respondent.
My lord, I am for the appellant, my lord. We have submitted our affidavit in opposition. And
Application for injunction.
My lord.
What is the
With the
context?
refusal of interim injunction, my lord, we approached with this honorable court. Your lordship, by an order dated 7th of, my lord, April 2026, your lordship passed an order. Passed an injunction order, my lord.
Oh, defamatory that.
My lord.
Yes, what is your
Your Lordship, at first place, I would like to point out that they have made a submission that the respondent has willfully left the matrimonial home and she came back to India. That is not the case. She was being persuaded by the plaintiff number 2 that you go back to India as of now due to the immigration documentation purpose, and that I would come with the child to India. So it was never the case that she has willfully left the matrimonial home. That was not the case. Secondly, they have filed an injunction application before.
no, what is the context of this suit? I mean, what is the relationship between you? The plaintiff and you?
I am the wife of plaintiff number 2.
All
And plaintiff number 1 is the mother-in-law.
all right.
So, Your Lordship,
Stay at the insistence of your husband, you had come back to India.
yes, Your Lordship, because I was persuaded to come to India, that for the time being, you go back to India, I'll come with the child. And they have also like mentioned that I have never given any thoughts of like visiting the child or so. That was not the case, since I did not have.
The context of the suit is your defamatory remarks, allegedly.
Yes, Your Lordship. Even if it is presumed, just for the sake of argument, that there was any post, any defamatory post, without admitting the same, those posts is not available on any social media at this given point of time. And this was the reason why the learned civil judge senior division of Barashat had refused the interim injunction at that point of time, since there was no urgency. The very purpose of filing an interim injunction under order 39 rule 1 and 2, the purpose is to restrain someone from doing anything which should not be done. But as of now, there is no urgency, there is no continuation. And I pray Your Lordship to kindly not pass any restraining order, as because it will create a presumption in the lower court, since she has not even filed the
Yes,
written
ma'am.
statement.
One is that injunction, they have annexed certain documents which prima facie show that at one point of time there were certain posts. We are at the prima facie stage, we are not deciding the suit. This is not conclusive. Prima facie, they have made out certain materials to show that at one point of time, apparently there were certain posts by you. Now that creates an apprehension. Just because right now there are no posts or you have taken off the posts does not necessarily mean that there is no apprehension tomorrow you won't do it. So today, what is the scenario that does not necessarily, that cannot necessarily be the only determinant. At one point of time, if there has been something, they are entitled to injunction, at least restraining from doing that. And these identity findings, we can make it clear that the identity findings will not be binding at any stage, which are also not binding. So if you want, we can dispose of the appeal along with the application itself by sustaining this interim order. And we'll say that these are not conclusive findings subject to adjudication in the injunction. We'll make it clear. Law
Your
is that.
Lordship.
We will make that clear. Because there are prima facie certain documents which we are satisfied that they may partake the character of defamatory allegations.
If I may be allowed for 2 minutes.
Absolutely.
There is no continuation, Your Lordship. Moreover, whatever order has been passed by the district court, it is not the final disposal of the case.
Right.
It was just an order was being passed on the absence of the defendants. Now the defendants has been served the notice that such a case is being
You filed
pending.
a written objection to the injunction.
Not yet, Lordship. Not yet, Lordship. We
How
will.
can it be heard out? We can direct it.
Yes,
to
Your
the-
Lordship. We have already been served the
How soon
information
can you
to
file?
file the written
How
statement.
soon? How soon? Written objection to the injunction. How soon can you file it?
Like
Will
no, in this we have filed.
No, in the trial court, we are disposing of the appeal application to. Otherwise, this will be pending forever, and that will also be stopped.
Yes, Your Lordship.
So that is what we propose to do. But how soon can you file your written objection to the injunction application, it is annexed also here. Their injunction application in the trial court has been annexed here. So how soon can you file a written objection in the trial court? Tell us that. We'll pass a request to the learned trial judge to dispose of the injunction itself within a limited period, but we'll keep that restraint order till that time. Your client is now residing in India or abroad?
Yes, she is residing in India.
Then
Your Lordship, even if Your Lordship does not pass any restraining order, it is not the duty of her to pass any lewd comments about the plaintiff in any social media or anywhere else. That is understandable by the respondent. No denial to that.
Not necessarily lewd comments, but in a sense that
Anything offensive.
Offensive in the sense serious allegations are being made. This is sub judice before the trial court. Then we can. I mean, is there any litigation independently going on between you?
Yes,
Custody.
lots of actually she has filed a matrimonial suits under section 125 of CRPC. Along with that, she has also filed an application under the Guardian and Wards Act, where an interim order has been passed that the mother should get a chance to at least have a video call with the child.
So therefore, all the more you should not make any comments since the matter is sub judice.
Right now,
And we find several printouts of social media posts.
but Your Lordship, the
You
genuineness.
rebut those presumption in the trial court. No difficulty. We are not conclusively holding, but we'll grant an injunction. We'll continue our injunction till disposal of that injunction. If you file a written objection in the trial court within 2 weeks, 3 weeks, give us a time. Give us a time. Whatever you say, will permit that.
Your Lordship, kindly allow 2 weeks time.
We can grant you 3 weeks time. 3 weeks time. And the trial court will preferably hear out the injunction application within 8 weeks from our date of communication of our. We'll pass that order. And we'll also make it clear that we are not conclusive on that part. The present, in view of the short ambit of the appeal, the appeal itself is taken up for hearing along with the application. The appellants, who are respectively the mother-in-law and the husband of the respondent, have filed the suit from which the present appeal arises alleging seeking damages for alleged defamatory comments being made by the respondent in social media against the appellants. For sub next para, learned counsel for the respondent vehemently opposes such allegations and argues that the learned trial judge refused to pass ad interim injunction since there are no social media posts available at present to indicate the involvement of the respondent in any such defamatory or derogatory remarks against the appellants. For sub next para, even on merits, learned counsel for the respondent submits that no defamatory comments have actually been made by the respondent. For sub next para, be that as it may, from the several annexures to the injunction application filed before us, which were apparently also a part of the injunction application filed by the appellants in the trial court, a prima facie case of seriously derogatory comments being made by the respondent against the appellant has been made out. Full stop. Next para. Thus, comma, the apprehension of the appellant regarding further such statements being made seems to be justified, comma, even if we presume that currently there are no such posts on the social media. Full stop. We are also apprised by learned counsel that different litigations are pending between the parties, comma, which all the more creates an apprehension that unless an injunction is in place, comma, the respondent may make comments which might partake the character of derogation of the appellants. Full stop. Next para. However, comma, while observing so, we make it amply clear that the above observations are only tentative in nature, comma, arrived at for the purpose of deciding the present appeal, and shall not be treated to be conclusive or binding on any of the parties or the learned trial judge at any further stage of the litigation, comma, be it the final hearing of the injunction application or the disposal of the suit. Full stop. The learned trial judge shall be at liberty to decide the injunction application and the suit on their own merits, upon giving adequate opportunity to parties to make their respective allegations and to rebut the same. Full stop. However, comma, in view of the above observations, comma, we find that the learned trial judge erred in law and in fact in refusing ad interim injunction as paid for by the appellant. Full stop. Accordingly, comma, FMAT 439 of 2025 is allowed on contest, comma, thereby setting aside the impugned order bearing order number 01 dated August 13, 2025, passed by the learned civil judge, senior division, 3rd court at Barasat, district North 24 Parganas, in title suit number 881 of 2025, and restraining the respondent by an order of injunction from what was the order we passed?
7th of April, your lordship.
127. Page 127.
From making
page
any post and stroke or publication in any media, comma, within double inverted social, double inverted close, or otherwise, comma, and stroke or using the photograph of the minor child of the parties in the light of the above restrictions, comma, which may be derogatory, comma, defamatory, comma, sarcastic, and stroke or scandalous, and may demean the social prestige of the appellants in any manner whatsoever, till disposal of the temporary injunction application in the trial court. Full stop. The respondent shall file her affidavit, written objection to the temporary injunction application of the plaintiff stroke appellants in the trial court within 3 weeks from date. Full stop. Next para. It is expected that the learned trial judge shall dispose of the temporary injunction application at the earliest, comma, preferably within 8 weeks from the date of the date of communication of this order to the learned trial judge. Full stop. Can 2 of 2025 is also disposed of consequentially. Full stop. There will be no orders to costs.
I'm grateful, my lord. Only one thing, my lord, the contention that there are no posts, my lord, that we are objecting to. Because we find that, my lord, there are some posts available.
আচ্ছা, যেখানে আমরা বললাম যে ওই learned counsel for the respondent submits পুরো সাবমিশনটা পরে, needless to say, comma, such submissions of the respondent are controverted by the appellant.
I'm grateful.
You have argued well, ma'am. Yes. Next. Yes, Mr. Ghosh, you are for the appellant.
This is that no summons or no notice was served.
Section 5.
Section 5. There is 315 days delay. My lord, I have served copy of the supplementary affidavit on 29th June upon my learned advocate. My lord, I may be permitted to file it because your lawyer has pointed out that the entire order says have not been annexed to the supplementary affidavit. My lord, I have annexed.
What has been done? Expert decree.
Expert decree.
What decree?
Preliminary decree along with the declaration of deeds. Deeds in my favor have been declared invalid void.
Yes, Mr. Dr. To the section 5 first.
That is section 5. You also kindly consider what suppression you also directed me. I thought notes regarding suppression. Yeah, so communicate about notes.
Yes.
You kindly have it okay. Customer, you also kindly go through their application.
Affidavits have been exchanged in this matter.
Yes. You also kindly go through their application, their knowledge, about their knowledge.
We'll look from your chart. You just place your chart. Yes.
After you also find that on 28th of February 2024, the summon was served on opposite
Now, this is on the basis of their averments.
their apartments. Their apartments and the
Oh, no, page 54 of the affidavit. Acha, very well. Let us continue. Yes.
these are all on
Summons were served, you say.
by the state court. The order sheet speaks about it. Court records.
Page 54 of the affidavit of opposition is that order.
Next, you'll also find that appeal number 2, receipts.
Yes.
Next, you'll also find
Appellant number 2 is not one of the appellants.
one of the appellants.
Oh, acha, sorry, appellant number 2. You say.
Appellant number 2,
Acha, very well.
defendant number possibly my lord 7.
7.
And my lord, next you'll also find on 29th April 2024, substitute service of summons. Order by Rule 20 allowed, and there are some paper circulation regarding the summons.
Yes.
Next, you'll also find defendant number 6, 7, 8, 9 applied for certificate. This is very vital. They have suppressed it. Well, you'll also kindly look into the memorandum appeal. Their allegation in the section 5, they applied for certified copy after 18th/11/2025. After 18th/11/2025, it is the specific case. And they applied certified copy on 26th of November 2025. Now, this is gross suppression among this suppression, they ought to be non-suited.
Oh, they applied as long. When did they actually apply?
Applied on the 4th of June. No, 4th of June.
It is encouraged submission.
Appeal was.
First, you will have your chance, please.
You will also kindly look into the memorandum appeal. I have checked up the record. And I have endorsed from the after going through the record matter. I have
4th of June.
4th of June. But now, Lordship, you will also kindly look into their application. Paragraph 5. I am reading. In the middle month of November 2025, the revenue officer DLRO Blackwood, by invoking provisions of section such and such, appellant respondent informing that we are hearing connection in miscellaneous case number such and such on 18th/11 at 12 noon. With the direction upon to appear such and such document, then my lord, you will also find. Then they applied for certified copy. Next page, you will also find. My lord, paragraph 6. It is their first knowledge. But their knowledge made out on 4th of June. They applied for certified copy. Next, paragraph 6. After coming to know about the facts stated above, in course of proceedings being miscellaneous case number such and such, the petitioner appellant applied for getting certified copy. Judgment of preliminary decree and the said petition filed statute number such and such on 26th of November 2025. Then another certificate copy they applied. And they are relying on that. But in the appeal, my lord, you will also find from the record of the appeal, my lord, you will also find on 4th of June. Then, my lord, their knowledge from since 4th of June.
They annexed the wrong certificate copy in the memorandum.
Bunch of certificate copy they have been
by mistake.
It is totally fraud on court. They have committed serious fraud on court. Under the impression, my lord, you are also under the impression that their property is going to be taken by the plaintiff.
That you will take in any event if their application is dismissed.
But lordship, their knowledge on 4th of June. Next, you lordship, in my index, you lordship will find. Apart from this, they got further knowledge in July 2025.
How?
You lordship find they have stated in paragraph. I have mentioned. But I have mentioned. Item number 4.
Yes.
Chairman of Dom Municipality issued notice to the applicant defendant number 8 and also to the plaintiff respondent number 1 to 5, directing parties to appear on 23rd of July 2025 before the Board of Council of North Dom Municipality by striking off the name of the applicant number 3 and 4 from the assessment registered in terms of the judgment indicated. The copy of the said notice, my lord, I have enclosed.
Mr. Datta, is there any proof that that was served on them?
Yes, yes, they have my lord, admitted
Where?
in the application.
Where is that?
Well, you will have to find. I have also mentioned.
Which paragraph of their application?
I have also mentioned.
Page 10 of the rejoinder also. These are your rejoinder and your opposition. Paragraph of number 3.
Paragraph 3.
Yes, let us see paragraph 3.
They have mentioned that after getting the impute expert order, made an application to the municipality for deletion of the name. And these documents, they appeared in their, lastly, my lord, there are 2 dates of hearing, and when the municipality did not pass order, we preferred writ application. My learned friend appeared, and my learned friend, in spite of that, thereafter they filed the appeal. My learned friends alleging that the trial courts, there are 6 learned advocates blaming on them that they are misguided.
6 advocates have admitted.
Yeah, yes, sir. In the petition, you also will find. Well, these are the gross, my lord, deliberate suppression, my lord. If a person is, my lord, suppressed, and my lord, your lordship is not deciding, I am relying on your lordship judgment that on merits your lordship will not decide this matter. Section 5.
Merits we cannot now.
These are the
We
gross
could not at
suppression
any point of time,
and
could only be a consideration. Now that is also cut off by the Supreme Court.
Regarding suppression, only one judgment exercise.
Yes.
Regarding suppression.
Quickly, Mr. Datto. Quickly.
Quickly.
Section 5, we cannot devote more time. We will not rely on the judgment, then we will miss.
I've got one. The judgment you also kind to consider regarding suppression. 2011 volume 1,
Dao.
Civil Case Supreme Court.
Which para?
And, you'll also find the paragraph
14, 15.
Yes, ma'am. 14.
Pollute the stream of justice.
13 and 15. 13, 14, 15.
Very good.
And in section 5, you'll also.
Let us hear them. Yes, Mr. Ghosh.
Yes.
Nutshell, quick, deal.
My lord, I made an application, my lord, for conditional bill only on the ground. Before 18 November 2025, appellant had no knowledge about the pendency of the suit and passing of the expired decree. My lord, when the BLRO issued a notice upon the appellants that you are directed to produce all the documents, and their client also was also directed to produce all the documents. In course of hearing, we came to know, the appellant came to know that they got an expiry decree from the learned trial judge. But that is on 21st February 2025. But prior to that,
Where is your first knowledge pleaded in the section 5?
Paragraph
Para 5.
Para 5, para 6.
Informing that hearing in connection with such and such or not.
Yes. My lord, again, your lordship was pleased to direct me to file a supplementary affidavit again. My lord, I have explained in paragraph, page 13, paragraph 19, that is the second supplementary affidavit. The prior to receiving the notice on 17th November 2025 issued by BLLRO, the applicants had no knowledge about passing of expert degree passed on 21st February 2025. And your petition may search in trial courts as to whether any.
So your first knowledge was on 18th of November.
18th November. And my landed adversary submitted that I have appeared before the writ application, writ court, before the writ court. Well, I have been served with the applications of the writ, supplementary affidavit, 27th.
No, not writ court. Mr. Dotto has three limbs of argument. First, that someone's categorical recording of the trial court. Someone was
Only
served substituted
upon one of the defendants.
Served on appellant number 2, substituted service on the others. He says there is no material to rebut that presumption. Secondly, that you applied for the certified copy itself on 4th of June, which is annexed to our memorandum. So how do you say you had first knowledge in 18th of November?
Well, I got certified copy. That is
when you applied, see that.
27th November 2015 seal.
Date of application for certified
only
copy.
Judgment. Only judgment. Thereafter, department
Sir,
directly the applicant.
sorry. You applied for the judgment on 4th of June 2025. And you were saying you had first knowledge in 18th of November 2025. Your application, if you file your application for certified copy in June, how do you say you learned it for the first time in November?
Lord, that is the amendment made in the first title appeal. That is
so therefore, this is palpably a lie. This is the incorrect statement.
They applied
5 months after you say you have got knowledge.
They had
5 months previous to acquiring knowledge, you had applied for the
certificate
certificate.
of the Bhasha Judges Court. There's an amendment. 26th November, they made an application for getting certified copy. It's supported by an affidavit. Well, I believe this statement that while drafting the application, well, kindly see for a moment. This is the title appears returned because of.
Why should you look at that? Your application is before us, where you say that you for first time you are still abiding by that. That you are saying 18th of November 2025 you had first knowledge, but your certified copy was applied for on 4th of June, and you use that certified copy for this appeal. You should have been more cautious while lying to the court.
Well, kindly see for a moment. Well, assessment.
More cautious. Should have used the next certified copy which you applied for afresh.
No, next certificate, that is judgment. Well, subsequently, department told me that your appeal cannot be registered because you have not filed the decree. Then I have made
your application. You say your first knowledge of November 2025, but you apply for the certified copy in June.
Well,
for some judgment which you come to know only 5 months thereafter. Retrospectively, you applied.
The expert decree, well, that is the
therefore that is palpably incorrect. Your appointment. It's palpably incorrect.
Well,
also, this notice by the Dom-Dom.
Sir, that is no notice was served upon me.
So then, how did you participate in the hearing?
I did not participate in the hearing. No notice was served upon me.
You say your knowledge is from the participation in the hearing of 18th November.
BLRO, not Miss Verdi.
Acha.
BLRO, not Miss Verdi. But kindly see the contents of order for Rule 20 application. I have annexed this affidavit. Their awareness is that no notice was served upon the defendants 1 to 9. They are returned with the remark the address cannot be located. Only service upon proffer dividend 10, 11, 12. That is the awareness made in order for Rule 20 application. On earlier I produced this information slip. From information slip, your lordship is fine. There is no bailiff report in the trial court. Well, I have annexed it with this supplementary affidavit. With this affidavit. There is no bailiff report, summons some given number 225 in the final degree. Finally, proceedings was served. But the original suit.
No, substituted service was effected. That is good, sir.
There is no bailiff report in the record.
One of the appellants was served.
One of the appellants served. I
made with you.
That appellant made an affidavit, supplementary affidavit, showing that the postal tax report, showing the service upon the Rabindranagar post office, it was a served upon him. I have categorically stated in my supplementary affidavit that all postal tax reports not addressed to the appellant. Well, I have stated in my category in my affidavit that has been challenged.
Track reports say that it is served at the.
Served upon the Rabindranagar post office.
That is the track. That is how the track reports are made, Mr. Ghosh. If you file your affidavit of services, if you take up any of your affidavits of service, that is how it is given, and it's written delivered at the
address must be the name of the.
No.
Rabindranagar post office.
Yes. You take up a.
Well, kindly see the order for Rule 20 application. This is their government with the supplementary evaluate. That defendant number 1 to 9 are returned with the remark the addressee cannot be located. On the basis of this amendment, publication was made.
Anyway, Mr. Ghosh, your client is not telling the truth. You apply for a certified copy on 6th
Well,
of
kindly
May,
see the order
that
for
only your application should.
only for a moment order for Rule 20 applications.
Where is
Only
that?
for a moment.
Where is
I
that?
have annexed it.
In what? The supplementary?
Supplementary. All years, my lord.
How many supplementary affidavits have you filed?
3. And my lord, second supplementary, I have annexed the order for Rule 20 applications.
We'll appoint you a special officer to locate the supplementary affidavits.
Minutes of the matter there.
If this is the appointment made in order for Rule 20 application, may I place this? My lord, may I place
Wait,
this?
wait, wait. We have found out 2.
Information slip and supplement order for Rule 20 application that has been annexed.
তিনটে পাওয়া গেছে আমি দুটোই পেয়েছি
May I please the copy?
There are only 2 supplementary affidavits on it. Not
My lord, I have annexed the information slip and supplementary evidence. Order for Rule 20 on earlier the lawsuit observed that yes, you have annexed the applications. Order for Rule 20.
yeah, that is there in the first supplementary affidavit.
That is the content. My lord, can you see the paragraph 2?
Hmm.
Plaintiff stated the plaintiff sent summons to the defendants on 28th February 2024 filed postal receipts and track report. On the track report submitted plaintiff, it is found summons upon the performed defendant 10, 11, 12. That is not the applicant people lordship. Duly served. But from the rest track concerned report, it is found summons upon the defendant 1 to 9 are returned with the remark the addressee cannot be located. Therefore, there is no valid report. And postal that is their government supplementary affidavit. Addressee cannot be located. Therefore, summons could not at all be served upon the appellant before lordships.
Appellant, the appellant number
One-
7
one to
was
6.
defendant
One-
number 6.
6, 7, 8, 9. That is their governments.
No, court's finding. Court's order records that. Court's order records that, not their government.
Number 7.
Defendant number 7.
Okay.
That is the order dated 28th of
That is wrong.
February
That
2020.
is wrong.
That
Because
is-
that is their government. They are saying from postal track reports it is found.
No, it must have served to both ways.
There
This
no
is
valid
their
report.
postal track
There is
report.
no valid report. Well, I have
Bailiff report need not be.
no
on
nothing.
this
is
rec-
no,
Must be there in the records.
Nothing. My lord, kindly call for the record, my lord. Your lawsuit will be wondered. There is no valid report. No summons was at all served upon the appellants. Well, lord, I have
Go
obtained
by
the
the
information
findings,
slip.
not your client's government, Mr. Ghosh. If the court records in its order that it has been served on
one defendant.
that defendant is a co-appellant with you, his knowledge should
But
need to be your
there-
knowledge.
There is statement made in the application that addressee cannot be located.
Very. Anything else?
Well, this is, summons could not be served, but summons was not
What is the delay? Period of delay?
315,
50.
315.
No, Mr. Ghosh, we are not allowing this.
Well, petitioners will be in the travel, my lord, without serving summons and notices. They obtained the expiry preliminary decree and my deeds were declared crores of property value. I was
Present
served in
appeal has been
summons.
preferred against a preliminary decree of partition, comma, also declaring title deeds in favor of the appellants invalid. For some next para, learned counsel for the appellant, comma, by placing reliance on the several supplementary affidavits filed in connection with the condonation application, as well as the averments made in the said application, comma, contends that the appellants only came to know about the impugned judgment and decree on November 18, 2025 during hearing before the concerned BL and LRO at Barakpur. For some next para, thereafter, comma, certified copies of the impugned judgment and decree were applied for and the present appeal has been preferred. For some next para, with regard to the plea of the respondents that summons of the suit was recorded to have been served on the defendant number 7 stroke appellant number 2 with a order dated February 28, 2024, comma, learned counsel for the appellant submits that such the veracity of such order is belied by the application filed by the respondents themselves in the trial court under Order 5, Rule 20 of the Code of Civil Procedure, where it was categorically admitted by the respondents that summons upon the defendant numbers 1 to 7 had returned with remark that addressee could not be located. Full stop. Next para, learned counsel further argues that the notice issued on July 17, 2025 by the chairman, North Damdam municipality, which was alleged to have been served on the appellants, was actually never served. Full stop. Next para, thus, it is contended that a liberal view ought to be taken by this court while condoning the delay in preferring the appeal. Full stop. Next para, learned counsel further insinuates that if the trial court records are called for, it will be found that there is no bailiff report regarding summons of dues due service of summons, even on the defendant number 7, stroke appellant number 2.
All the appellants.
Even on,
Yeah.
let alone the other appellants. Full stop. Next para, learned counsel for the respondent relies on a chart of alleged suppressions by the appellants in their application under Section 5 of the Limitation Act and the corresponding supplementary affidavits. Full stop. Next para, learned counsel for the respondents primarily places reliance on the orders dated September 28, 2024 and April 29, 2024, where the learned trial judge respectively recorded due service of summons on defendant number 7, stroke appellant number 2, and substituted service of summons having been effected on the defendant numbers 1 to 6, 8 and 9. Full stop. Next para, it is further argued that from the certified copy of the impugned judgment annexed to the memorandum of the present appeal, it will be evident that the same was applied for on June 4, 2025, whereas the appellants have made out in their condonation application that their first knowledge of the impugned judgment and degree was only after November 18, 2025, which is palpably an untruth. Full stop. Next para, learned counsel further points out that from the materials on record, it will be evident that the notice issued by the chairman, the North Damdam municipality 17, 2025 was duly received by the appellants much prior to their purported pleaded knowledge of the impugned judgment and decree. Full stop. Next para, learned counsel thus argues that in view of the suppression of such material facts on the part of the appellants, the condonation application ought to be dismissed. Full stop. In support of such proposition, learned counsel cites such as Ramjosh Foundation and another versus Union of India and others, reported at 2011 within bracket 1 ICC 639. Full stop. Next para, from upon a perusal of the materials before us, we find that the averments made in the condonation application and the supporting supplementary affidavits cannot be relied on insofar as credibility is concerned. Full stop. The very first aspect of the matter which catches our eye is that the appellants have categorically averred and submitted before us that their first knowledge of the impugned judgment and decree was acquired on November 18, was acquired after November 18, 2025, whereas it is palpable from the reverse of the cover page of the certified copy of the impugned judgment filed along with the memorandum of the present appeal itself that such certified copy was applied for on June 4, 2025, that is about 5 months prior to the pleaded first date of knowledge of the appellants. Full stop. It is absurd that such certified copy was applied for retrospectively by the appellants 5 months before coming to know of the concerned judgment itself. Full stop. Next para, although it has been sought to be insinuated by the appellants that such application for certified copy was made by the appellant's learned advocate at the relevant juncture in the trial court without knowledge of the appellants, the very fact that the self-same certified copy has been used for preferring the appeal indicates the complicity of the appellants in the above regard. Full stop. Next para. Apart from such palpable untruth, we also find that the statements made in the application of the plaintiff's respondents under Order 5, Rule 20 of the Code of Civil Procedure to the effect that summons upon defendant numbers 1 to 9 were returned with remark that addressee cannot be located, can easily be explained away, since it is the custom and practice of civil courts to direct service of summons both ways, both personally by registered post by the plaintiffs as well as through court. Full stop. Next para. The recording in the relevant order of the trial court dated February 28, 2024 to the effect that the summons had been served on defendant number 7 stroke appellant number 2 indicates that the said service was effected through court, whereas the statement in paragraph number 2 of the Order 5 Rule 20 application as to summons having been returned with the remark that addressee cannot be located pertain to the alternative mode of service resorted to by the plaintiffs themselves. Full stop. Next para. As is well settled, presumption of correctness is attached with all official and judicial functions, which has not been rebutted in the present case, insofar as the service of summons having been recorded on the to have been effected on the defendant number 7 stroke appellant number 2 as early as on February 28, 2024. Full stop. Next para. We cannot lose sight of the fact that the appellant number 2, who had prior knowledge of the impugned of the suit, is a co-appellant with the other defendants before us. Full stop. Thus, the knowledge of defendant number 7 stroke appellant number 2 about the suit in at least prior to February 28, 2024 itself is a sufficient indicator that the other appellants also had access to such information. Full stop. Next para. The ratio laid down in Ramjoss Foundation Supra is apt in the context where the Honorable Supreme Court, upon considering previous judgments, took note of the dictum that a litigant who attempts to pollute the stream of justice or who touches the pure fountain of justice with tainted hands is not entitled to any relief, interim or final. Full stop. Next para. Hence, lenience cannot be extended insofar as the present application for condonation is concerned in view of the untrue methods adopted by the appellants before this court. Full stop. Next para. In such view of the matter, we disbelieve the case made out in the condonation application and the supporting supplementary affidavits and come to the finding that sufficient reason for the delay in preferring the appeal has not been made out. Full stop. Accordingly, Can 2 of 2026 is dismissed on contest without any orders to cause, thereby consequentially dismissing FAT 3 of 2026 as time barred. Full stop. Next para. The other pending connected applications can dispose of as well. Number jodi kichu thake as well without any orders to cause urgent certificate. Eta ekটু ফেরত দিয়ে দাও. Mr. Ghosh, please take this back.
In this matter, I appear for the question. This is an application for stay by the wife appellant hearing who has suffered a decree for divorce.
For the first time?
For the first time.
The present appeal has been preferred against divorce decree obtained by the respondent husband against the appellant wife. Full stop. Next para. Although a prayer for stay has been made, in view of the impugned judgment being in the nature of a judgment in rem, comma, we stop short of granting stay, comma, which will have larger ramifications. Full stop. However, comma, the respondent husband shall remain restrained by an order of injunction from contracting any remarriage, comma, if not remarriage to a third party, comma, if not already contracted, comma, during pendency of Can 1 of 2026. Full stop. The appellant shall serve a copy of Can 1 of 2026 on the respondent, indicating that the application shall next be listed for hearing in the monthly list of September 2026, when an affidavit of service to that effect shall be filed by the appellant. Full stop. Affidavits, comma, if any, shall be exchanged in the meantime.
Grateful. My lord, there is a minor delay, a minor defect is there, my lord. Let it be corrected, my lord.
What is the
Liberty. My lord, it was classified as decree
Very well.
original.
Leave is granted on the prayer of learned counsel for the appellant. Leave is granted to the learned advocate and record for the appellant to carry out the necessary rectification in the memorandum of the appeal to cure the defect pointed out by the office.
Grateful to your lords.
There is an office report to that effect.
Yes.
Yes. Yes. Yes, Mr. Bhattacharya.
This is appeal, challenging the preliminary decree of partition.
First time. First time.
There is an application for stay, but there is a defect, my lord. If your lordship would kind enough to see the memorandum of appeal.
He's the advocate and record. Delay, defect.
Milord,
What is the defect?
defect not, milord.
Oh, defendant answer, not that
You
sort.
kindly see, milord, 1, 2, and 3. Appellant number 1, 2, and 3 were the defendant number 1, 2, and 3 in the trial court. And milord, respondent number 1 and 2 were the plaintiffs. And milord, if your lordship kindly see, milord,
defendant number 3 died.
Exactly. We were also defended. The plaintiff did not substitute. Milord, we have made the heirs of defendant number 3 as
Have
parties.
you made an application for leave to prefer?
That was not there. That is the defect.
File that application. Otherwise, the appeal is not maintainable against them.
Because the plaintiff never, milord.
File that application. Mention that. Then we will put it in the list. We will not keep the matter pending here in the list.
1 week. It's ready, milord. Only it will be affirmed.
Learned counsel for the appellant seeks liberty to file an application. Appellants seeks liberty to file an application for leave to prefer the appeal against the heirs of the deceased defendant number 3. Full stop, such leave is granted. Full stop. The appellant shall, comma, upon filing the same, comma, mention the application for inclusion in the list along with the current application. Full stop. Let the matter stand adjourned till August 4, 2026.
Subject to correction, leave application will not be maintainable here.
Why?
Addition of party, because they had died during pendency of the suit. Leave is after
this partition suit.
Partition suit.
তাহলে leave না করে ওটা application for addition of party.
So great.
Petition is the husband, my lord. Mutual divorce petition of the petitioner parties have been dismissed on the ground that the parties have not been complied with the mediation proceeding, my lord.
You also agree to this?
Well,
so it's almost a joint appeal sort of.
Yes, yeah. But I found in the cause list that there is some defect.
Defect. Let us see what is it.
One thing I found, my lord, I have not mentioned the name of judge trial.
Classification of appeal furnished in words. What have you classified it? Why have you written so many things? You help him. Memorandum of appeal from original judgment and order dated such and such. So not so many things. Proper. Preamble is name of presiding judge in the trial court have to be given. You know the name of the judge. You can find out the name of the judge.
That is
there. Very well.
Yes.
So these two only.
Okay. Anirban.
We're granting you leave to do both the things during the course of the day. Let us see the judgment once. These are the Hindu Marriage Act.
No, my lord.
Special Marriage Act. Special Marriage Act without.
Section 20.
Special Marriage Act.
My lord, the mediation was ordered on the first day without consent of the parties also, my lord. I have annexed all the orders in.
Under the Special Marriage Act, is there any provision?
No.
I don't know of the Section 89 Civil Procedure Code manages the court to consider whether both parties are agreeable. Only then.
Absolutely.
consent appeal নিয়ে reset করেছিল। বলে দিচ্ছি শুনে দিচ্ছি। No, it was dismissed on that ground.
Yes, madam. On that ground, it was dismissed.
Name of the judge should be in the preamble.
Only, my lord, just not complied with, not communicated.
Very fast. Order of the court violation বলছে। Compare করতে হবে remediate। কোন কোর্ট? শিয়ালদা। কেন আপনি? ওই অনর্বণ এটা করবে না, ও এটা করবে। ওই অনর্বণ অনেক ভালো যাচ্ছে। আসুন না। We are disposing of the appeal itself. On the prayer of learned counsel for the appellant, leave is granted to the learned advocate and record for the appellant to carry out the necessary corrections to the memorandum of appeal to cure the defects pointed out by the stamp reporter during the course of the day. Who's up next para? Learned counsel.
May I submit one thing? Actually, the advocate record due to illness could not come to. I will definitely done by tomorrow, my lord. I will.
Very well. His illness will be cured by tomorrow. Are you sure?
Since the yesterday's match, my lord, he could not come. Or that is. He could not come today.
You are sure he will not become more sick, depending on the side he was.
I have.
Very well. By the course of the delay, by the course of this week. Correction. Next, learned counsel for the appellant submits that the learned trial judge dismissed the application filed by the parties jointly for divorce by mutual consent under section 28 of the Special Marriage Act 1954 only on the ground that the parties had not appeared before the mediator to settle their disputes as per previous direction of the court. So next para, learned counsel submits that mediation depends on the consent of both parties, and in the present case, since the parties in any event have applied for divorce by mutual consent, their non-appearance for mediation could not have vitiated the application itself. Full stop. Next para, learned counsel for the respondent, who was a co-applicant in the application for mutual consent divorce, adopts the arguments of the appellant and also submits that the impugned judgment should be set aside on such count. For some next para, from the impugned judgment, we find that the learned trial judge observed that video order dated August 12, 2025, the parties were directed to appear before the mediator to settle the dispute between themselves. First up, it is further recorded that the matter was fixed on several other dates, on which dates learned counsel did not think it their duty to intimate that they did not go for mediation. Full stop. Next para, the learned trial judge further observed that when the matter was taken up, a submission was made that the order dated August 12, 2025, directing the parties to go for mediation was not complied with the parties, which was construed to be a deliberate violation of the order of the court. And the learned trial judge went so far as to observe that the conduct of the parties and their counsel was not at all praiseworthy. Full stop. Next para, not stopping there, the learned trial judge held that he was not inclined to show any soft attitude towards the petitioners, and accordingly dismissed the matrimonial suit itself, which arose out of the section 28 application, for non-compliance of the specific direction of the court. Full stop. Next para, such attitude of the learned trial judge is strongly deprecated, being completely dehorse the law. Full stop. the provision under which a court, in a suit of a civil nature can send parties to mediation is section 89 of the Code of Civil Procedure, the trappings of which are applicable to a matrimonial suit as well. Full stop. Under the said provision, if there are elements of settlement involved in a dispute raised in a suit, subject to the agreement within bracket and only subject to such agreement bracket closed, the court can send the matter for alternative dispute resolution, either by arbitration, conciliation, mediation, or judicial settlement by including lok adalat or otherwise. Next para, however, the consent of both parties to go for mediation is a sine qua non for referring the matter to mediation, and the parties cannot be forced against their will to go to mediation. Full stop. Next para. The learned trial judge proceeded on the palpable misconception of law that it was the duty of the parties to go to mediation, and that being forced by the learned trial judge, since the parties did not comply with the direction to go to mediation, the application for mutual consent divorce was itself liable to be dismissed. Full stop. Next para. Such opinion of the law is absolutely perverse and contrary to legal tenets. Full stop. Next para. In such view of the matter, if we take up the appeal itself along with the application for disposal with the consent of the parties, full stop. FAT 22 of 2026 is allowed on consent, we are saying. On consent, in the light of the above observations, thereby setting aside order number 5 dated January 15, 2026 and decree of event date passed by the learned additional session district judge, first court at Shialda, district South 24 Parganas in matrimonial suit number 344 of 2025, and remanding the application under section 28 of the Special Marriage Act 1954 filed by the parties to the said learned court for disposal in accordance with law, within the timeline as stipulated in the concerned statute, that is the 1954 Act. Full stop. No address to cost, urgent certified copies. The trial court as well as the parties and all concerned shall act on the server copy of this judgment without insisting upon prior production of a certified copy for the purpose of compliance. Full stop. Can 1 of 2026 is consequentially disposed of as well. No address to cost. Certified copies, urgent certified copies. Thank you.
Well, may there be a timeline framed because we have
Statutory timeline that we have. There is a waiting period also, so that has to be seen.
Great.
Now, what you want?
41, my lord, I am on behalf of the appellant, my lord. Let's suit
Lord,
for.
I appear to have responded, my lord.
Let's suit for.
Can't see you. Yes, now you can see. Right. Yes, very well. Yes.
Let's suit for eviction. The suit was decreed. I am the defendant before the court.
The deficit court fees you have put in?
I have paid. It was paid on 9 July. And I am showing the case status, my lord.
After line at court, no, give it to me. At the outset, learned counsel for the appellant submits that the deficit court fees have been put in on July 9, 2026. That is a day after the report of the stamp reporter to the contrary effect. Full stop. The office shall furnish a revised report in that regard. Yes, the application is taken up for hearing. What is it?
The application
it has not been served upon us, my lord. Kindly.
Not been served, that's it.
My lord, the application for stay, my lord, they are proceeding with the execution of the degree. But because this is a suit for recovery of possession, I have filed this application for stay.
No. When is the next date?
No, the next date is fixed recently in the 5th bench because the police help application has been filed. I have registered.
When is the police help fixed, Mr. Mishra?
My lord, I will not be. The trial court advocate is there, my lord. I am not appearing there. The learned advocate record will be able to assist in that regard. My lord.
You are the advocate record. Assist.
No, Mr. Modi, I am extremely sorry.
Yes, Mr. Modi, when? Police help.
No, my lord, we have not been started with any of the appeal.
When is the police help application fixed in the executing court? Your police help.
I'm really no
Not sure. There is no caveat in the matter.
No.
No, there's no
There was no
caveat.
caveat.
So we'll take up the application and direct them to serve a copy on you.
Yes, my lord.
No difficulty in that.
But till such time, the limited protection may be given, my lord.
What is the decree for?
The degree for eviction.
Eviction on the ground of trespass.
2G. My lord, they have invoked
2G.
2G. My case at
What is your case? Prima
Lord,
facie
no.
case you have to
My lord, my prima facie case, my lord, previously the tenancy was in the name of Dhakeshwari Bhandar. At that point of time, the Dhakeshwari Bhandar was obtained by my father. He was doing business.
Sole proprietorship.
Yes, my lord. After her death, my lord, they have granted a tenancy solely in the name of Dhakeshwari Bhandar. And my lord, Dhakeshwari Bhandar, after the death of my father, I have obtained. And my lord, they have repeated accept the bill. And my lord, when the cross examination was held, they have accepted.
But
that
difficulty is sole proprietorship is no
Lord,
separate
but the tenancy
jurisdiction.
has been changed. My case that the tenancy has been changed previously in the name of my father.
Even if it is in the name of Mrs. Dhakeshwari or whatever, if it's a sole proprietorship, law does not recognize it as a separate juristic entity.
But well, after the death,
So therefore 2G would
absolutely.
apply.
But well, I have informed. After the death, they have issued a bill, and my lord, when the cross examination was held, they have accepted the bill that we have issued the bill. That is my case. But they have accepted
The
all
pendency of the
my lord,
suit.
4 years. My lord, 4 no. My lord, before the suit, my lord, 4 years they have issued a bill in my name, and all the bills were marked as without objection.
What is the moratorium? 5 years.
5 years.
So within that they have received.
My lord, no, after 5 years, my lord, they have issued a bill continuously. I will satisfy to your lordship. My lord, and all the bills were marked on admission.
Have you annexed
On
those?
the part of the no, because it's no, my lord, it's not annex. Because when in the stay application, I have annexed the plaint as well as the written statement. Well, I will satisfy my case with regard to the bill and the other aspect is concerned.
But we don't have those. Those were marked as exhibits.
It was marked as exhibit on admission. That they have accepted. I have showed him the bill.
Annexed those at least. And you should have you taken this as a ground? Those are marked as exhibit.
Yes, my lord.
No, marked as exhibit you can find. No, board resolution. But no. Tenancy receipts. Yes. Carbon copy of rent receipts. No, exhibit A, B, A series.
Yes, but there are numbers. Yes.
4 rent bills. You give them a copy and come back tomorrow. Since they're appearing.
Give your response.
Since we are you're Mr. Mishra.
Yes, madam. Yes, madam. Can it be kept day after tomorrow, Willets?
No. Tomorrow.
We'll be there.
Mr. Mishra, along with his learned advocates on record, appears and submits that he has instruction to appear for the respondent. Although no caveat has been lodged, for the sake of propriety, we direct the learned advocate on record for the appellant to serve a copy of the application on the learned advocate on record appearing with Mr. Mishra. Here and now, can you give it?
Well, I will make a Xerox
during the course of the day. During the course of the day, first up, the matter shall be listed tomorrow under the same heading. So I'm sure we cannot give more time to you because day after tomorrow we'll be taking up hearing matters.
I understand.
Then it will go to next week, which will be difficult.
We'll get them.
I'm great.
Please ensure that a copy is given to you.
I'll give.
Yes. Statistically, you should lose now. Yes.
Yeah, my lord, we can't lose both the appellant and the respondent.
He's supporting your case.
Mutual divorce, my lord.
Oh.
Kindly see.
Again on the ground that it did not go for mediation or what?
No. Kindly see the my lord, drastic order has been passed, my lord.
Drastic order? What drastic order?
My lord, I was, my lord, about to be sent to my lord jail. The learned trial judge, my lord.
What did poor you do?
Yes, kindly see the impugned order, my lord, once. Yes, since your lordship had passed an interim order, my lord, police stops chasing me.
why was it section 28 or 13B?
13B.
Why dismissed?
Dismissed, my lord, on the ground that, my lord, when the when the parties were married.
Let the ringtone complete. Yes, now it's over. Yes.
My lord, when the parties were married, the wife was, my lord, 15. Underage, 15 years and 9 months, and when the child was born, the lady was 17 years and 9 months.
So what?
Since the marriage itself is null and void.
Null and void. Underage
That is
null and void.
and my lord, not only that, the learned, what he has done, my lord, is something, my lord, which is unheard of, my lord, by a court. My lord, my lord,
Directed registration of
FIR by whom? My lord, kindly appreciate. I have taken specific instruction from my counterpart in the trial court. He, the learned judge, my lord, he is the special court under POCSO. He is the complainant. I will be arrested and produced again before him.
He is the POCSO
He
court?
is the special court under POCSO. I have taken specific instruction, my lord, from the learned advocate in the trial court. And my lord, few, my lord, provisions of law, my lord, I will be, my lord, showing to your lordship.
Hindu Marriage Act. Hindu Marriage.
No, my lord, first, my lord, the Prohibition of Child Marriage Act.
We will look into that. Hindu Marriage Act to POCSO এখানে আছে কি? POCSO থাকবে না। Hindu Marriage
Act নিয়েছো?
No. Thank you.
আচ্ছা, প্রথমে হচ্ছে
ছেড়ে দিয়ে নিচ্ছিলেন POCSO, which provision you will be relying on?
Yes, my lord, POCSO, my lord.
Section 31.
Section 31.
You read out that section.
My lord, I am reading. No, my lord,
Not section 31.
Information.
Yes, information, there is a provision. You will just check.
Section 19.
19.
Reporting of offense.
Give us half a minute. No, keep the book with you. We'll just.
Section 2196 of BNS system.
Yes, reporting of sorry.
219. BNS.
1 minute. Yes, reporting of offences.
My lord, kindly see, my lord, by whom?
Yes, yes.
Notwithstanding anything contained by the Code of Criminal Procedure, any person, including child, who has apprehension that offense under the act is likely to be committed or has knowledge that he has offense or has been committed, he shall provide such information to A, Special Juvenile Police Unit, or B, local police. 2, every report given under subsection 1 shall be ascribed an entry number and recording in the writing. B, read over to the informant. C, shall be entered into the book to be kept in the police unit. My lord, this is what, my lord. Then, my lord, whether where the report under subsection 1 is given by a child, the same shall be.
No, but any person includes the judge also.
That
otherwise, it's bad on a different ground because he will be the judge, jury, executioner.
Exactly.
But that's a different proposition.
Whether any person will include the child, my lord, that is any will include the judge. My
Why not? Any person, judge is not a person.
Definitely, my lord. But whether in these proceedings.
A person is a person in any proceeding. No proceeding is
required. Not a 156 clause 3 or a complaint case otherwise under 200.
No, any person who has knowledge of this, why shouldn't he be able to inform? That is a high ground you are taking.
219.
But yes, if he is himself the POCSO court, that acquires a different color.
Yes.
So he will be deciding the issue.
I will be produced before him. He will reject my bail application.
Yes, a prior formation of opinion.
Exactly. Now, my lord, kindly see, my lord, section 209.
19. Section 6.
What was the age of the husband?
Husband was, my lord,
18.
No. Yeah.
What was your age? There will be a difference in our mind if your age was suppose 65.
24 years.
At the time of marriage.
At the time of
you are 24. She was,
my lord, 15 years, 9 months. And when the marriage took place and when the child was born, the lady was 17 years and 9 months. Date of marriage. Now, my lord, kindly see, my lord, 219 subsection 6.
Read with section 31 of POCSO.
উল্টে রাখো ওনারা কিন্তু বন্ধ হয়ে যাবে
TRPC এটা applicable for POCSO তে।
হ্যাঁ হ্যাঁ তাতে কি হয়েছে?
না না ওইটা থেকেই POCSO তে ড্রপ করে 6 মানে বলছে after elapse of one year হয়ে গেলে
এটা শিওর তো ওই পক্ষ করলো
হ্যাঁ
ওই ওরাই বলেছিল
এই
এটা কি
no court shall take cognizance of an officer 64 of BNS টাকল তো BNS করবে বসুন না
না void
punishment for it.
yes
19 subsection 6.
একটা বই আনা হয়
yes
Kindly see,
no court shall take
kindly see the word wife is there.
Date of marriage হবে
Date of marriage হচ্ছে
what is section 64
64 is rape.
See, 64 my lord is punishment for rape.
so this is not such a case he's not
Even
asking you
even if my lord we take it
this
that
is for child marriage
yes my lord
prohibition of child marriage act is also
yes
there
yes
not
yes.
why
Section-
POCSO
section
he
3
has directed under POCSO to be
yes
registered.
yes yes.
Could have been prohibition of child marriage act
No, that is also voidable at the option of the party section 3.
you're right lecture distribution
No, my lord,
because this is one of the features which has been introduced now. That is what we have been lecturing people on. I mean, that this now it has been made voidable a bit better, but still at the instance of the parties when they become.
and my lord, the annex the affidavit in chief of the wife and the mother of the wife. My lord, all my lord consented to my lord the dissolution of marriage by mutual consent. And
Wife was the applicant
and
number
my
one.
lord, the marriage date of marriage was 1st of May 2013. Even if my lord we take
It's
it,
like prosecution for theft when you are going to return the stolen articles. It's like that.
my lord, if we my lord take the date of marriage as the commission of offense 1st May 2013, then my lord 219(6) says my lord, even if it is wife, then my lord within 1 year from the date of 1 year
So the court says protection of child, POCSO.
POCSO, and my lord, he has also said that it is void. The marriage is void
That's
under
void.
the child restraint.
Prohibition of
Yes.
he has not said void.
Kindly see, my lord,
Suit is
it
hereby
is
dismissed.
found that the application for mutual
Ordering portion says hereby dismissed on account of marriage being solemnized in violation of prohibition.
yes, kindly see, yes. As such, the date of solemnization of marriage, the petitioner number 1 was 15 years, 9 months, and 22 days, and as such, it is found that marriage in question was solemnized in violation of the prohibition of the child marriage 2007 as well as the Hindu Marriage Act 9 and punishable under both legislation.
But Mr. Bhattacharya, suppose if he does not take up the
This is Millard 13B, Millard, but both the parties are Millard consenting
Wife
Millard
is
for
the applicant number one.
Millard. I
no,
don't
but we were wondering something else. This is a new aspect of the matter. We have never come across such a. But this under section 19, that liability to POCSO, the liability to give him from reporting offense, report offenses is cast on any person.
Any
No, we have
person.
have it. Yes, any person. So I shouldn't a court if the court finds it's all the more liable to responsible for reporting this.
Yes, Millard, kindly see, Millard, notwithstanding anything contained in the Code of Criminal Procedure, any person included who has apprehension of that the offense under act is likely to be committed or has knowledge
No, it has to be an offense under this act.
It has to be an offense under this act.
No, offense under this act has been made out also.
No, the kind affidavit in chief, my lord. And my lord, there is a child, my lord, now 9 years, now 15 years. Therefore, my lord, both the parties, my lord, never intended this as an either 219 subsection 6 or, my lord, this POCSO Act.
But disposing of the appeal. In view of the short ambit of the appeal, comma, we take up the appeal itself for hearing along with the application on consent of the parties. So, sub next para, by the impugned judgment, comma, an application under section 13 capital B of the Hindu Marriage Act 1955 filed by the parties for divorce by mutual consent was dismissed on the ground that the marriage between the parties was solemnized in violation of the Prohibition of Child Marriage Act 2006. Push up, not stopping there, comma, the learned trial judge directed a copy of the order to be sent to the officer in charge of the Bhagwanpur police station to treat the same as an information in terms of section 19 of the prohibition of offences against children, POCSO Act, POCSO Act, and register a case on the basis of the same and take appropriate action in accordance with law. So, next para, learned counsel for the appellant argues that it was entirely beyond the jurisdiction of the court, trial court, to pass such directions while sitting over an application for mutual consent divorce under section 13 capital B of the Hindu Marriage Act. Next para, that apart, comma, on merits as well, comma, no offense under the POCSO Act having been made out, comma, it is doubtful as to whether the court could be construed to be a person, to be construed to be double inverted any person liable to report such a non-existent offense within the contemplation of section 19 of the said act. Moreover, comma, even under the Prohibition of Child Marriage Act 2006, comma, child marriages are voidable at the option of the contracting party, comma, being a child. In the present case, comma, since none of the parties sought a declaration to that effect, comma, the learned trial judge, comma, it is submitted, comma, transgressed his jurisdiction in passing the impugned judgment. Next para, moreover, comma, it is argued that the provisions of section 13 capital B of the Hindu Marriage Act does not permit such a course of action to be taken. Next para, learned counsel for the respondent adopts the arguments of the appellant and agrees to the impugned judgment being set aside and the mutual consent divorce petition to be decided on merits. Next para, on a bare perusal of the impugned judgment, comma, it is evident that the same is palpably contrary to law. First, comma, the court taking up an application under section 13 capital B of the Hindu Marriage Act is governed by the parameters of the said provision and at best, comma, the provisions of the said act. Within such limited conspectus, comma, the learned trial judge acted beyond Dehor's jurisdiction in passing the directions regarding registration of a criminal case under the POCSO Act against the appellant. Appellant is a husband. Against the appellant husband. Full stop. Next para. Under the said provision, under section 13 capital B of the Hindu Marriage Act, comma, the court was only to ascertain whether the yardsticks and tests laid down therein are satisfied, and comma, upon such satisfaction, comma, to pass a decree of divorce by mutual consent. Full stop. Next para. Secondly, comma, there is no provision within the four corners of the Hindu Marriage Act 1955 declaring an underage marriage to be either void or voidable. Full stop. As such, comma, within the four corners of the said statute, comma, under which the application before the trial court was filed, comma, the learned trial judge did not have jurisdiction to adjudicate on the said issue at all. Full stop. Next para. Thirdly, comma, even under section 3 of the Prohibition of Child Marriage Act 2006, comma, a child marriage is voidable at the option of the contracting party, comma, being a child. Full stop. In the present case, comma, since none of the parties sought for a declaration of the marriage to be void, comma, rather having sought for a divorce, comma, thereby implicitly admitting that there was a valid marriage, comma, the marriage between them could not be held even to be voidable. Full stop. Next para. Even otherwise, comma, we do not find from the four corners of the petition under section 13 capital B of the Hindu Marriage Act that even any semblance of any offense under the POCSO Act was alleged by any of the parties against the other. Full stop. In the absence thereof, comma, the learned trial judge acted dehors jurisdiction in taking it upon himself to act as a person within the contemplation of section 19 within bracket 1 of the POCSO Act and reporting such non-existent offense to the concerned officer in charge and directing the registration of a criminal case in that regard. Full stop. Next para. Even that apart, comma, no case under section 219 of the Bharatiya Nagarik Suraksha Sanhita 2023 has also been made out in the present case. Full stop. Next para. We also take note of the joint submission of learned counsel for the parties that the learned trial judge himself has been functioning as the POCSO court in the concerned district, and as such, comma, by directing a complaint to be registered under the said act, comma, the trial court would be mechanical in ensuring that he himself would be the complainant in a case which would ultimately be brought before him for adjudication. Full stop. Such a mode of function, such ingredients vitiate the entire action, comma, being dehors cardinal tenets of natural justice, that a person cannot be judge of his or her own cause. Full stop. If the complainant himself becomes the judge adjudicating on the merits of such complaint, comma, it would be a travesty of justice, and the judge himself would be acting as judge, jury, executioner, comma, all rolled in one, RLLET, rolled in one. Full stop. Hence, comma, the impugned judgment is bad in law on such count as well. Full stop. In view of the above, comma, this court is of the opinion that the impugned judgment cannot be sustained for a minute. Full stop. Hence, FA 46 of 2026 is allowed on consent, comma, thereby setting aside the impugned order number 3 dated December 23, 2025 and the judgment of event date passed by the learned additional district judge, first court at Kontai, district Purbo Medinipur in matrimonial suit number 117 of 2025 and remanding the application filed by the parties under Section 13 capital B of the Hindu Marriage Act 1955 for a fresh adjudication on its own merits in accordance with law. In the light of the above observations, for sub next para, the learned trial judge, while so disposing of, shall adhere to the timelines stipulated in Section 13 capital B of the Hindu Marriage Act. For sub next para, any action, if taken in the meantime, pursuant to the impugned judgment, including registration of a case and or complaint in terms of the same, stands hereby revoked and cancelled, and shall be reversed by the concerned authorities by acting on the server copy of this judgment without insisting upon prior production of a certificate copy. Can such 1 of 2026 is accordingly disposed of as well, no rest to costs.
Client to fire us though.
Yes.
I was asking him to ask the client to come back to Kolkata now. Jharkhand. Jharkhand.
ওইগুলো ফেলছে। আচ্ছা প্রথমে না একটা এটা হবে আগেরটা যে এফিডেভিট সাইজ ফাইল থেকে গেট করলো এখন যেটা
Yes. Item number 37, that is the mistake of the copying department, I am told. And the original, the appeal.
File a recall application, we have passed our judgment. Yes.
What to see, my lord, I am for the appellant. I am for the response.
Yes.
My lord, a probate application, my lord, filed by one of the executor has been, my lord, held to be not maintainable. In view of, my lord, that the other executor filed a probate application previously, my lord, subsequently died, and as such, my lord, that probate application was dismissed for default. My lord, the learned code is of the opinion, my lord,
No, the previous probate application was dismissed for default.
Default.
On death.
No, not on death.
They did not take any steps. That is why, my lord, dismissed for
the other executor, he did not take any step.
Yes. Not he, my lord. Both were, my lord, both were filed. Both
had filed together.
Yeah, both had filed together. Subsequently, one of the
One died, but he did not take any step.
No, nobody.
No, my lord, the other executor did not file. It was filed by one of the brother.
No, that is not in the order sheet. Can you see the order sheet?
My lord, I'm talking about instruction, my lord. One of the brother filed, he died. Subsequently,
you were the beneficiaries as well as the executor.
As well as the executor.
Both the brothers.
Both the brothers. One of the brothers initially filed.
The other brother.
Not the other brother. Yeah, my lord, he died. Subsequently, that probate application was dismissed for default. And my lord, after a period of time, my lord, the other brother filed, being the other executor. And my lord, that application, my lord, has been held to be not maintainable. Kindly, my lord, take some, my lord, the order once.
In the first line of the order sheet, it is very much clear. By filing the instant petition, opposite party number 1 submits that the petitioner in association with his brother, namely Gopal Mollik, by filing one miscase.
You are right. You are right. Yes, Mr. Banerjee.
My lord, I'll just indicate.
Absolutely right.
My lord,
your learned friend is absolutely
kindly, my lord, takes up my application, my lord. There is no objection to that effect, my lord. I can, my lord, produce. I don't know whether, my lord, my client.
See the first sentence of the impugned judgment. By filing the instant petition, opposite party number 1 submits.
My lord, be that as it may, my lord. My lord, I am, my lord, supported by a judgment which.
Why opposite party number? Oh, maintainability. Maintainability petition was taken out.
Maintainability petition was taken out by them.
Oh, it's their contention that both of you filed.
Their contention.
Have you got a copy of the previous one? That would
that, my lord,
either of you give a copy of the previous one.
No, that was not.
You allege he denies, none of you have a copy. So how can you know either of you?
My lord, my specific case is, my lord, that. And my lord, be that as it may, my lord.
Both of your specific cases are without you looking into the papers.
No, my lord, kindly.
How can you be so sure about that? You are submitting before a court, Mr.
My lord, that
both of you.
Unless
you have seen that application by yourself, how can you submit even?
Yes.
You based on your applications. If all clients were truthful, then there would not be any litigation in court.
That is true. That is true.
Either if you must have been wrong. Counsel should act as a screen.
My lord, may I place, my lord, my application, my lord?
Present application.
Present application, my lord, the averments in my.
So let us first see the impugned judgment, then we'll
Yes.
go back. There is no section 5.
There's no section 5. Well, the defect was with regard to, my lord, 25 rupees of court fee was deficit, my lord, that I have paid.
Further terms judgment in
একই জিনিস নাকি?
সাকসেশন একটা দাও তো এই উপরটা লাভ দিতে গিয়ে পড়ে যাবে সিভিল কোড অ্যাপ্লাই করে একটু জায়গাটা একটু previous application copy was necessary.
Yes, my lord. It is not here.
My lord, may I submit only one thing, my lord? But I'm, my lord, supported by a judgment which says, my lord,
So this should not apply to an in-rem action.
yes.
That we agree. But in addition, we want to look into that also. That will be another ground.
That will be another. What I've taken
That will
both.
be another ground.
I've taken
If both grounds are available to you, while restrict to one. Suppose we hold that subject to hearing, your learned friend. We have our reservations. We are making it open to you also. We have our reservations as to, yes, as far as applicable, 295 says that civil procedure code will apply. As far as applicable, we want to read into that. Actions in REM have a larger ramification, operating in the whole world, as you all know, as we all know. So, but therefore, Order 9 Rule 9 pertains to a personal cause of action, that the plaintiff shall not be entitled to file another application,
Yes.
another suit or application. Now, whether that applies in a judgment in REM, because it's not his personal cause, but the wish of a deceased person. So that has a wider ramification. We want to deal with this, decide that Order 9 Rule 9 regard would not apply. If he has an additional ground that it was a different person, if either of you also, if you find that we know, we have confidence that you will point out to us.
Yes.
If it was another person, then in any event, Order 9 Rule 9 becomes more diluted, because it's not him that is filing it, the other executor. So just ask from your clients that application and come back tomorrow.
My only difficulty will be, my lord, that I don't know whether, my lord, that application is at all available with my client. Then, my lord, the only remedy would be, my lord, taking out a certified copy of the 2017 application, my lord.
That would take time, even if you, yes.
7 days time can be given, I will say.
Either of you. The short question involved in the appeal is whether the learned testamentary court was justified in dismissing the appellant's application for probate of a will on the ground of bar under Order 9 Rule 9 of the Code of Civil Procedure. Pushap learned counsel for the appellant argues that contrary to the contention of the respondents, who took out an application challenging the maintainability of the probate application, the earlier probate application was filed by the other executor than the appellant, who met his demise and subsequently the earlier probate application was dismissed for default. Full stop. Thus, it is submitted that the bar under Order 9 Rule 9 would not be applicable to the present appellant, who was not a petitioner in the earlier proceeding. Full stop. Such contention is controverted by learned counsel for the respondents on instruction. Full stop. However, since a copy of the said earlier probate application is not available with either of the counsel, we request learned counsel to produce a copy of the same on the returnable date. Full stop. Another interesting question involved in the appeal is whether the rigors of Order 9 Rule 9 of the Code of Civil Procedure would be applicable in an action in rem in view of the wider ramifications of such an action, where the cause of action contemplated in Order 9 Rule 9 of the Code is not restricted to a personal cause of action, but is in effect the endeavor on the part of the executor stroke propounder to bring to the notice of the court the fact of the will, upon which ratification to such will is merely granted by the court by way of probate. Full stop. In any event, in view of our above request, let the matter stand adjourned till July 27, 2026 for production of a copy of the earlier probate application.
Grateful.
We have recorded also so that we don't forget on the next.
Grateful.
As far না সেটা তো প্রথম গাউন যদি আলাদা এক্সিকিউটিভ একটা অর্ডার লাইন মূল্যায়ন বার দ্বিতীয় করব কল কর 44
Item 44, this is my appeal.
Yes.
And advocate on record for respondent number 1 and 2. I have been requested to pray for.
Who is appearing for them?
This is the affidavit of service.
Who is appearing?
Momita Ghosh. Well, she is ill, kindly adjourn for 2 days.
We generally don't grant adjournments. Is there a caveat? You have you have served.
We have served.
What is the appeal against?
Milords, this appeal arises out of a decree where my suit for partition has been rejected, Milords. On the last
Your partition suit is dismissed.
Yes, Milords. On the
what do you want now in the application?
Milords,
There's a condonation, there's a delay.
5, there's a section
Then we need to hear her. So when will she?
3 days. 3 days.
The next Monday we are fixing?
As you like.
Milords, in fact, one submission, Milords, there were certain other respondents who were not appearing before the learned trial court. So we have served, but the service is not affected in this.
No, the difficulties in a partition suit all are in the footing of a plaintiff. That is
Milords, however, they were suggested to make parties in the trial court because their property was adjacent to my property. However, they are no.
It's bad for misjoinder also.
Milords, in
The
fact,
misjoinder is not a ground for dismissal of a suit. Non-joinder is. So who have been served and you are appearing? She is appearing for 1 and 2. 1 and 2 are the main.
1, 2, and 3 they appeared before the learned trial court as well.
3 has been served.
3 has been served.
Achha. So should we dispense with service on the others? At your own risk, we'll do that.
Milords, in that case, Milords, as an abundant caution, Milord may direct a substituted service, Milords.
No, substitute service is not required. They did not contest the suit.
No. Written statement was filed by 1, 2, and 3.
We are dispensing with service, unnecessary. Affidavit of service filed to be kept. We are granting it. Affidavit of service filed to be kept on record, from which it transpires that respondent numbers 1 to 3 have been served. Since it is only those respondents who contested in the trial court, service on the other respondents, being respondent numbers 4 to
2012 has refused.
4 to 21 is dispensed with. Full stop. প্রথম সেন্টেন্সে যেখানে বললাম have been served বললাম, রেসপন্ড নাম্বারস 1 to 3 have been served. ফুল স্টপ দিয়ে আরেকটা অ্যাড করে দাও. Respondent the intended the envelope sent to the respondent number 12 has returned as refused, which also amounts to good service. ফুল স্টপ তারপর যেটা বলেছি যে only respondent numbers 1 to 3 contested. dispensed with. That is respond numbers 4 to 21. Full stop, next para. At this juncture, comma, an adjournment is sought on the ground of illness of the learned advocate for the respond numbers 1 and 2. So accordingly, let the matter stand adjourned till July 27, 2026. The affidavit of service filed to be kept on.
Let's maybe fix in the month of August if any possible.
Why?
Let's 28 July.
27th, you have some problem?
Yes, Milad.
July 28.
Listen, one more submission Milad. On the last order, Milad, even respondent number 13 has refused the service.
Why are you saying piecemeal?
This to be
12 and 13 both?
Yes, Milad.
12 যেখানে বললাম ওখানে 13. 12 and 13 refused.
And the envelope to be kept on record.
Envelope, affidavit of service and envelope filed to be kept on. Next.
So grateful.
You please give your name. Sir, you please give your name. Only your name. Yes.
My lord,
I appeal for the respondent.
it's a suit for divorce, my lord. The petitioner before your lordship, my lord, is the wife. Now, my lord, lordship, my lord, had granted an injunction, my lord, restraining the husband, my lord, from remarrying.
He has
And, my lord,
remarried in the meantime.
Yes, my lord, in the meantime, and thereafter, my lord, we had filed
He has remarried.
No, he has not been remarried. Now, my lord, we had also, my lord, filed an application for alimony pendentility. Now, my lord, affidavit of assets and liabilities have been filed by both the parties. Now, my lord, if your lordship takes up the affidavit of assets and liabilities, husband is a pensioner. My lord, he has disclosed it, but his pension is 63,000 rupees per month. Now, my lord, the wife till March 2026, my lord, she was paid 10,000 rupees a month. Thereafter, my lord, the payment has been stopped.
You have challenged the divorce decree, obviously.
Yes, my lord, I have challenged the divorce
March 26, the divorce decree was passed.
My lord, the divorce decree, my lord, is dated, my lord, 22nd December 2025. 12th December
So you are being
2025.
paid that 10,000 rupees as per some 125 order or
My
something?
lord, in the trial court, my lord, I was being paid 10,000. My lord, even after the
Carried
decree
on
of
after
divorce,
the.
he carried on.
No 125.
No 125.
Obviously, no child.
There is, my lord,
no minor
if
child.
there is no child, my lord, with the earlier marriage, he has a daughter.
That he's not.
No, my lord.
So therefore, he earns 63,000 per month.
Yes, my lord, kindly takes up his affidavit of assets and
So
liabilities.
let us proceed on that premise for the timing, unless Mr. Bhagat will revert.
63,000, my lord, he is getting his pension.
Pension. That is the gross amount.
Gross amount.
Acha, what is your claim in the alimony application?
My lord, 10,000 rupees per month. My lord, whatever I was being paid by before the learned trial.
You have not.
No.
Mr. Bhagat, it seems to be a fair claim.
No, my lord. What happened? He has, my lord, concealed his income, her income, my lord. My lord, I have filed the opposition to their, my lord, affidavit of assets, my lord.
So you have annexed something.
Yes, yes, my
lord. What does she
yes, my lord, I
do?
suppress everything, my lord. Even his name, her name, even, my lord. He has attached to the bank account, which does not belong to her.
Deepti
My lord, I
Mujumdar.
have taken the exception to his affidavit, my lord. Kindly see my affidavits. First, he places his affidavit, thereafter I shall.
But kindly takes up my
kindly
affidavit.
place-
No, 63,000 pension you are admitting.
No, my lord. The-
And he has stated in his affidavit of assets and
You are not getting 63,000 as pension also.
My lord, kindly allow me few seconds, my lord.
His case is only that. Then you will hear your case and then his rebuttal.
My lord, kindly seize my affidavit of assets.
No, you tell us whether you admit that you earned 63,000 as pension.
No.
No, that's very. Your affidavit of asset.
Well, kindly allow me some time.
Your affidavit of asset we have.
Yes, I find.
Which page? Which page, Mr. Das?
My lord, he has only served me, my lord, with a copy in the email. He has not served me any physical copies.
So what?
Nothing. No.
My lord, it is
But Mr. Pratik Bhattacharya, I have repeatedly requested him, but he is giving me part pages, my lord, in emails.
Oh, Mr. Bhattacharya.
yes, he is the
No, but which page you should know?
But may I
Soft
take-
copy contains the pages also, Mr. Das. Where are snatching his copy?
several pages.
Unimaginable.
From his copy. I can show it from his
You're snatching it away from him. Strange, Mr. Das.
My lord, he has stated, my lord, in his income that is
After
pension is
4 p.m. something happens to all of us. You're not accustomed to working after
এই যে আগের
3:30.
page টা, আগের page টা। আমি Lordship would take up, my lord, page 6, page 7.
7.
Lordship. Kindly see, pension received is 63,000.
Yes, in bold letters you have admitted.
63,000. And my lord, kindly sees the expenses.
Then we cannot rely on you on any of the other submissions. If you don't know your pension, it's bold letter, it's written.
Sorry, my lord, because it is Mr. Bhattacharya's brief.
But now you are appearing before the court.
Well, I got some only, my lord, yesterday. Only, my
lord, my claim is 10,000 I was receiving. My lord, my claim is 10,000.
This case, Mr. Bhagat, are you ready in the matter? Should you take it up tomorrow?
Yes, my lord. Kindly take tomorrow.
And may I take a copy from him in course of the day, a physical copy?
Not in the mode you are taking.
No, my lord, I shall but formally request him and take.
Get it formally, yes. On the prayer of learned counsel for the respondent, the matter is adjourned for the day. For substance, learned counsel for the appellant submits that he is not posted with a complete copy of the pleadings of the respondent husband, comma, learned counsel for the respondent is requested to furnish copies thereof to the learned advocate for the appellant during the course of the day.
আমি Xerox করে আপনাকে দিয়ে দিই।
You pay for the Xerox. That's a penalty for your. Yes. Yes. Yes, dismissed. You are appealing for the respondent, then allowed.
Lordship, I am on behalf of the.
You have moved several matters from the morning, Mr. Bhattacharya.
8th one.
Now it will appear that you are a talisman in the court.
8th is the 8th one.
So you cannot take that risk.
Lordship,
Yes.
kindly grant
No,
me-
prayer for adjournment refused. What is the matter?
Lordship, I am not chamber junior.
Then we dismiss for default.
And on the last occasion,
Advocate on
Lordship-
record. Advocate on record.
Who is that? The advocate on record?
Angshuman Chakraborty, his father suffering from
Mr. Angshuman Chakraborty, his father, what happened to his father?
hospitalized in the
Then-
prison
We'll keep it when? Tell us.
next week.
On the prayer of learned counsel for the appellant in view of the personal difficulty of learned on the prayer made on behalf of the appellant on the ground of personal difficulty of learned counsel for the appellant, comma, let the matter stand adjourned till July 27, 2026. You please give your name only. Yes, Mr. Bhattacharya, come back. Pencil. Dako. Yes. Yes, Mr.
This morning, I found that my application is defective. Can 2, this page.
And for the respondents.
Yes. Defective means?
Can 2, this page is not typed. Was in my copy at least. I don't know what
Which
is
page? What is the page?
Page 10 of can 2. This will be the correct page. Yes.
No, the prayer portion.
Yes.
Yes,
Yes, that is not correct. This will be this page.
What is the
4
difference
lines-
between the two?
These 4 lines.
Please
has
compare
not-
and say what is the difference. We won't sit and compare then. What is the difference between the two?
Prayer, full prayer is not there. Full thing.
What
has
is
not
what
been
are the
typed.
differences? Give us a chart of the differences.
Under the circumstances, we pray before lordship, that is not there.
Acha dekhi.
In the prayer.
Give it.
This will be the original.
Then
Yes, I have to give them.
Gupta also has.
Today morning I have seen this. This is discovered. It is just
Oh, we thought it started from such.
the wrong printed page.
Yes, Mr. Gupta. Basically, he has paid for stay of the judgment.
No, this is for leave to
prefer the
appeal against the dead persons who had died after the preliminary degree and before passing the final degree.
Mr. Gupta, do you oppose this application?
I'll just take 2 minutes. An earlier application, they had moved leave to file this appeal without the copy of the decree, which your lordship had rejected.
That is on a different
Yes.
footing. Yes.
But now we have no copy of the decree. How can this proceed? They have still not filed it.
No, decree
Decree has not yet been drawn up. We have
Yes, nobody knows.
Cost was
How
deposit.
appeal could be drafted also, I don't know, your lordship. Without.
Then we cannot also ascertain whether the appeal is in form.
appeal can be passed on judgment. We have given the copy.
All of us know, Mr. Shah, that appeal can be filed with a judgment.
Your
But
lordship
according
said-
to the matrix is that appeal can be filed, it will not be time barred if it is filed with the judgment as per order 41. But our rules still say decree has to be filed, otherwise it will be defective. Because of the simple reason that unless the decree is filed, we cannot, in other matters, this is what? Matrimonial.
This is partition suit.
Partition suit, valuation cannot be ascertained. And also more importantly, the name of the parties, everything depends on the decree. So without that, it cannot be ascertained, the appeal is not in form. So first file the decree, he has a point there.
Decree had not yet been drawn up.
Let it be drawn up, let it go out of the list. When it is drawn up, you file it, then we'll take up. At the outset, learned senior counsel appearing for the respondents points out that as per previous leave granted by this court, the certified copy of the impugned decree has not yet been filed. Full learned counsel for the appellant submits that the decree has not yet been drawn up. Full however, unless the decree is filed, the appeal remains defective and no effective order can be passed therein. Moreover, the veracity of the cause title of the memorandum, the names and particulars of the parties as well as the valuation cannot also be ascertained in the absence of a certified copy of the decree. Hence, let the matter go out of the list for the present with liberty to the parties to mention for inclusion in the list as and when the decree is filed. Certified copy of the decree is filed in the department. Upon such certified copy being filed, the office shall furnish a revised report in that regard. এখন out of list. Mr. Acha, very well. A correct copy of page number 10 of Can 2 of 2026, which is handed over to the court, be kept on record. A similar copy be handed over to the learned advocate on record for the respondent during the course of
I've already
be handed over, has been handed over. During the course of the death has been handed over to the learned advocate for the respondent here and now. ওটা ক্যান টুটায় ঢুকিয়ে রেখো তো পরে 10 পাতে দাও 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 yes
My lord, I am appearing
দাও
for
আগে দেখে না হয়
appellant led by Mr. Aniruddha Chatterjee, senior counsel, who is in online.
he is being shown by many people from the morning. We have not seen him online. Still we don't see him. We have been seeing his friends, but not him. Where is he? Where is he? He's not there.
Difficult to make out with the background.
Obnoxious comment.
My lord, this
Racist, obnoxious, bad from Mr. Kaur would not approve of that.
give a short passover. I'll
What short passover? No, at 412, no.
my lord,
Because 420 we could have considered.
my lord, this
412
matter pertain to an appeal from arising out of an order.
If you do the matter, do it full-fledged, then we'll ask our officer to take the trouble of handing this over to him.
My lord,
Otherwise, we won't take up the matter.
my
If
lord,
you
then-
do it. No difficulty. We encourage you to do it.
Tomorrow, kindly fix. Not today.
I'm
Tomorrow,
actually
kindly fix.
supporting.
Not today.
Kindly.
No, I'm supporting Mr. Chatterjee and the prayer for not today since he is not there, my lord. Kindly.
And
take
What
it
is the prayer in the main? Mr.
Milord,
Kaur is also supporting.
No. Opposing. He's the main opponent.
I'm being sandwiched.
Milord, decree passed on the basis of admission. Order 12, Rule 6 application filed, and Milord, chance given to file affidavit. Affidavit not filed because advocate's father, Milord, was unwell, and advocate himself, I'm told, was unwell, and decree passed. Decree passed on the basis of is, Milord, a description of a property given in an affidavit or in the plaint, which is totally wrong. Kindly, Milord,
No, Mr. Kaur is for the respondent.
Lord, I am for the plaintiff respondent. My suit, that there was a previous round of litigation.
Decreed on Order 12, Rule 6.
Order 12, Rule 6 decreed because, my lord, in the written statement, they admitted that they were, my lord, occupying my property.
Yes, suit is for eviction. Or what?
Eviction. In the schedule, they admitted, and now, my lord, they're saying that the schedule was a mistake in the written statement. Anyway, I mean, Lordship will have to
I
hear the
have
matter.
sold the property.
The secondary purpose has been served.
No, under Surface Act, I have
Secondary
sold-
purpose has been served.
Not tomorrow, Milord. Some
On the prayer of learned counsel for the appellant, let the matter stand adjourned for the day. We have disposed of most of the previous matters, applications. So in any event, it will go up.
My lord, kindly tomorrow, kindly fix the time because they have.
No.
No, I'm grateful. Not
Thank
tomorrow.
Not today.
But I remember that comment. That was a good
Which one?
about the background.
Oh, that is, what did they say? Obnoxious, racist. And Mr. Kaur would not approve of that. Mr. Kaur did not hear it.
No, he has said worse things about me.
My lord, I'm for the appellant.
Yes.
My lord, I'm for the appellant, my lord. My
Yes.
lord,
You are for the respondent, obvious. Yes.
My lord, husband is the appellant here. My lord, this appeal has been preferred against decree of divorce, my lord, passed by learned court of additional
Section for how much delay?
22 days, my lord.
Hello.
Delay, my lord, I'm not sure.
Only delay. What is the reason?
My lord,
You
appellant
have
was
not
suffering
abused
from-
anybody, not found blame with advocate.
No, no, my lord, my appellant was suffering from financial difficulties and there was some
In
puja
view,
holidays.
in view of sufficient cause for the delay having been explained in the application, can 1 of 2025 is allowed, thereby condoning the delay and preferring FAT 509 of 2025. Full let the appeal be deemed to stand registered and admitted. Yes. Now you are asking for what is the appropriate order?
My lord,
Divorce decree has been granted in their favor.
yes, my lord.
Appropriate orders, why do you write appropriate orders? Where we are allowing it by passing appropriate orders.
My lord,
We'll say we are passing appropriate orders.
I stand that it is my fault.
Why do you file these applications? Oh, first priority is setting aside the degree.
Setting aside decree, my lord.
Say at the interlocutory application stage, we'll set aside the degree.
No, my lord, I am in the interim state, my lord. I am praying. It
Stay
is
here.
my fault.
Have you remarried?
Yes, my lord.
Great. There is no scope then. File a written an affidavit in opposition within a week, disclosing all those things, the
My lord-
particulars of the marriage.
My lord, if I may point out the mechanical judgment which the learned court has
No,
passed.
no, we are only hearing the stay application now. There is no scope of stay. They have already remarried.
I stand corrected, my lord.
We are keeping the application pending. They have to show before the court that they have actually married. That is a valid marriage. Some proof of that. The present appeal has been preferred against a decree of divorce obtained by the respondent wife, at the behest of the appellant husband. For sub next para. Since the judgment is in the nature of an action in rem, we are not inclined to grant stay of operation of the same. For sub next para, however, while considering whether to grant an injunction restraining the respondent from remarrying during pendency of the appeal, learned counsel for the respondent, on instruction, submits that the respondent has since remarried. As such, it would be a futile exercise at this stage to grant ad interim injunction without ascertaining the veracity of such assertion. Accordingly, the respondent shall file affidavit in opposition to Can 2 of 2025, disclosing the particulars, if necessary, substantiated by documents, as to the subsequent marriage contracted by the respondent. Such affidavit in opposition shall be filed within a fortnight from date. Reply, if any, shall be filed within a week thereafter. The application shall next be listed on August 17, 2026 for hearing.
My lord, may I, if on August 17, I have some problem.
When? Tell us.
Any day after August 18.
Well, August 17 na kore, in the monthly list of September 2026, 1 week after. Are you sure that he has married? I mean,
Yes, see. Quite.
You have seen something?
Yes.
Some document?
Yes.
Yeah. Rule number 50, I am paying not to remind.
Why not to? Don't grant not to this. Mr. Bonik is there. He's not there. You are also praying for not today.
For not this week.
Not this week.
My lord, as
You are asking for not this year, or you are also there. Why not this week?
we was directed to file our composite affidavit of opposition.
Why haven't you filed it?
My lord, due to the delayed service of that.
When did you serve? Delayed service. Affidavit of asset was served late.
Served on 22nd June.
22nd June is 1 month back. So what prevented you?
My lord,
Very well. We were granting them time because alimony application cannot be decided without their. If they fail on the next occasion also, then we'll take up.
I am also praying liberty to file a supplementary affidavit in connection with
Again, supplementary affidavit, then it will take more time. It will have to.
But
You have your affidavit of asset you have filed or you will file?
already filed.
Supplementary affidavit, then it goes further back. You are ready with the supplementary affidavit?
No, my lord. Already today I have seen.
Why supplementary affidavit?
But I have stated the income of the husband is 72,000. But I am not praying to how much amount I am paying. That is the only question.
On the prayer of the appellant, leave is granted to the appellant to file a supplementary affidavit on the returnable date with an advance copy to be served on the learned advocate for the respondent by tomorrow.
Tomorrow it is not possible. He will come.
Advance copy. You have the advance copy to be served by tomorrow. For some next para, the time for filing composite affidavit in opposition, comma to the alimony application, comma the affidavit of asset of the appellant wife, as well as the supplementary affidavit is extended for a fortnight from date, 2 weeks. Fortnight from date, full stop, along with the said affidavit in opposition, comma, the respondent husband shall also file his affidavit of assets. Full stop, next para, composite reply thereto, comma, if any, comma, shall be filed within a week thereafter. The within a fortnight thereafter, full stop. The application shall next be listed for hearing in the monthly list of September 2026.
Lord, I'm appealing for the petition. Lord, this is a Lord, I have appellant Lord is challenged Lord the judgment and decree passed in a while in which Lord does marriage. I do not know whether I'll call it annulled or divorced because the plaint is in Bengali. It says that bibaho bichhinno and batil kora hok. So, but the decree is that Lord, it says that annulled marriage has been annulled and it has been passed Lord ex parte.
Annulled on what ground?
On ground, Lord, it appears of fraud and misrepresentation.
You have not filed it. Acha. Oh, acha. The ex parte degree.
Ex parte degree.
You did not take out a Northern Idol 13. That would be the easier recourse. That would be the easier recourse.
Lord, but
you only have to satisfy the court that on merits you don't have to send. But you are taking a risk if this appeal is dismissed first.
Lord, there are two grounds, my lord, in this appeal. First is that the Order 5 Rule 20 petition, my lord, which was allowed, that was not for the requisites were not followed in respect of that because only by way of a private courier service a notice was sent.
Irregularity in service is not a ground.
And secondly, my lord, my lord, I'll try to my lord, satisfy your lordship on that. And second point is that the decree, my lord, has been passed on the ground that the submissions that are made and the amendments made in plaint does not unchallenged, goes unchallenged. Accordingly, my lord, there's no requirement to be, my lord,
proof.
No requirement to be proved because it goes unchallenged. That has not been held.
No evidence led.
Evidence, my lord, only the in chief.
That is sufficient. What else can be done?
Not, but that has not been discussed and nothing has been held in respect. Only that because it goes unchallenged and no WS has been filed, so there is no satisfaction of the court.
You serve a copy of the memorandum as well as the application. It has been annulled. We won't stay that operation. It will revive the marriage.
Unless some benefit is granted, relief is granted.
Only benefit is direction of service. The benefit is implicit in the direction. We direct you to serve a copy of the memo as well. If somebody reasonable appears for the other side, like you, then we can decide the appeal along with you. You have to put in Tolowana and of ₹4. You have not put that in. Put that in also in the meantime. Serve copies and.
No, I am told, my lord, that they are not. The husband is not yet married.
You have not asked for any.
Stay has been I have asked for.
Oh, in that sense. So no injunction has been sought. Stay we can't grant. So you want an injunction?
explicit terms, my lord, injunction has not been sought. It said the order of stay of operation of the
Very
judgment
good.
and decree.
The present appeal has been preferred against an ex parte decree annulling the marriage between the parties. Full stop. Although, comma, since the impugned judgment is an outcome of an action in rem and has wider ramifications, comma, thereby precluding us from granting stay of the same, comma, nonetheless, comma, the respondent husband shall remain restrained by an order of injunction from uh, contracting any remarriage, comma, if not already contracted, comma, during pendency of the present application. Full stop, we mold the relief sought in the application to that extent. Full stop, a copy of the application bearing can 1 of 2026 shall be served by the appellant on the respondent at the earliest, and an affidavit of service to that effect shall be filed on the returnable date. Full stop. The matter shall next be listed on in the monthly list of September 2026. Affidavits, if any, shall be exchanged in the meantime. The appellant shall put in Tolobana and written up notice form for service of notice of the appeal on the respondent, comma, within a fortnight from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a fortnight. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. So we have, this stage is over. So when the application is taken up, we can just.
Grateful.
Yes, thanks.